It's not to not have the registration executed. So not, I need my lord's leave, my lord, to obtain the certified.
Get the certified copy.
Not of the orders, my lord.
You are not the party to the suit. You are not to file the wakalat nama.
No, my lord, with the leave of the court, I can get.
No, kindly come to the chapter 4.
Lord, I am so sorry.
Chapter 4.
I do not have. Do not have.
No rules, no rules. The original is not available.
Lord, in that case, may I come back on Monday, Lord, with the rules, Lord? I think
Come.
I'll come on.
Satisfy me. Because I have gone through, it is only the advocate who is having power and party to the suit.
Lord, I'll check, Lord, and come back. I'll definitely check and come back.
May I have my lord kind leave to mention a matter, my lord. Interim order is expiring tomorrow. Tomorrow being declared as a holiday, my lord. May it be, my lord. And it was listed also, my lord, to tomorrow. My lord, may it be extended.
Come.
I'm mentioning upon notice, my lord.
Come at the time of rising. Because other parties.
May I, my lord's kind leave to mention, my lord, there is a matter fixed at 3 p.m. That synergy matter, section 34 that I have been arguing, my lord. My lord, I will be praying for an adjournment today. I have informed Mr. Sinha, my lord, in advance.
Today.
It is fixed at 3 p.m. Therefore, my lord, I was mentioning so that other matters can be taken up, my lord. My junior will come and pray for it. I'm deeply obliged.
Lord, may inform the bar, my lord, that the matter may be postponed so that not other matters can be. I'm grateful to you, Lord.
May I, my lord, kindly to mention, my lord, Mr. Drolia is here.
Who?
My lord, Mr. Drolia, who was arguing. My lord, the suit was fixed on, my lord, 1st, 2nd, 7th, and 8th. Kindly fix, my lord. My lord. Hopefully, my lord is in circuit bench during this tenure.
1st, 2nd,
7th, and 8th.
7th, and 8th. Yes.
Kindly fix his, my lord, any day. Otherwise, my lord, tomorrow is holiday. We will not get any chance, my lord. Otherwise, this will languish in the list. We will not get a slot. My lord, any day, my lord, 4 days, my lord.
Lord, it is very difficult.
Any day, my lord.
Last 6, 7, 8 August. 6, 7, 8 August. Yes, Mr. Drolia?
Lord, I have no objection. I lordship.
Time to fix.
Lord, it's being fixed, Lord, on
6, 7.
6, 7th, and 8th
Lord,
of August.
6 can be skipped, Lord. 6 can be skipped.
No.
Is
August.
Then all right. Then
Not July.
Then all right.
The matter is mentioned by the learned counsel appearing for the plaintiff in presence of learned advocate appearing for the defendants. Counsel for the plaintiff submitted by an order dated 7th May 2025. This court has fixed the matter for argument on 1st July 2025, 2nd July 2025, and 8th July at 3 p.m. and 8th July 2025 at 11:30 a.m. For the counsel for the plaintiff submitted, this court will not be available during the sit period due to the circuit bench holding the circuit bench at Port Blair. Accordingly, he prays for fixing the matter to some other date. We have the submission made by the counsel for the parties. Let the matter appear on 6th, 7th, and 8th of August 2025 at 11:30 a.m.
As your lordship. Grateful.
May I have my lord sign leave? This is my lord, the written statement. It is out of time. Within 20 days, I'm standing on the 100th day. I have already filed an application also to file it in the department.
You to submit in the department subject to acceptance by
the department. So they said that I have to take leave of my lord.
In course of this day. Affidavit affirm?
Yes.
Today you will file. Okay. Give the leave and you file in the department.
My lord, may I be permitted to mention execution
Only to submit, submit in the department, subject to acceptance by in course.
May I permitted to mention on execution matter, my lord, on a last occasion at our request, we are for the decree holder, my lord. The matter was adjourned in view of the talks of settlement. The party have entered into the talks of settlement, my lord. It is agreed. We have agreed to the sum of rupees 80 lakhs being paid by way of check, my lord. But they want our assurance that after receiving that settlement amount, we will withdraw. We want to file our undertaking, my lord, to that effect, so that
may I suggest?
When the date is fixed?
Date is on 2nd June, Lordship. What I was humbly
22nd July.
Let there be a settlement, terms of settlement, Lordship, because
22nd July. What is the date of the check?
Check is of 20th, Lordship. That it has 3 months.
20th?
There is no problem in that. We are still we have given a Xerox copy, Lordship.
No, date is of 20 July. Date is fixed on when?
22nd July.
22nd July, the
22nd
matter
July.
is coming up.
But
my lord.
let it come on, what is the
we-
date?
Until and unless we file our undertaking, they are not going to give us the check, my lord.
Obviously, we have to file it. Lordship, the terms of
My lord,
settlement
the
has to be
matter
filed.
can become as
Some
to the
documents
mention,
before
my
the
lord.
honorable
When?
court.
Today is the last
That-
day.
If the matter can be
We have
taken
given
up
a
today,
copy of the
subject
check,
to
Lordship.
convenience of
We
the
can,
lordship, my
we
lord,
can,
at 3 p.m.
What you want?
We want to file our undertaking so that they can give us the
What
check.
undertaking you want to file?
We will withdraw the matter after receiving the amount of rupees 80 lakhs. We will.
after withdrawing, after receiving Miss Lordship.
Yeah,
Yes, after subject
unless
to
and
clearance of
until
the
he
check,
Clearance
my
of the check, Lordship.
after clearance of the check only he will withdraw.
will hand
Otherwise,
us the
then
check
again he has to file.
No, no,
it
no, no,
himself.
Lordship. Until unless it is in
एक काम
cash.
करो, 3 बजे supplementary लगा दो. To be mentioned.
Grateful, my lord. Grateful.
May I have your lordship's kind leave to mention.
Only difficulty, Your Lordship, the client who is having a check is not here. I have to confirm, Your Lordship, with
Come at 3 p.m.
Lordship.
In the supplementary, it is be at 3 p.m. Come at 3 p.m.
Lordship.
May I have your lordship's kind leave to mention one court application and one chamber application in the same suit, my lord. I'm mentioning for listing.
Who is for the other side?
My lord, I am for the plaintiff
Chamber
because these
application.
are new motions, my lord.
Not
appeared
notice
on
not
the return.
served.
Served, my lord, but did
Ah.
not appear on the returnable date, so I'm mentioning it, my lord, for listing.
ठीक हो 15 16 को रख दो 16 जुलाई 16 जुलाई.
Lordship, I am mentioning upon notice, CS com 408 of 2024. Lordship, they have placed for order date Rule 10. An argument has been concluded and your Lordship has been pleased to fix the matter as to be mentioned only for the issue of filing of written notes of arguments. Lordship, I am just apprised by the Privy Councils that my client has filed a SLP assailing your order whereby file to detail statement has been foreclosed. In that SLP, Lordship, Supreme Court has not state these proceedings before this honorable court, but has issued notice and it is returnable on 21st July. Kindly, I'm handing over. I'm leaving it.
No, my lords, what
I'm
is
leaving it
happening?
to your Lordship.
I will now tell your lordships what is happening. This SLP was filed long before even the hearing commenced. They
I'm just leaving
continue.
it to your Lordship.
They
I can't
continued with the hearing before your lordship. They continued with the hearing. There is no stay. They asked for a stay. Stay was not granted.
It's not there, Lordship. I'm leaving it.
Please, I don't like this. You make your submissions and then allow me to submit. This is not the way. So, my lord, after that, my lord, they continued with the hearing. Now your lordship took out the time, gave all the time. Matter has been heard. My lord, this was your lordship's last order, where your lordship gave, my lord, parties, my lord, liberty to file notes by 2nd of July. Now, my lords, what they want to do, the intention is to basically derail your lordship from proceeding with this further.
Your Lordship.
Okay,
just
do
been-
one thing. Okay, it is on 21st of July.
Yes.
Correct. And you have to file the written notes of argument.
The written notes.
File the written notes of argument. On that day, we'll see. Because
Yes.
on the very same day, this court will not pass the judgment. It will take for minimum 10 days or 1 week. I have to apply my mind.
Well,
Okay, no problem. You are informed that I will keep it in mind.
My lord, may I have your lordship leave to mention a matter? My lord, this CS number 2115 of 2024, 3 GAs are pending before your lordship, part heard by your lord, non-commercial but part heard.
Non-commercial partner.
Part heard. My lord, your lordship fixed the matter. Sure.
I'm sorry.
I'm led by
Well,
Mr. Ghosh. in
At
this matter.
my instance, your lordship had fixed it tomorrow at 1. It'll take 5 minutes, I said. But again,
Tomorrow again, holiday.
we are having a very difficult time explaining to the
Client.
clients, etc. Because it was for it's Section 8 has
Who is
been
for the
filed
other side?
2 years.
They are
Mr.
not,
Rohit Banerjee was there.
And
Given
Pooja Shah.
any day at 1 o'clock if it is kept.
Today?
No, today also, but I think they'll
They
be
are
in.
not
They will not. That's why I'm asking. If they will ready, then come at 3.
2nd August.
Yes. Oh, then we can come at 3.
No, if
We'll give
other
notice.
side is ready,
Well,
he informed, then I will order for the supplementary list so that it can be taken. If the other party is ready, if the other party is not ready, then it will go after 15th of July.
15th of July, because
After
they returned a notice saying
Okay, then it will
to
be
contact our client.
15 जुलाई के बाद कोई डेट है क्या?
Just to dispose of the Section 8 application which has been filed 2 years after the written statement.
After written statement, section 8.
Yes,
2 years.
it's 2 years after the written. And just when I took out an application for commission, Otherwise, the suit is ready.
What time? Hey. Give the order.
Last order. দুটো দিলে কেন? দুটো notice.
So inform the other side also.
Yes.
The matter is mentioned by the learned advocate appearing for the plaintiff. Counsel for the plaintiff submits that the matter is fixed on 27th of June 2025 at 1 p.m. But due to the decision taken that on 27 June 2025 as holiday, accordingly prays for fixing another
কি
day.
হবে, sir?
In view of the submission made by the counsel for the plaintiff, let the matter appear on 23rd July at 12:30
I'm grateful.
12:30 p.m. Counsel for the plaintiff is directed to inform the next date of hearing to the learned counsel for the defendant.
My lord, may I be permitted to mention, my lord?
Hmm.
My lord, item 84 of today's list, my lord,
Hmm.
it is appearing for case management. My lord, the defendants have never appeared.
84.
Yes, my lord. My lord, the issue that has arisen, my lord, is that it has been noticed
Hmm.
subsequently after filing the suit is that my lord, the suit has been filed in the wrong division, my lord. It would be filed before the intellectual property division, my lord. It has been filed before the commercial division, regular commercial division, my lord.
It is the IP matter.
Yes, my lord. Under the IPR rules, my lord, that have been filed, that have been
No,
formulated
it is
last
the
year.
commercial division.
Yes, my lord.
When it was filed.
My lord, this year, my lord, in January of
So I
2025.
am transferring it.
My lord, if that may be done, my lord, for that I am mentioning for to be listed, my lord.
ये वाला मैटर का फाइल निकाल के रखो. हाँ, 84. रखो. Who is for the other side?
My lord, no one has appeared for the defendants, sir.
Not taken steps.
No, my lord.
इसका ना कब करेगा? 3 बजे निकाल के रखो. इसको ऑर्डर करो. Come at 3.
Grateful, my lord.
Inform this court. Yes, next.
Adjournment item number 1.
Yes. What can be done?
I'm in your lordship's hand now.
I allowed your application, but cost approved is 50,000.
Kindly consider the cost. Lower it, my lord. I'm not saying do not impose cost. My lord,
2060.
since your lordship, I was carrying the original written statement.
No, I directed them to file the supply the written amended copy of the written statement of truth and document within a week. Then within 2 weeks, you file the written statement
Subject to payment.
to payment of cost.
Very
But I was more concerned about the interlocutory application, but my advocate on record just informs that unless the plaintiff is admitted, the interlocutory application will not come in the list. I tell you, Lordship, my lord, we seek leave under clause 12 of the latest patent and, my lord, 12A.
12A.
Yeah, and 12A.
Why 12A, sir?
I'll tell you, Lordship, my lord. But I have pleaded that, may I just explain what? Well, it is a contract which was issued by the defendant company. The defendant is a public sector undertaking. Now, this is for the effect of the contract is augmentation of Henry's Island for a fishery project. I have been doing it. The total time duration was 560 days. But I've been doing 90% of the work is complete. Now, at a stage, my lord, I asked for extension because this is in the Gangashagar area, Mela area. So it was out of bounds for about that 2-3 months when it happens. So there are other impediments we face. So I asked for extension of time. Extension of time given to us till the 31st of May. Now on the 19th of May, we receive a letter saying that we are going to impose liquidated damages if you can't complete it by the 31st of May. Very well. Now on 19th, you're saying 31st of May. How will I complete? Despite that, my lord, they call me for a meeting on the 4th of June. Well, just one document, if your lordship will see.
There is no arbitration.
No, my lord, there is none.
And the state 82.
My lord,
Section 82.
No, my lord, it's a public sector undertaking. It is exempted
This
under
is the
section 80.
Public, okay.
Then, my lord, on 4th of June, so if you say the contract is completed, has to be completed by 31st of May, otherwise I'll take courtship steps. 4th of June, I'm called to a meeting.
Correct.
My lord, kindly see the last letter. The last annexure, page 36. Regarding the aforesaid work, and see the previous letter at page 33. So on 4th of June, because they know there has been what they are doing now is they are trying to allot the balance work to third party agencies. Now, third party agencies are taking inspection of the work. That's my cause of action. And they are taking coercive steps so that I don't oppose it. Now they are taking steps to blacklist me, debar me, and those proceedings have also been initiated. So this is the urgency. If this happens, I am a contractor which have been doing public sector undertaking work across the country for more than 20 years. I have got more than 12 ongoing projects across the country. Just 2 letters. Even if I assume the allegations made in page 33 are correct, they say tender will remain valid till 31st of May. Last sentence at page 33.
Yes.
If this is the case, then how are you issuing me the letter on 4th of June?
What the 4th of June they told?
Well, kindly check.
So what has happened on 10th of June?
I went on the 15th. Now, on 10th of June, in the meeting, it was agreed that I ask for 3 months' time. I have to be practical to complete the work. They said that, no, we are not going to give you 3 months' time. I'm going to give you at best 1 month time. Well, this has been going on. So after that, after this, our case is that third parties are taking inspection. So then 4th June, you want me to complete the work when the tender, according to you, stood closed on the 31st of May.
Yes.
And my lord, this is arising out of
So
a tender, it's a commercial dispute.
There is no contract entered between the plaintiff and the defendant.
Yes, work order. My lord, the work order.
Only work order. There is
Yes,
there is no arbitration.
No, there is not.
There is no arbitration.
No arbitration. Well, we have been happy if there was any arbitration. But now, since the Perkins TRF principles allied, appointing authority having interest from the subject matter cannot appoint. Now there will be independent arbitrators, so they don't want arbitration. Well, the work order is the first annexure. After the plaint, well, the first annexure at page 25 is the work order. And my lord, now after the Dhanbad Fuels judgment of the Supreme Court, para 42 of Dhanbad Fuels, which has gone up from our court, my lord, it says that, my lord, I'll just read out that pleadings on record and oral submissions would be sufficient in ordinary course for 12A.
Correct. That
Separate application for 12A is not.
That is a settled now. Separate application, even the injunction application is not required only in the plaintiff, but subsequently you have to see what you.
Yes, my lord. My lord, we have from paragraph 42 onwards, we have made out the case of the urgency and why I need leave under order 12A. My lord, first at para 42 at page 14, we've indicated that, my lord, it comes within the purview of 21C.
Supreme for the plaintiff. The plaintiff has filed the present suit for specific performance of the work order dated 31st of July 2023 and the agreement dated 4th of December 2023 along with allied prayers. The plaintiff has prayed for leave under clause 12 of the latest patent as well as dispensation of section 12A of the Commercial Code Act 2015 for institution 2015. Counsel for the plaintiff submits that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Counsel for the plaintiff submit that The work order was issued on 1st of July 2023. Subsequently, on 19th of May 2025, the defendant had issued a notice intimating that the tender issued to the plaintiff will be valid only up till 31st of May 2025. But on 4th of June 2025, the defendant had again issued a notice for meeting on 10th of June 2025. On the plaintiff is submitted, the defendant is going to issue the work order to third party with regard to the balance work, and the third party is inspecting the premises in question, site in question, and as such, if at this stage the plaintiff will go for the pre-institution mediation, the suit filed by the plaintiff will be infractious. But the learned counsel for the plaintiff peruse the materials on record. This court finds that part cause of action arose within jurisdiction of this court and part cause of action arose outside jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. This is also found that the plaintiff has sufficiently pleaded with regard to the urgency in the matter and filed the suit without initiation of pre-mediation process. This court also find that this is a fit case wherein dispensation of leave under clause 12 or under section 12 of the latest patent of the Commercial Code of 2014-15 is granted. This could also find that if at this stage leave is not granted to the plaintiff to file the suit by dispensation of the section 12 of the 12A of the Commercial Code Act, the plaintiff will suffer irreparable loss and injury. In view of the above, leave under clause 12 of the latest patent 1865 as well as dispensation under clause 12 under section 12 capital A of the Commercial Code Act is granted. Full stop. Plaintiff is admitted subject to scrutiny. Subject to scrutiny by the department.
So 12 and 12A. 12. I have also prayed for leave under clause 12 or latest patent. One indulgence, my lord. I have overheard that your lordship is not available from Monday.
Next court.
I don't want to say anything. But this is only because the plaint was being presented. But the interlocutory application is effectively a verbatim reproduction of the plaint. But may I come back at 2 o'clock for 5 minutes? My lord, your lordship has already heard details, so this is all I'll say. I'll not say anything more than this. My lord, the interlocutory application scrutiny is ready, everything is ready. So unless they admit, my lord, otherwise, my lord, the entire object, purpose, 12A, everything will stand frustrated.
The plaintiff is given liberty to move the interlocutory application at 3 p.m. 3 p.m.
My lord?
3 p.m.
3 p.m. Grateful. Grateful. No, say department diye. Grateful. Deeply obliged.
This is my contempt application, extremely unfortunate situation. But if there is ever been a expression fraud on court, this should be the statutory example. Last day they had submitted a check or a draft was already deposited with the bank, and 1 crore would be transferred. Your lordship recollects, my lord, the submission. That money has not come. But on that basis, my lord, we had even conceded in the application taken out by the respondent number 8 that since we are receiving 5 crores, so very well. Now that money has not come in. So as on date, it's that 4 crores, and that check which was deposited is still not.
Both checks.
No, two. One was received prior to that day. On that day, it was submitted that a check has been deposited yesterday, and it should hit our accounts the day we were arguing the matter. That has never come.
No, he's here, my lord. Lordship desire that he should
look for a buyer to sell his property. Your lordship has been pleased to obtain report from the collector, my lord.
Okay, I am sending him the proper place,
Lord.
and I will appoint a receiver to advertise the property, sell the property, deposit the amount, then he will be released after
No,
realization.
he did mention, but
He is playing with the court, sir. I don't want lose my temper. At the very first matter, let he go to the proper. Which place is proper here? Alipur.
My lord. Sorry, my lord.
Alipur. Correctional home is Alipur.
I don't think it's any longer there in Alipur. It's been converted into a
That's
museum.
why I'm asking. Let he go.
My lord.
Now that is
My lord. My lord.
it has done
NCLT.
many
Companies gone to NCLT.
He has played
personal
many
all
games with
assets
the
are-
court also. He has played many games with the court. On that day, I have taken the leniency and given liberty
Your
to
lordship has-
search out the purchaser. So you are taking the benefit of that and making a submission here.
why did you not pay 1 crore rupees?
That day concession, next day in others application other- concession.
Okay, you go to the jail. No problem. You go to, which correctional home? Give the address.
He is sending you
Here
to
in
jail.
now. Where is the constable is outside? Let him be arrested here in now.
My pitiable story, my lord. Please, my age is some.
Okay, no problem. Your age.
My lord, rumors
Sufficient-
spoiled my life. Rumors, that people-
Sufficient facilities are there in the government house.
My lord, I get 50 lakhs. I 1 crore already paid.
Sufficient facilities available in the government house. You will get morning at 5 o'clock chana.
Nobody is there to me to get money for them. So I go and sit there. Nobody is there to get
And
money.
8:30 you will get the breakfast. 10:30 you will get the
I don't
lunch.
want any breakfast, that's my lord.
And
I want
4:30 you will get
your
the
mercy,
dinner.
your mercy, my lord. Your mercy. Please.
That's
please
why I
us-
have given so much
Sir,
mercy
no,
for the
my
last
lord,
1.5 years.
My life became miserable, my lord. You don't know, my lord. Please
Okay,
give
you
me
go.
one more
No,
chance.
lordship,
One
kindly.
more chance, my lord.
I have talked to him in the morning, my lord. He came to my office, my lord. My lord, your lordship has fully observed, my lord, that my lord, whatever he has said, he has not been able to fulfill. He says, my lord, because of these orders, my lord, he has not been able to get proper buyer also. Your lordship was kind enough to.
That
Yes,
submission that
yes,
And on that day, why you
Yes,
have stated that
my
yes,
lord,
we are
what-
paying the amount.
Yes,
Today
my lord. Whatever he had submitted, my lord, he
Correct.
did not get it from, my lord.
You
uh,
tell the,
he did not get that
you
money from the
informed
lenders,
court,
my lord.
you are transferring the amount today
My
itself.
lord, he did not get the money from his lenders, my lord. That is what he told me. My lord, your lordship, kindly appreciate, my lord. Your lordship has been kind enough to give him, my lord, he will try to. But your lordship, as a last chance, my lord, your lordship kindly test his bona fides, my lord. Your lordship, I was suggesting, my lord, subject to my lord's
Go
exception.
to the
My
go
lord,
to the government
your
house.
lordship will direct the
I am
receiver.
giving up to 2 p.m. time. If you arrange, you arrange. Otherwise, you arrange the half pant.
My lord, not possible, my lord. My lord, that people are going back after seeing all
Okay,
the
you
courts. My lord.
need not to go back. I will make necessary arrangement.
Can you pay 1
Your
crore
medical
rupees by 2 o'clock?
facilities, your food, and all these
50
things.
lakhs I pay on Monday. I pay 50 lakhs.
Even I will arrange the yoga also.
I don't want anything. I want to go to God, my lord.
I will
I
send
don't want
before
my
the
lord.
God. I will send a proper place to you.
No need, my lord.
You can learn how
I
you
want
can
your
play
mercy,
in
my
the
lord. Understand my pitiable position, my lord.
Okay.
See,
I am fixing at 2. Come at 2. If it's
But I will try to explain.
if he ready to pay, and he will remain in the court. He cannot go.
even
from
to
the-
travel
out of the
to Calcutta, I don't have money, my lord. I borrowed the ticket and I came here. I'm really, I'm telling you, honestly, I'm telling my lord, I want your mercy, I want your mercy and your blessing. Otherwise, I can't, because
I can't give bless. You take the bless from that side.
No, yes, my lord, they are good people. They paid money, and
They
I
are
agree.
good people. They
That
paid
is
the
why
money,
I
and
give-
you are playing with them also.
No, my lord, they have gone to NCLT, all the assets in the bank and all assets by your honorable judge, sir, is attached to all my assets.
Correct.
No, nothing is with me, sir. Only except this mantle shirt. I don't have with me in my pocket money also for 5,000 rupees only ticket I'm having, my lord. I asked the people. They told they are manhandling me. Why you are attached to my properties? Like that, they are coming and they are chasing me. They are trying for me. I'm abstanding. I'm not able to see that faces.
My lord, I have taken instructions. My lord,
Okay. I am appointing the receiver.
my lord, your lordship will
Sell
appoint.
your property.
to sell the property. This is what I was submitting. Let him sell the property which has been.
Pay the cost of the remuneration of the receiver by you only.
Yes, my lord. In fact,
Make
this
the
is the case, my
publication.
lord, where the receiver should take possession of the assets and not sell it, my lord. The receiver will sell the property we have secured before the court.
But the sales means won't get money, much good money, my dear.
He says, my lord, if the receiver sells it, perhaps
50
he will
lakhs I pay in Monday, my lord. After that, some numbers, only 3 properties is mine.
Okay, you come at 2 p.m. with some amount. I will leave you. And if you will not come at any amount at 2 p.m., then I will not leave you. I make it clear.
I don't have in
If
my.
you are going to make the payment on Monday, you make the payment today.
I got assets, but all are gone. Now what to do? Company NCLT. NCLT attached all these things. It is the NCLT.
Okay, the court will attach you now.
All attached, yeah.
So I am attaching you. Let you go to the government house. I am passing an order.
Say, yeah,
Lord, Your Lordship, kindly.
Please.
Lord, Your Lordship, I'll talk to you. I'll try to explain my lord's view, Lord. Lord, I was suggesting that the receiver, this is the fit case, Lord, where the receiver can be appointed, Lord. Lord, these are
They
property,
are ready for the receiver. Either you 2 p.m. you pay the amount, or I will pass an order.
Last chance, my lord. Give me last chance, my lord. I honor everything.
And it is your risk. If you left the court, then it is your risk. You being the court officer.
He will be staying here at the court. But I can't force him to, but Your Lordship can direct. You can't leave the courtroom. Huh?
Sit here.
Stay here.
Manage the amount at 2 p.m. and by 3 p.m.
No chance, yeah.
No chance.
No
Okay,
chance.
then I am passing.
Otherwise, I don't want to lie to because
he says by Monday, Lord, he will try to pay 50 lakhs. That is what he had told me in the morning.
Monday they give, yeah. Monday they give, yeah. Monday.
50 lakhs he can.
I will do nothing. I will send you to the proper place. That's all.
I'm requesting, my lord. Give me sufficient time. I want to clear. I don't want to.
How much time? For the last 1.5 years, it is going on.
My lord, my position. I'm in a big position, my lord. I lost everything. I don't have anything with me. Promise, I'm telling you.
Where is your partners?
Your partners.
What? No partners, my lord. No partners for me. See, I settled. You give me another 15 days time, my lord. I next month end you give time. I total money. I clear the thing and I see your. I take your blessings and I go. Next month end I clear everything, my lord. I pay. I'm requesting. I'm requesting your. I'm requesting your mercy, my lord.
In box, Lord.
Let him go to the box
and
make this.
You go to the box.
I appear for contempt number 5, 6, 7, and 8, Lordship.
Yes.
Her application has been
call
allowed.
your clients also, I think so.
Lordship, my client has nothing to do with it, Lordship.
What is your name?
My Jairam Chaudhary.
Record the evidence. What is your name?
Jairam Chaudhary.
Jairam Chaudhary. What is your age?
77 years.
77 years.
Yes.
What is your address? Permanent address? Now you are residing.
Now I'm in Chennai only.
Give permanent address. Give the
I'm,
paper. You
Tirupati.
write it.
You wrote it down.
Your address, police station, or permanent address and present address, both. Yes, what do you want to say? Why you are not paid the amount? Record the question. Why you are not
My lord.
Why you not
My lord, all
paid the amount?
whatever assets I'm having, all attached by the banks.
Whatever my assets, answer, huh? Whatever
with
the
banks.
assets, whatever my assets have been attached by the bank. Yes.
Company gone to NCLT. Whatever money they paid it great. Before that, we are having good dealings and everything. They are good people. They
That is over. Now what you want?
Now I pay entire money by next month end. with the interest and everything.
How much amount you will pay by next month? Total amount?
Total amount I pay. Next month, August
I
15th, you give.
undertake-
August 15th, you give.
I undertake that I will pay the total balance amount
By August 15th.
along with interest on or before 15th of August
August.
2025.
Yes. Yes.
Correct?
Yeah, yes.
Fine. If you will not pay, what will done?
You put me. I go to sit in the whatever
I will
wherever
not-
you ask, I go there.
If I will not pay this said amount by 15th of August, I will necessary order can be passed for punishment. Yes.
But only thing, my lord, your lordship would kindly consider recording that till date 4 crores has been paid.
Yes, come. Come. Okay. Step down. So suffering for the plaintiff. So suffering for the alleged contemner. Alleged contemner number
4. He is 4, my lord.
4.
He is
Alleged
4.
contemner number 4, namely, क्या है?
Jairam Chaudhary.
Jairam Chaudhary is present. Police stop. Counsel for the petition submit that on 20th June 2025, when the matter was taken up for hearing by this court, the alleged contender submits that they are transferring further amount of rupees 1 crore in course of the day, and accordingly this court has passed an order. But in spite of the undertaking, in spite of the submission made by the alleged contender, no amount has been transferred in the account of the plaintiff. Police stop. Then today when the matter is called, the alleged contender number 4, namely so and so, submits that due to some financial crisis, he is not in position to pay the amount, and accordingly he undertakes that he will clear the total balance amount. What is the total
8
balance?
crores with interest, my lord, balance 4 plus interest.
Balance.
4 crores principal
interest.
plus interest.
Balance amount of rupees 4 crore along with interest by 15th of August 2025. Police, so the alleged content number 4 was examined, and his statement is recorded, and on oath he has stated that he will clear the total principal amount along with the interest by 15th August 2025. As per the statement and undertaking made by the alleged contender, the case is adjourned. Let the matter appear on 18th of August 2025.
He'll be entitled to look for a buyer in terms
That's
of
already
losses
there.
or last order. You
That
will
is already
clarify.
there. Yes.
Yes, my lord. I'm deeply obliged, my lord.
Item number 4, my lord, I appear for the plaintiff petitioner. I'm being led
Item
by.
number 4.
Yes, my lord, I'm being
Yeah,
led
my
by.
lord, in item number 4, my lord, I'll just indicate the petitioner before your lordship, my lord, is the borrower of the defendant bank. Now, my lord, the suit is, my lord, one for specific performance. We had given an offer, my lord, for settlement. And according to us, my lord, that offer was accepted. And pursuant to such acceptance, my lord, the initial money that we were required to pay, my lord, we have also paid that.
Yes.
Now, my lord, we had, my lord, initially filed the suit asking for dispensation, my lord, under 12A. My lord, your lordship had passed an order saying that if this is the situation, then this is an ideal case for mediation.
Yes.
And your lordship had sent us to mediation. However, my lord, when we went for mediation, my lord, my learned friends, my lord, did not want to, my lord, enter into any mediation, my lord, and they refused to do so. As a result of which, my lord, we, my lord, received the necessary report from the mediation center and we refiled it.
Okay.
Now, my lord, while the, my lord, matter is pending, my lord, we have again spoken to the bank, and the bank has, my lord, asked us to renew our offer, my lord, with certain, my lord, other terms and conditions. We are in the process of doing that, and, my lord, instead of, my lord, fighting a long protracted battle with the bank, my lord, we would try to see, my lord, if it could be settled. My lord, at the same time, I don't want to waste today's hearing, my lord. So, my lord, I was only requesting, my lord, your lordship will give directions for affidavits, my lord. In the meantime, if it can be settled, then, my lord, well and good. I'm not, my lord, today pressing, my lord, troubling your lordship. But, my lord, if a short direction could be given for affidavits and if it could be kept under some time.
Suit is liable to be dismissed.
Why?
Section 34 of the Surface Act. Kindly come to the.
Okay, take the.
And my lord, only thing, pendency of this litigation will not cause any impediment on the ongoing litigation. Kindly record that. We have NCLT proceeding pending. We have Surface proceeding pending. Original application.
My lord, My lord, I don't know how. My lord, am I not entitled to file a suit? And have I asked you to pass an order of injunction restraining, my lord, those things
I
from
am not
proceeding?
passing interim order. So
Have I asked for that?
At this stage, I am not passing, only I am passing in direction for affidavit.
But I kindly record in NCLT, my learned senior friend's client has filed an application for stay of the NCLT proceeding.
So that's why they prayed for interim. So I am not entering into that. If then I have to decide the total.
Well, tendency of this litigation will not.
No, no, he can't ask for that order. He's in any event, he will oppose me in the NCLT that I don't have a stay.
Decision.
He will go to the NCLT and point out that I don't have a stay.
If they are taking before the authority, you pray before the authority. So and so suffering for the plaintiff, so and so suffering for the defendant. The plaintiff has filed the present application being GA Com 1 of 2025, praying for interim order. The counsel for the defendant prays for time to file appeal in opposition. Let appeal in opposition be filed within 2 weeks. Within 2 weeks, a reply, if any, to be filed within a week thereafter. List the matter on 17th, 2 weeks का बोले. So आज 26 है ना? 10. List the matter on 22nd.
Deep level.
July.
Your Lordship, I'm appearing on behalf of the plaintiff. On the last occasion, Your Lordship was pleased to give us leave to file the supplementary affidavit. The certified copies required to file the supplementary affidavit is not received yet. Your Lordship, kindly give us 2 weeks' time to file the supplementary affidavit. On the last occasion, Your Lordship was pleased to give us the leave to file the supplementary affidavit.
So and so suffering for the plaintiff. Counsel for the plaintiff prays for extension of time to file supplementary affidavit. That supplementary affidavit be filed within 2 weeks.
2 weeks, Your Lordship.
2 weeks. List the matter on 22nd.
Great.
22nd July. Next.
I appear for the Item 6, I appear for the plaintiff. Last day also, an adjournment was sought. I'm not saying anything.
Your Lordship, I'm led by my senior Ritovan Sirka. He's on his legs before another court. Kindly grant us a short passover, very short passover.
Passover.
Even my lord, I appear for the petitioner defendant. Now, this is my application for acceptance of my written statement. My lord,
who is for the plaintiff? When you receive the writ of summons?
Yes, my lord, 27 February 2025 by speed post and through bailiff on 7th March 2025. 120 days expires. If my lord takes 27 February, it expires 27 June. I have filed the written statement with leave of my lord on 9 June 2025. My lord, it's a bank, my lord. That's why it took some time, and the claims also are of a few years back. So it took some time to collate the documents, my lord. We prepared it at the earliest possible opportunity. And my lord, the intervening summer holidays also, our written statement was prepared effectively in May itself. But due to the summer holidays, my lord, we couldn't file it. My lord.
Yes.
My lord, para 9, if my lord will kindly consider.
My lord, I am praying for time. I will file my AON here. For opposition, I am praying some time.
Within 120 days. Your seniors.
My lord,
Yes. Come. Yes. Not objection.
Lord, I apologize. Lord, I'm instructed we will be needing to file an affidavit in opposition, my lord. My lord, if it's not for the record, my lord, I personally do not stand in the way, my lord, but I am a creature of my instructions.
Let the allegations not be admitted. I don't.
They are the plaintiff. Sensation suffering for the plaintiff, sensation suffering for the defendant. Defendant has filed an application being GA Com 3 of 2025, praying for extension of time to file written statement. Counsel for the plaintiff prays for time to file appeal in opposition. Let appeal in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Leave the matter on 24th July.
My lord, also may I file an affidavit?
My lord is aware, my lord, I do do not usually stand in the way of these things, my lord, but I'm a
Lord, may I file my affidavit of service in respect of the written statement, my lord? Written statement also I formally prepared an affidavit of service. We had served on them.
Keep with
Keep
with you.
for whatever
deeply
reason.
obliged, my lord.
Oblige.
Deeply obliged.
Thank you. Oblige.
Item number 8.
I'm opposing the section 34. I've nearly completed.
Yes.
Only my decisions were left. And if I may just tell my lord, the 5 points that my learned friends have urged. First is that this booking agreement was liable to be registered and it is not. My lord, several decisions were cited. 4 I had dealt with. And from my notes, I find one more decision was there, 1999 to CHN 369. I had asked Mr. Gupta for a list. He said, I don't have a list of cases that I've dealt with, my lord, 69 Supreme Court, 89 Supreme Court, 2014, 2008.
You dealt with the Delhi Metro 2024? Yes, you
Yes. And only this I found from my notes that one judgment 1999 to CHN 369.
1999
to CHN 369.
Dr. Sapna.
Well, I won't trouble my lord. It's again agreement for sale, possession was involved, and that the registration was required. So the arbitrators have clearly held that this is the agreement is in the nature of an investment. And my entire claim is based on the fact of the return to my investment. As far as the principal sum is concerned, which I have paid for my flat, I have not even asked for that back, and I can't hear. The 2 crores 56 lakhs, the 53 lakhs that are with them. That when I get my flat, when I get possession, it will happen. So that was the first point on registration. Second. So my answer to that is it was within the domain of the arbitrator. Section 34, such detail cannot be gone into. Second was even more factual. The agreement stood modified. And admittedly, there is no modified agreement.
Yes,
they are saying it's an oral agreement, and that also by not a person who is authorized by the. And out of this, so if that goes, again, that's a completely factual situation within the domain of the arbitrator. If that goes, then the third point that we owe them maintenance charges, well, admitted in the submissions also, learned counsel said, we have not taken possession. We have not taken possession. So the question of that their counterclaim, CAM charges, does not arise. And in any event, that arises only when the supplemental agreement for sale, which is envisaged in clause 11, is entered into. That will happen. So that's the third point gone. The last is 2 more points. One is the interest is barred by limitation. And it's a continuous cause of action. My submission is number 1. Number 2, I've said that the arbitrators have also gone into it. It's compound interest. My cause of action accrues every year. So even as on the day, and my lord, one more point which I don't think I made before, that there is no time limit within which this interest has to be paid. So it's continuous. My cause of action will arise when I made a demand, and my demand was in 2018.
Yes.
So the arbitration was not barred by limitation in any manner. So my right to receive the interest accrues when I demand it. I had not demanded it, it was continuing to go on. And as my principal is still with them, it is probably still accruing, which I haven't asked for in this arbitration. So those were the 4 main points. The last point was that the arbitrator has not considered certain documents. My lord, a chart was given.
Yes,
I took my lord through the chart. All these documents are, first of all, they are all referred to in the pleadings and even in my notes of arguments. But the arbitrators felt that it doesn't have to be specifically referred to. My lord sees serial number 4, for example, in their chart, supplementary agreement with other purchasers. Completely not necessary, because they are admitting in their pleading also that I did not enter
into that.
the clauses from the statement of defense I gave. So, I'll complete by only citing one or two decisions. The first one, 2019 for SCC, page 163. It's the same reiteration of all the principles. I've just chosen one judgment, my lord. Here, if my lord comes to paragraph 11 straight away, or my lord, paragraph 10. But before I place it, if I may just point out this, mainly the discussions in these latest judgments are that previously, if it is contrary to the contract, contrary to law, then it would come under the header of public policy. But now it will come under patent illegality. Because so that distinction at that time in 2019, it was very new. So they discuss a lot on that. But paragraph 10. Before proceeding further, we find it necessary to briefly revisit the existing position of law with respect to the scope of interference with an arbitral award in India, though we do not wish to burden this judgment by discussing principles regarding the same in detail. Such inference may be undertaken in terms of Section 34 or in appeal Section 37. While the former deals with the challenges to an arbitral award itself, the latter deals with the appeals against the order under Section 34, setting aside the order. We are concerned only in the first part, 11. As far as Section 34 is concerned, the position is well settled by the court that the court does not sit in appeal over the arbitral tribunal's award and may interfere on merits on limited ground provided under Section 34(2)(b)(2). That is, if the award is against the public policy of India. As per the legal position clarified through decisions of this court prior to the amendment, a violation of public policy in turn includes a violation of the fundamental policy of Indian law, a violation of the interest in India, conflict with morality, etc. This is the old position is being discussed. Then additionally, the concept of fundamental policy of India would cover compliance with statutes, judicial precedents, adopting a judicial approach, compliance with the principles of natural justice and Wensbury reasonableness. Furthermore, patent illegality itself has been held to mean a contravention of the substantive law of India, contravention of the 96 Act, and contravention of the terms of the contract. That was the judicial findings then. It is only if one of these conditions is met that the court may interfere with the arbitral award, but such interference does not entail a review of the merits of the dispute and is limited to situations where the findings of the arbitrator are arbitrary, capricious, or perverse, or when the conscience of the court is shocked, or when the illegality is not trivial but goes to the root of the matter. An arbitral award may not be interfered if the view taken by the arbitrator is a possible view of the facts. Again, the principles of these earlier cases. Then 13. It is relevant to note that after the 2015 amendment to Section 34, the position stands somewhat modified. Pursuant to the insertion of Explanation 1 to Section 34(2), the scope of contravention of public policy has been modified to the extent that it now means fraud and corruption in making the award, violation of Sections 75 and 81, contravention of fundamental policy of India, and conflict with the basic notions of justice. Malo, if I may pause, they are not taking these points against this particular award. Additionally, Section 2(a) has been inserted in 34, which provides that in case of domestic arbitrations, violation of Indian policy, public policy, also includes patent illegality appearing on the face of the award. The proviso to the same states that an award shall not be set aside merely on the ground of erroneous application of law or reappreciation of evidence. So again, I'm pausing. Limitation and registration were particular points referred to the arbitrator. Both sides have argued. So even if they have applied it erroneously, which I say they have not, but even then as far as, so this part is 14 to 16 is they sum it up. As far as interference with the order under 34, as per section 37 is concerned, it cannot be disputed. Well, section 37, we are not in. They said it's a little bit diluted, but actually in 37 also, whatever there is in 34 can be looked into. Now, my lord will come to paragraph 15 and 16. Having noted the above grounds for interference with the award, arbitral award, it must be noted that the instant question pertains to the determining of whether the arbitral award deals with the dispute not contemplated by or not falling within the terms of the submission to arbitration, or contains decisions on matters beyond the scope of the submission. However, the question has been addressed by the courts in terms of the construction of the contract between the parties, and as such, it can be safely said that a review of such construction cannot be made in terms of reassessment of the materials on record, but only in terms of principles governing the interference with an award as discussed above. So, what are the construction, interpretation of the contract? If the arbitrator's view has to be held, it is equally important to observe at this juncture that while interpreting the terms of the contract, the conduct of the parties' correspondence exchange would also be relevant factors, and it is within the arbitrator's jurisdiction to consider the same. And then McDermott is quoted. So that is all as far as the principles are concerned. Just for completeness, this has been followed in 2024. 6 Supreme Court cases, 809. National Highways Authority versus Hindustan Construction. Well, it's exact, the repetition is there. Paragraph 11 quotes these paragraphs. It quotes paragraph 11 of the earlier act. Well, I don't think it's really necessary. The conclusions are at the last 3 paragraphs of that judgment. Interpretation is within the domain of the arbitrator. So, no, I think it's followed in those.
Yes.
Let's see. Sangyong is followed. Well, the anchor usually is that Sangyon judgment, but my learned friend also hasn't cited that. But even those principles are the same. The principles are same. Your Lordship knows that. No, these 2 decisions, I think, are enough to cover that, because I've dealt with it on the arguments of my learned friend, point by point. I think I've covered most of them. The last, yes, even the perversity point I've covered. Those documents were actually taken into consideration, and irrelevant documents need not be quoted.
Correct.
Those are my submissions.
Thank you.
The reply is to be given by my learned friend. I have only cited these 2 new cases, so it have to be limited to law, because the ingenuity of Mr. Sen has been remarked 3 times in the award. So I'm a bit scared on
Mr. Sen, my lord, he's on his legs. I spoke to him. He has requested, my lord, if the next date can be fixed sometime in August on Fridays.
August on a Friday.
On 4th August, my lord, the first Friday of August.
2nd August is a Friday. It's a Saturday.
Saturday.
It's a working.
No, 4th August, I'm saying.
That's a Monday.
Second is the
Oh, sorry.
second is the free day. Then you can.
Oh, sorry, 1st August. 1st August.
My diary permits.
But if required, we will give the note. If my learned friend is giving them.
Yes, my lord, we'll give a note, my lord.
1st August.
1st August. So appearing for the petitioner, so appearing for the respondent. Counsel for the respondent has concluded his argument. Counsel for the petition prays for time. According case is adjourned. Let the matter appear on 1st August at 11:30.
Well, only the decisions. If we have an opportunity to put that on record, because Mr. Sen is not here. Won't be able to stop him. Then. Anyway.
Grateful, my lord.
Yes, next.
My lord,
Today. Well, just COVID thing, I have recovered. I don't
another
want
reason
him to
why,
be
my lord,
contaminated. My lord,
my lord, I was only praying for, my lord, one indulgence, my lord. I had moved an application claiming rejection of plaint on the ground that leave under clause 12 was not taken in this matter. But we are filing an appeal against this order
the
today.
appeal is not maintainable because it's a commercial suit under order 43. It is a special petition which they have to prefer before the Supreme Court.
So, my lord, if my lord can give us one opportunity, my lord, to
Let
try.
me put, my lord, my order 12 rule 6, my lord, because your lordship will kindly see section 13 of the Commercial Courts Act. It says only orders which are appellable under order 43, and this is your lordship's order on rejecting their application.
That's an argument which my learned friend can make in the appeal court.
My lord, let me proceed with it. It has been fixed, my lord.
Second reason why I should
With
not,
their
my lord,
consent.
he has just recovered from COVID, my lord. I should not have.
That's I'm staying away. I'm putting a mask. I'm putting a mask.
Only one opportunity, my lord.
No,
That's my only prayer, my lord. I leave it to my lord. We are filing it today.
And this was peremptory. They have not. They have not filed their affidavit in opposition either. It was a peremptory order.
I'll be very candid, my lord. There's no such defense in the matter except this technical ground, my lord.
Well,
One, I'm very candid.
That's why he is going here and there.
Only one
Let him
opportunity.
secure. My lord, in that case, let him secure. I have an application which is GA3. Let him secure in terms of Rahul Shah. Let him secure the money.
My lord, give me one opportunity when my lord comes back, my lord. Within that much time, if my lord I'm able to get an order, it's fine. Otherwise, my lord will proceed.
My learned friend also knows it's not available. And Supreme Court opens on 14th of July.
I leave it to my lord.
When your appeal is
Today it's being filed, my lord.
today filed.
And it will come up, my lord, in 3-4 days. So, my lord, whatever happens, it will happen before my lord comes back, my lord.
Then you
No, it is not appellable. But at least let him secure. My GA3 is there. My lord will kindly see the praise in GA3.
That's allowing his application status.
GA2 is my application for. My lord will kindly see your lordship's last order, which is of 7th of May 2025. Your lordship had rejected their application under Order 7, Rule 11 by an order dated 29th of April.
Yes.
My lord will kindly see paragraph 5. Counsel for the defendant submits that he has no objection if the date is fixed for hearing. But in the meantime, the defendant may be given chance to file affidavit in opposition. The plaintiff has raised objection and draw the attention of this court to the order of 20th February 2025, wherein the court has made it clear that the next date fixed, if the parties fail to complete the pleading, the application will be taken up.
Have you filed the affidavit? No.
No, nothing.
My lord, I was only saying, my lord, if I succeed in my application, my lord, then the entire plaint goes, my lord. That's the only thing, my lord. Give me one opportunity, my lord.
I'm afraid it is not appellable.
No, that's for my lord to any day, my lord.
Let him at least secure the money. My lord kindly takes my GA3.
I am fixing on 20 and 29th of July. If it is
his offers is empty, he would my lord, his entire money he will take out. He admits to the fact he has taken loan, he has given PDC, those has been dishonored.
now, all you have to argue the matter, but he has preferred an appeal. Let the appeal decide. I am fixing on 29th.
It's not even filed.
29th, my lord will no. It's
not even been filed.
It's being filed, my lord. It's being filed. It's ready, my lord. It's being filed. I'm very candid, my lord. It's being filed.
Let him secure, my lord, at least by GA3.
29th.
Suffering for the plaintiff, suffering for the defendant. Counsel for the defendant submitted, being agreed with the order passed by this court dated 29th of April 2025. The appellant is intending to prepare an appeal. Accordingly, prays for adjournment. Counsel for the plaintiff prays for a direction directing the defendant to secure the amount. Consider the submission made by the counsel for the parties. Let the matter appear on कोई डेट है कितना बजे 1st August 12:30. Come on that
August. Lord, let him secure. My lord, in the meantime, he will. Huh? Your Lordship is.
That is the otherwise. Come on,
At least let him secure the money, my lord. At least some cost. At least some cost, my lord.
Come on that. Yes, next.
My lord, would it be your Lordship's pleasure to fix a time, my lord?
Yes, 12:30.
12:30.
That's why 1st August I pay. Otherwise, I could have said third week of the July. But
1st of August, my lord.
1st of August. Check your diary.
1st of August. I
busy
have a matter
person.
fixed in.
Supreme Court.
No, my lord, it's. No, it's fine. It's on 4th.
August 12:30.
It's on
Please,
4th.
please make. On that day I will.
Otherwise, I'll proceed, my lord. Yes, ma'am.
May it please my lord, in this matter, I am appearing for the defendant. On the last occasion, my learned friend appearing for the plaintiff had completed arguments on his order 13A. My lord had heard me summarily. I shall conclude. May I first draw my lord's kind attention to the application itself.
GF4.
GF4, my lord.
Yes.
Now, my lord, the application was not placed by my learned friend. The application, my lord, I have gone through, and I most respectfully submit, proceeds on one ground alone, that there is an agreement of 21st July 2005, and that since the defendant has admitted the agreement, nothing further remains, and summary judgment is to be passed. The other allegation in the application is that I have avoided service of summons for 6 long years. The suit was first filed in the as a regular suit in the regular division of this honorable court in 2018. I have allegedly avoided service of summons. Finally, substituted service was effected, and I entered appearance and filed my written statement pursuant to that. Now, my lord, 2 other cases have been made out by my learned friend at the time of his oral arguments, which do not form part of his application. The first is that I had admittedly filed a prior suit before the learned court, competent court at Shialda. Now, my learned friend contends that he was aggrieved by the rejection by the learned Shialda court of an Order 7 Rule 11 application. He took out an application under Article 227. Now, my learned friend's contention is that the Honorable Divisional Court has set aside my plaint case or set the contentions in my plaint case at naught. This, I most respectfully submit, is not what either appears from the order passed by the Honorable Revisional Court or what has been pleaded. And, my lord, the 4th case that my learned friend made out, which does not appear from his application, is that I should be put on terms in terms of Rule 7 of Order 13A. Now, my lord, there is not a whisper of this, and I shall also try to satisfy my lord that no case has been made out for the imposition of any conditions. And, my lord, apropos this submission, that the plaint case before the learned Shialda court, which is really my dispute in response to the claim, I have made 2 false statements. My learned friend points out that a false statement has been made in page 35 of my written statement, and a reiteration thereof at page 11 of my affidavit in opposition. Now, my lord, having pointed out, also on the statement of truth. Thank you. Now, my lord, endeavoring to deal with the first of the plaintiff's cases, that is the agreement of 21st July 2005 having been admitted, nothing else remains. May I first show before my lord paragraphs 12 to 14 of my learned friend's application that my lord finds at page 8 of the application. May I just summarily place, my lord? It is a matter of record, and more particularly, which would appear from the defendant's letter dated 14th December 2015, that the said agreement dated 21st July 2005 is not disputed and, in fact, admitted by the defendant/respondent. In paragraph 13, the plaintiff petitioner states that the defendant has no defense to the claim of the plaintiff. The defendant respondent, despite having admitted the existence of the agreement and the contract executed by the defendant respondent, for which the price of goods was duly received by the defendant respondent, the defendant respondent has failed to make payment of the commission as per the said contract. Now, my lord, paragraph 14. Inasmuch as the acceptance and admittance of the said agreement by the defendant respondent, there exists no compelling reason why the claim of the claimant should not be disposed of before recording oral evidence. Moreover, there are no triable issues insofar as the aforesaid claims are concerned. Now, my lord, bringing my lord's kind attention back to paragraph 12, the plaintiff states that it would appear from my letter of 14th December 2015 that I have admitted the agreement and therefore nothing remains. Now, my lord kindly takes my letter of 14th December. Yes, my lord, I stand for an apology. My page numbers perhaps may not match. Thank you. My lord takes page 47. Of my learned friend's application. My lord kindly sees this is the letter referred to 14th December 2015. And it is this letter on which the plaintiff places reliance and says, I have admitted the agreement. Now, my lord, this is in response to the plaintiff's demand on 13th November 2015 . May I first place the 13th November letter? My lord kindly takes. Mr. Shastri, can you help me with the page number? My brief is not paginated. 45.
Page 45.
Page 45. I am obliged. Now, my lord, this is the plaintiff's letter, which he claims to be a letter of demand. Now, my lord, I do not trouble my lord with the first one or two paragraphs. My lord kindly takes the last paragraph on that page. Since July 2005, our client acted as commercial agent for NM Exports. That is me, my lord. Based on this agreement, our client is entitled to receive any information which is necessary to calculate his commission. This means that NM Exports is obliged to disclose all the orders carried out by NM Exports and paid by the costumers placed by our client. For the submission of this information, we set ourselves a deadline. I'm sorry, my lord, to page 24. We set ourselves a deadline until 30th November 2015. Now, my lord, most respectfully, the plaintiff terms this as a demand for payment. In my most respectful submission, my lord, there is no demand for any payment. He himself, my lord, seeks to ascertain whether, if any, commission is outstanding and payable on the orders that have been successfully procured by him.
This was issued by the plaintiff.
This was issued by the plaintiff, my lord. Kindly makes a note of the date, 13th November 2015.
Extended.
Yes.
Submission for information, we set ourselves for deadline as 30 November 2015.
Yes. Now, my lord, there is admittedly no demand for any sum in this letter. Rather, the plaintiff is himself not aware whether any commission is payable and outstanding, and he seeks mere information as to whether anything is outstanding.
Yes.
Now, my lord, it is in response to this letter that my advocates issue a response, which is at page 47.
Yes.
That, my lord, is my letter of December 14, 2015. My lord's kind attention be drawn to the third paragraph on that page. My lord's sentence beginning with under the said contract.
Yes.
Under the said contract, your client was obliged to comply with the obligations contained in point numbers 3 and 5. My lord, I shall place the agreement later. It is our client's contention that save and accept the contracts with Ernst's family and Manor AG and introducing our client to Charles Vogel, your client did not act in terms of the said contract. Your client was duly paid the commission for the contracts with Ernst's family and Manor AG as agreed. Apart from the aforesaid, your client did not comply with his obligation in terms of the said contract. Your client was called upon to produce evidence in support of point numbers 3 and 5, which your client has avoided and naturally failed to discharge as yet. Next, my lord's attention I draw to the last paragraph on that page, which is a contract with another fashion house. My lord, I draw my lord's kind attention to the third sentence. Our client communicated, my lord, that is the second sentence I stand. Our client communicated to your client that it would only be possible for him to pay a commission of 1.25% on the Charles Vogel business on the collection prepared by our client. And therefore, my lord, I lay emphasis, our client have paid to your client commission at the rate of 1.25%, which was agreed to by and between the parties and received by your client without any protest or objection till July 2015. Thereafter, my lord, may I draw my lord's kind attention to the last few lines beginning with, it is pertinent to mention here that your client never acted. My lord has found it.
It is pertinent.
Last fourth line from the bottom, my lord. Beginning, it is pertinent to mention here that your client has never acted in the true spirit of the contract. He never visited Charles Vogel to discuss our client's collection, nor did he ever present the said collection or discuss the business possibilities. It is also a fact on record that despite his non-performance, he had continued to receive a commission at the rate of 1.25% on account of Charles Vogel without any protest or objection till July 2015. Now, my lord, apropos 1.25%, the plaintiff admits payment. And in my written statement, I have disclosed all the invoices raised at 1.25 and the supporting SWIFT or bank account statements showing that those commissions were paid. My lord kindly turns over to the next page. Since your client did not comply with his obligation as contained in the said contract for a long time, there was a dinner meeting between your client and our client in February 2015 at Cologne, where it was agreed that our client would discontinue to pay to your client the said commission for Vogel contracts at the rate of 1.25% from next year, 2016, and your client agreed to and did accept the same. It appears that after our client had made payment of the said commission in respect of invoice number 84, dated 3rd July 2015, your client has now sought to retract from the solemn agreement entered into by and between the parties and sought to instruct you to address the letter dated 13 November. Now, my lord, the last paragraph. In view of the aforesaid, our client denies and disputes each and every allegation contained in your letter dated 13 November and your mail dated 9 December, as if they are set out herein and denied seriatim. Please note that no claim of your client would be entertained by our client from now, as the agreement or understanding by and between the parties having been terminated and or determined in the manner as aforesaid. My lord kindly turns over to the page to the response of the plaintiff dated 23rd December 2015. This is, my lord, page 49. I'm very thankful.
Yes.
This is, my lord, a reply on behalf of the plaintiff. Reference is made to your email of 14th December, which we would briefly like to comment as follows. As a matter of fact, a valid agency agreement exists since 1st July until today. The agreement automatically renewed every year until today due to the fact that it has not been terminated yet. Therefore, our client still has the right to claim commission, which is based on any and all sales NM exports made with the companies that have been placed by our client. In addition to this, our client is entitled to claim information with respect to these sales aforementioned. This also comprises the disclosure of a statement of account. The objections from your side are not convincing at all. Now, my lord, apropos these three emails, my most respectful submission would be that not only is there never a demand of a quantified sum, therefore, the sum claimed in the application for summary judgment today is unfounded on the basis of any of the documents disclosed in the plaint case. Secondly, my lord, I admittedly issued a letter saying that your contract is terminated. I alleged breach and non-performance. I also alleged, and this is an admitted position, that commission at 1.25% has been paid and accepted. Now, my lord, the plaintiff disputes such termination and says, no, I am entitled to commission and I'm also entitled to information on how much is payable to me. These correspondences taken together, my lord, only lay credence to the fact that there was in fact a dispute between the parties. Now, my lord, in making this submission, I do not wish to state or propose an argument that summary judgment has to proceed on admission. It is not an application for judgment on admission. What I am rather on, my lord, is that the fact that in Order 13A, the plaintiff has to demonstrate two vital things: that there is no contest to material facts, and the plaintiff in the usual course will be entitled to judgment as a matter of right. Most respectfully, my lord, these documents serve to show that not only was there serious contest to the facts, and these facts form part of my written statement, but that the plaintiff cannot possibly be entitled to any judgment as a matter of right because he has never quantified his claim contemporaneously in the first place.
Yes.
Now, my lord kindly recalls I had taken exception on the last occasion to my learned friend's submission that the order of the Civil Revisional Court virtually sets at naught my plaint case. My lord, may I straightaway bring my lord to the order passed in the application under Article 227. My learned friend will help me with the correct page number, please.
72.
I'm obliged. My lord, may I please? My lord kindly sees the suit appears to be tenuous and more for professional benefit than earning any relief to the plaintiff herein. My lord, I lay emphasis, however, on the second paragraph. There is a dispute between the petitioner herein and the opposite party as to whether the petitioner is entitled to any commission on account of the sale of goods of the opposite party's manufacture in Europe. My lord, most respectfully, this observation of the Honorable Revisional Court reinforces the fact that there were in fact disputes, and however poorly the reliefs in my plaint before the learned Shalda Court may have been framed, my plaint case sets out this dispute. Now, my lord, may I bring my lord's kind attention to the second page of the order. My lord kindly sees the paragraph beginning, since the trial court. Since the trial court has found a modicum of cause of action evident from the plaint, the order impugned is not interfered with. It is, however, clarified that the pendency of the suit will not stand in the way of the petitioner herein instituting his independent claim before an appropriate forum. Most respectfully, my lord, the plaintiff was aggrieved by his rejection of the Order 7, Rule 11. The Honorable Revisional Court did not interfere with that order. Apropos this final finding of the Revisional Court, how, if I may ask this question to myself, have I made a false statement in claiming that the order of rejection of Order 7, Rule 11 was accepted by the plaintiff? He did not choose to be aggrieved with this finding, that since the trial court has found a modicum of cause of action, the Revisional Court did not interfere. Therefore, my lord, most respectfully, no false statement has been made. The fact remains that the only thing that may have been granted to the plaintiff is for him to institute a claim, if he has any, if he feels he has any. And in any event, that is the law of the land, my lord. No court will restrain him from filing a claim if he believes something is due and payable to him. But the order passed by the learned trial court rejecting my learned friend's Order 7, Rule 11 was not interfered with. In light of this, my lord, I respectfully submit there has been no false statement made. My learned friend has indeed accepted the outcome of the Order 7, Rule 11.
The first page of the order.
Yes, my lord.
Third paragraph. On
Yes.
reading the plaint, it does not appear that the first and third reliefs
Can never
must
be granted.
granted.
Yes.
So, with regard to these two prayer, the court has seized it.
Absolutely, my lord. Absolutely. I do not join issue on this, and I have seen the plaint, my lord.
If that's so,
yes.
Kindly come to your plaint.
Yes. The first prayer being a declaration for a money claim.
First and the third.
And the third.
First and third will go.
Yes.
So what remains in that?
Lordship prayer B.
Alternative entitlement of defendant as the commission.
Lordship, I will not, in all candidness, I do not stand to say one word in favor of the plaint case. I'm only fortunate that I was not the learned draftsman. But, my lord, the plaint sets out certain disputed contentions of fact that will have to be adjudicated upon, assuming but not admitting that I do not win there. That will not automatically absolve or dilute whatever I have made out in my written statement today. Adverting back to the rigorous principles applied in Order 13A, my lord, it cannot most respectfully be said that the plaintiff is entitled to judgment. And for that, my lord, again, if I may emphasize, the second paragraph of the Civil Divisional Court's order, even the Civil Divisional Court records that there is a dispute as to entitlement, whether the plaintiff is at all entitled to anything. My lord, I am not troubling my lord with my written statement because the documents are identical and my case is also identical. However, my lord, one other thing, there has been an allegation that I have avoided service and that there has been 6 years of delay. Now, my lord kindly takes up my affidavit in opposition.
Yes.
My lord straight away comes to page 12. It is subparagraph E. Subparagraph E with the main paragraph. This is a continuation, my lord, of paragraph 4.
Yes.
May I place, my lord? The suit was originally filed in the year 2018 and writ of summons was allegedly lodged on November 26, 2018 for service upon the defendant. However, between the years 2019 to 2022, admittedly no steps had been taken by the plaintiff to either transfer the suit to the commercial division of this honorable court or to expedite the carriage of proceedings, or even to seek summary judgment against the defendant under the regular provisions of the code. It was only on August 17, 2022, when the plaintiff commenced taking steps for conversion of the suit into a commercial suit and consequent transfer thereof. Thereafter, after passage of nearly another year, on August 30, 2023, the plaintiff sought leave to allow his alleged constituted attorney, who is the deponent of the said purported affidavit, to reaffirm and re-verify the plaint and to take further steps for conversion of the suit into a commercial suit. My lord kindly comes to page 13. Even thereafter, successive adjournments were taken by the plaintiff for his repeated failure to comply with the order dated August 30, 2023, compelling this honorable court to pass an order dated January 16, 2024, directing the plaintiff to complete all formalities by January 25, 2024, failing which appropriate orders would be passed by this honorable court. It was only on January 25 that the plaintiff was able to successfully report compliance with the provisions of the Commercial Courts Act and to file a report as to writ of summons, which could not be served on the defendant through the usual mode. Now, my lord skips over a few lines and thereafter a sentence beginning with, it appears from a further order dated April 4, 2024, that the plaintiff was granted liberty to effect substituted service under Order 5, Rule 20, and it was finally on 24th July 2024 that the plaintiff made necessary paper publications. Now, my lord, I have annexed the entire series of orders to my opposition. My lord finds that from page 70 onwards. My lord kindly sees the first order, 17th August 2022.
Page?
This is, my lord, page 70, annexure B of my opposition.
Yes.
My lord sees 17th August.
Yes.
Counsel for the plaintiff submits that the suit is of a commercial matter, division matter, but inadvertently the same has been filed. My lord directs appropriate steps for reaffirmation and re-verification. My lord turns over the page.
Yes.
Hiatus of 1 year, my lord sees the order date August 30, 2023.
Yes.
My lord kindly takes the third paragraph. Counsel for the plaintiff prays leave to take appropriate steps in accordance with the order through power of attorney holder. My lord comes to thereafter page 73. My lord notes the date of the order, October 10, 2023. And my lord sees thereafter successively prayers for adjournment on behalf of the plaintiff. My lord, the adjournments continue until page 76, which is my lord's order. It is made clear that if by the date fixed, the plaintiff fails to comply with the order dated 30th August, appropriate orders will be passed. Thereafter, my lord, page 77. My lord kindly notes the date of the order, January 25, 2024. My lord, the last paragraph. Now, my lord, therefore, yes. Oh.
Yes.
Yes. My lord kindly also sees page 79. March 12. Again, a prayer for adjournment for 3 weeks. Thereafter, my lord, page 80, application for substituted service. Therefore, my lord, the allegation that I have sat on the fence for 6 years cannot be laid at my door. Now, my lord kindly gives me a moment. Yes. Coming back to my lord, my defense in the written statement, I have not only disclosed all the invoices, my lord, I have disclosed my written statement commencing, that's the first annexure. Page 22.
Yes.
My lord, not only does it contain the reiteration of the correspondence, the termination, the payment of commission at 1.25%, my lord also sees that along with my written statement, at pages 43 to 69, my lord, thereof, I have disclosed the invoices that were raised and the payments that were made. My lord, for demonstration only, because all the invoices run at identical rates, I shall bring my lord's kind attention to page 43.
43 to 69?
Yes, my lord. 43 to 69, I think. Yes, to 69, my lord. Invoices and corresponding payments have been disclosed.
Yes.
My lord, only for the sake of record, I place page 43. My learned friend has admitted. A rate on invoice is all claimed at 1.25%. There is not an invoice on record today or any other document which shows a claiming at 3% or any other rate than 1.25. My lord, I believe I have dealt with everything. My lord, may I just place one judgment very briefly? This is, my lord, rendered in the context of largely similar facts where the defendant had admitted the transaction between the parties and had admitted that some payments were definitely made, and the defendant had said that those payments were the only payments due and payable and nothing remains. This is 2020 SCC Online, Delhi, 2862.
Yes.
My lord, may I just briefly place the facts? This is an application filed on behalf of the plaintiff under Order 13A, directing the defendant to pay such and such. Now, my lord, paragraph 2, the plaintiff in its application under Order 13A has asserted that there are no disputes about the admitted facts and the liability of the defendant to pay such and such with interest is proved and established from various invoices and documents relied. The defendants, my lord, paragraph 3, have controverted the assertions made in the application and asserted that the claim is not maintainable. Now, my lord, the 4 is the plaint case, largely similar circumstances. Some commercial transactions had been entered into, supply of Burma teak woods, etc. Now, my lord, comes to paragraph 6. It is claimed that the defendants acknowledged the payments to the extent of 5.97 crores as due and payable to the plaintiff and proposed to make payment in 2 tranches. Since the defendants failed to make the payments, legal notice was issued, etc. Now, my lord, comes to paragraph 9, which is the written statement of the defendants. The defendants, may I place, my lord?
Yes.
The defendants in their written statement have admitted that sometime in 2016, the plaintiff was engaged to do the woodwork during the renovation of such and such. The work done by the plaintiff was claimed to be subpar, and there were material delays in execution of the work. The defendants paid rupees such and such towards full and final settlement of the entire work done by the plaintiff by June 2018. Now, my lord, this is largely similar. I have accepted and admitted the agreement. I have alleged that there was no performance to my satisfaction, termination, full payment of whatever was payable. Now, my lord, kindly takes paragraph 14 onwards. The defendants have thus denied the entire claim of the plaintiff and have asserted that the number of purported invoices is in duplicate. Only 17 invoices had been raised against which payments have already been made. There are inherent contradictions in the documents relied upon the plaintiff, and therefore the suit is liable to be dismissed. Now, my lord, paragraph 15. My lord, straight away comes to the sentence beginning. It empowers the court to give summary judgment against the plaintiff or the defendant on a claim it considers that the plaintiff has no real prospects of succeeding in the claim, or the defendant has no real prospect of successfully defending the claim, as the case may be, and there is no other compelling reason why the claim should not be disposed of before recording oral evidence. Lordship, it is these two parameters that I had referred to at the outset of my submissions. Now, my lord, order 13A is set out. My lord comes straight away to paragraph 20 of the judgment. The twin test, therefore, provided for a summary judgment is, my lord, I had referred to these. Now, my lord, kindly sees paragraph 27, 28, and 29, which is the finding of the Honorable Court. May I place, my lord? It is quite evident from the email that have been exchanged that the defendants have refuted the correctness of the bills that have been raised by the plaintiff, which needs a trial. The plaintiff has also claimed that the defendant had agreed to pay rupees such and such, which also needs to be proved by adducing evidence, since it has been outrightly denied by the defendant. There are neither any undisputed facts nor admitted documents from which it can be inferred that a summary judgment can be passed. A definite defense has been taken by the defendant, denying the authenticity of the documents relied upon, and also highlighting the contradictions in the documents and the facts asserted in the plaint by the plaintiff. It is the plaintiff who is required to prove his case and also the documents relied upon by him, and it cannot be held that the defendant has no real prospect of succeeding in its defense. Considering the disputed facts and also that the plaintiff is required to prove its documents and case, it is held that the twin test for pronouncement of summary judgment not been satisfied. My lord, I believe I have dealt with all the contentions of my learned friend.
Yes.
These are my respectful submissions.
Thank you.
May it please, your Lord. It's like I'm stuck between the devil and the deep blue sea. I'll just quickly reply to the contentions raised. The first argument or objection raised is that I have a defense raised. I have raised a contemporaneous dispute, and I do not disclose any documents. In my order 13A, I have disclosed the commission agreement. The terms of the agreement have not been read in full. The agreement provides I will be entitled to commission annually for all sales made. So on that basis, the demand was made. When that demand was made in 2015, it was from 2006, 2007, 8, 9, 10, 11. When I made in 2015, first time a termination or an oral contract has been pleaded. It was not pleaded contemporaneously. It was pleaded then, which I replied. Having replied, it is a defense that I have raised a plausible defense, the order 13A should not be allowed. So kindly remember, Your Lordship, on 14 December 2015, when my demand goes, then the document comes. So whether I put my case of the defense of the defendant as sham or illusory, I will just try to demonstrate that.
Yes.
If the agreement is admitted, then the entire defense raised in 2015 should be given a go by. The second aspect which has been raised is that I have made a submission that the entire defense has been set not by the revisional court. While I made this submission and when I went back and did my homework, there is an expression, estoppel acquiescence by accord. If between two parties used the pleadings when the self-same defense has been raised and at a prior proceedings the entire defense has been set not, the learned friend or the party is precluded from urging the same defense. The learned court has to deal with the same facts. I do not wish to on reply, but I just want to rely one paragraph from the Supreme Court. 2000.
But
yes.
Which document you are supporting your submission?
Lordship,
Because
only I'll just indicate.
agreement.
I'll indicate you, Lordship. If there is an agreement which is admitted.
Correct. Okay, admitted, and it was going on, but subsequently your client has accepted instead of 3, your client has accepted 1.25.
My client
and your client has not raised any further claim.
My client has raised. That's
Where
it.
is the
My
claim?
client, that is the notice which was given. My client has received 1.25%. My plain cases, after giving adjustments, because the agreement was continuing, I have been receiving 1.25%, which was accepting. But after giving adjustments of whatever the commission I am entitled to, this is my entire amount.
Where is the case?
This is the plain case.
Where is the case? 1.25 is the adjustment, and this leaving aside this 1.25, the further amount is there. Pay the other amount. Where is their claim on that?
Let's maybe put in Lordship.
Kindly come to your letter, first your letter dated.
My letter at page. This is my letter at page 45.
Yes, 45.
Reference to made to the contract between your company and our client. According to point number 2 of the contract, our client is entitled to receive a commission of at least 3%. This is the simple case made up. He has not, I will be very candid. My client has not put in so many words, but he has only referred to the contract and said, look, at the end of the year, whatever payments I am entitled to this payment. This is your obligation. I have nothing to say. Assuming in 3% I receive 1%, I am not saying anything. This is my plain case. I said
that's why. So if you receive the 1.25, suppose there is a transaction between you and the defendant of rupees 1 crore.
Yes.
Correct.
Yes.
And you have received in terms of the agreement, you are supposed to receive 3%.
Yes.
As agent.
Yes.
As commission.
Yes.
Correct. But you have received only 1.25.
Yes.
So what is your claim before the defendant to the defendant? Sir, please, this was the total amount. You have received this amount. Please pay me the remaining one. Where is that claim?
There is, I'll be very candid. There is a statement which was sent. The statement is with me, but I have not put it on record. I can show that.
Not put up.
I know my client has not put it. So Your Lordship, I'll be very candid. There has been a delay on the part of my client. My client could not contest it well. But I am only supporting whatever is with the limited documents. I am only trying to club the missing links. There is a contract which provides entitles me 3%. I say in my plain case, after receiving whatever money you have paid to me, I am entitled to receive this amount of money, which was my demand.
Correct. So they are denying that.
They have been denying that on the day when I made a demand.
Yes.
Yes.
They are denying.
Yes.
So how the order 13?
Yes. Now how the order 13? Now this denial was the entire substratum of their suit. Can
under order 13 application it will be decided?
Your Lordship, on an order 13A, there are 3 principles which has been set by the Supreme Court. 1, if my learned friend brings out a triable issue with a clean hands, he gets unconditional leave. If there is a triable issue, disputed facts, then also he gets a leave. But in the third, if the defendant comes, he is not acting in the best of the faith and comes to the court, raises a tribal issue, this court has ample jurisdiction to consider the facts, put him on terms to contest
Yes,
that.
with condition, yes, no problem.
Now, only thing, why I say so, I fall within that my learned friend has not come with good faith. Now, kindly allows me to place 2 paragraphs, then I'll just come. So, this is the decision reported in 2005, 1 SCC 787, Bhanu Kumar Jain versus Archana Kumar and another. So, I am only placing the head note. Kindly see Placidum D, especially paragraph, kindly comes to paragraph 29 once. This is what I want to rely on. There is a distinction between issue estoppel and res judicata. What I am only before your lordship is that if the defense which has been put forward cannot be looked into, and if the subject matter of the agreement is admitted, and if the defendant comes with the suppression, then your lordship has ample jurisdiction to put him on terms.
Correct, no problem.
I am only on that.
Show me.
Yes. Now, the res judicata debars a court from exercising its jurisdiction to determine the list if it has attained finality between the parties, whereas the doctrine issue estoppel is invoked against the party. If such an issue is decided against him, he would be estopped from raising the same in the latter proceedings. Now, kindly read his plain case. His entire plain case is matching whatever his written statement is. Now, when it was brought before this court, the learned judge at the opening para made a statement and declined to pass 2 reliefs. Now, your lordship, kindly consider the situation. My entire defense on which the relief, and more importantly, the suit which has been filed is running ex parte also, because a show cause has been filed, they are not taking steps. Now, the entire issue of defense on the basis of which 2 reliefs have been claimed have been put at naught by this court. Can that very defense be looked into? My respectful submission, no. There is an issue of estoppel which will arise now, and he is precluded from taking that defense. This is one. Now, lordship, kindly comes to the why I said faith and good faith is important. What my learned friend read out from order 13, I am also
reply your
I know, but that's the 2 paragraphs. I am not saying anything. I understand the difficulty because I was also struggling to get something. So kindly comes to internal page 309, 33.1. Because I know I am on a difficult situation, but still I want to fall back within the corners of order 13 in subsection 7.
Yes.
Also, my learned friend has read out the entire proposition, or she wants to fall back under the previous classifications where a leave should be granted, admission, etc. I am only on one point. As noticed, if the defendant satisfied that the court hears a substantial defense, that is a defense which is likely to succeed, he is entitled to unconditional leave to defend. I pause here for a minute. The defense which has been urged has been already examined by a court and has been struck off. So that defense can't be put again. In the second eventuality, where the defendant raises triable issue indicating a fair or a bona fide reasonable defense, albeit not a positively good defense, he would be ordinarily entitled to unconditional leave to defend. My learned friend is trying to put a case here. In the third eventuality, where the defendant raises triable issue, but it remains doubtful if the defendant is raising the same in good faith or about the genuineness of the issue. I am only here. My point is, when I said that there is a suppression, my learned friend has affirmed that affidavit written statement by saying true to knowledge. That fact was well within their knowledge that the matter was carried to the High Court in a revisional jurisdiction, which was not disclosed. The order was not disclosed.
What?
The order of Justice Banerjee in a civil revisional proceeding was not disclosed. The fact that the challenge
order of
Justice Sanjeev Banerjee in the civil revisional proceedings against the order of rejection of plaints was carried. That was not disclosed.
We are not disclosed.
In the written statement in the opposition, they made a misstatement that I have not suppressed anything. And a statement is being making that I have accepted the plaint. I have not, because the challenge was made and I carried the challenge here. And since the 2 reliefs have gone, nothing remains in the plaint. So that means I have not accepted. My only thing, if the defendant is having a so plausible defense, the defendant could have brought this on record. The defendant has chose not to. 3 affidavits affirmed on statement saying no suppression. Is it in good faith? And the same defense is being taken on. The same defense is being urged, which my learned friend is stopped by waiver. Which she can't.
What waiver? What waiver you are
Waiver, Your
claiming?
Lordship.
What estoppel you are claiming? Show
What
me
I
that.
am
What waiver and what estoppel you are
Yes,
claiming that? Show me. What they have already pleaded and then now they
yes,
have
yes,
waived.
yes, yes,
Show me that.
yes. Your Lordship, kindly comes to page 50 of my application. And
Yes.
I'll just put forward with the written statement, Your Lordship. And 23 of their opposition.
Correct. Opposition.
Yes, opposition, because that
Okay.
is the defense that has been urged now.
Yes.
Lordship, kindly sees paragraph 1, admitted position, where they plead that the plaintiff is a manufacturer and exporter of garments,
Correct.
which they have admitted that they are exporter
So
of.
you are the page 51
Yes,
and kindly come to the page 23.
yes,
7A.
yes,
Correct.
yes.
7A2.
Entire verbatim.
Correct. That's simple. Let 7A2.
And this is a page 54, sometime in 2006. Compare it with page 25, paragraph 11. The entire verbatim starts. The story starts.
Sometime 2006. That is up till page 25, paragraph 11.
No, it continues, Your Lordship, till.
And pursuant to yeah, that is also there.
It kindly comes till page 62. And it continues till page 29, the entire averments made.
Page 29.
Yes, they have put all the reliefs.
Yes.
More importantly, this relief was put without any explanation that these two reliefs have been set at naught by the High Court.
Second, defendant files the suit before the itna claim for. So 29, whatever the plaint they have filed before that.
Yes, so that's the defense.
That has been.
And thereafter is a denial.
That has been.
Yes.
So they have not suppressed that they have not filed the suit. First thing. They have not suppressed, they have filed the suit. So they have disclosed what the suit.
Yes, after I disclosed in the plaint, they have disclosed it. Yes, yes, they have not suppressed.
After the plaint, only the return statement will come.
Yes, I bow down. Yes.
Correct.
Yes.
Now kindly come to the page. So with regard to this, there is no suppression.
No.
Or there is no acquiescence up till paragraph page 29 of the written statement.
There is no suppression.
No suppression. There is no acquiescence.
Acquiescence waiver, I say, because this subject matter.
Which one?
This subject matter.
Paragraph 7A.
Yes.
To paragraph 20 till page 29. You say this is the acquiescence or waiver?
I say paragraph, the plaint case from 7 to 29 was the subject matter in Shalda court.
Correct.
Yes.
So that's I'm telling. Paragraph 7A to paragraph 20.
Yes.
C.
Yes.
There is no waiver because they have verbatim of the plaint which they have filed before the Shalda court.
Right.
So there is no suppression in that.
There is no suppression.
Suppression in that. Correct. Now kindly come to the page 20, paragraph 21. Which paragraph you wanted to point it out that this is the acquiescence and this is the estoppel?
I am
Show me that.
The paragraph which I point out on estoppel is that the entire pleading.
Show me.
Your Lordship, I am just saying. May I just place it? The plaint case 7 to 1 to 29 and the defendant's paragraphs up till 20. This subject matter was urged before the trial court, which has been adjudicated once. So, raising the same defense, he is stopped now to raise the same issue in his written statement. This is I'm on. Estoppel by accord. So, he cannot be now permitted to raise the same defense which he has raised in the plaint.
So, defense kindly come to the. This is a counterclaim. Written statement is not a counterclaim. They have claimed a counterclaim in the written statement.
No.
So they have stated whatever the facts they have narrated in the suit. Correct. This is not a claim. What they have narrated the fact in the Shalda court, they have verbatim has been.
So
given.
The fact which was narrated in the Shalda court also was pleading an oral
They were not
contract.
asking the same prayer before in the written statement by your counterclaim.
Lordship, his prayers in the written statement is my plaint should be dismissed.
Dismissed.
And
but they are not asking for the prayer which is the prayer before the Shalda court. So how you can the claim? This is only, they have given the defense what they have taken the plea in the Selda court.
Your Lordship kindly comes to paragraph 28, page 33 of their opposition.
Page 28.
Yes, page 33, page 28 of their opposition.
Paragraph
28, page 33.
Yes.
The suit is liable to be dismissed. The plaintiff is not entitled to make any prayers or claims. So my claim in my plaint is on account of invoices, and their case in the plaint is that I am not entitled to raise any claim on account of the commission agreement.
Correct. So that's why I'm telling after that.
Yes.
Page paragraph 20 onwards.
Yes.
Now they have made the defense with regard to a paragraphs made in the plaint.
Yes.
What defense they have made in the paragraph?
The self-same defense which is the
Show
plaintiff's.
me.
Yes. Kindly comes to paragraph page 29, paragraph 22. Kindly see para 25 first, page 30. It is denied that during this period, in order to promote, I have traveled. The plaintiff is strict to performance of agreement. Kindly sees.
Denied and disputed.
Yes, everything denied dispute.
And then
Whatever. Worship, my respectful submission, if I'm not able to make it under what I'm trying to contemplate, estoppel by accord is if a party in a trial court has made a preemptive suit on an action on facts, and on those facts certain reliefs are being claimed. The self-same facts are being put as a counter defense in the present proceedings. When in earlier proceeding, those facts and those reliefs were not being granted. My respectful submission is that this court cannot look into this defense because it has already passed the test of scrutiny. And my point on suppression here is that at nowhere in the written statement, Your Lordship kindly sees.
Yes.
Kindly sees the disclosures or the documents relied upon by the defendant, the order of the court in civil revision not disclosed, nothing mentioned. So my respectful submission based on these two decisions, the plain defendant may have made out a triable issue, but if I am able to show that the defense is sham, then my respectful submission, Your Lordships can put in on terms. A plea has been set up that I have been avoiding. I'm not able to serve, but kindly look at the orders. All the summons which were served being returned as unserved. It was on the same address which was being served. I am not going into the nitty-gritty, but today I am standing before Your Lordship with a plain case. I may not have documents, but having the agreement admitted, my rights admitted on a contemporaneous document, it has been terminated when I ask a demand, and when they file a suit, a negative suit saying that I am not entitled to the claims, that self-same defense is put forward. Your Lordship will not see is perverse. My respectful submission is sham, and hence my learned friend should be put on terms. I am not putting on the broader framework, but I am only on the limited framework. That's all my submission.
Okay, thank you.
My lord, may I only briefly just distinguish the issue as it's come up in rejoinder? May I just have a minute? My lord, the first judgment that my learned friend has relied on in 2005, volume 1, deals with issue estoppel. My lord takes paragraph 31. It says if the cause of action was determined to exist, that if his judgment was given on it. My lord, I do not propound further on this. The law is well known. And my lord, the other judgment, 33.1, if the court is satisfied that it is a substantial defense, and my lord, my learned friend is going on harping on my plaint case has been set at naught. I take serious exception to this, my lord. The revisional court has only tomorrow, my lord, nothing prevents me from amending the plaint. I can amend the plaint, take out the reliefs that have been incorrectly drafted and substitute it.
After
there are
10 years.
Catena, he's coming to court after 10 years himself.
Yes.
That's all, my lord. I'm obliged.
File the written notes.
Yes.
Sense opening for the plaintiff, sense opening for the defendant. Hearing concluded. Parties are directed to file their written notes of arbitration on 16 July 2025. Please, the matter on 16 July has to be mentioned only for filing written notes.
My lord keeps it on
16 July.
for filing of the note. I'm obliged.
Yes, call the matter.
Our application for revocation, Lordship will recollect, letters of
My lord, I am appearing. My lord, if your lordship kindly permits me to complete the argument online, my lord, kindly, my lord.
Yes, no problem. Yes.
My lord, if your lordship remembers, my lord, this is with regard to a revocation application filed in respect of, my lord, letters of administration granted to my mother, who had already dealt with the, my lord, the property, filed reports before this court.
But I think some of the judges has taken so many notes. So why?
No, my lord, your lordship had taken the notes.
No. There are other notes of the other judge.
But there was only one, my lord, may I just point out, Justice Pattanaik had taken some notes.
Yes.
After that, your lordship had heard it out extensively. I was in reply, my lord, I had made my submissions on section 6, if your lordship remembers, that there is a change in section 6 amendment, where, my lord, in co-parcenary, my lord, testamentary jurisdiction, now, my lord, it is on the death of the person in the nature under the Succession Act, where my learned friends were saying that no, co-parcenary develops a right in all properties from the birth. And I had shown that, my lord, if your lordship, my lord, it's been quite some time, I do understand, my lord.
Yes.
So, my lord, I'll just point it out once more, my lord. Very quickly, my lord, because obviously, my lord, kindly sees the applicant who has come before your lordship is the widow of Dilip Wadhwa. Now, my lord will kindly take, if your lordship kindly takes page 14 of the application, which is the a genealogical table, my lord.
Yes.
In the genealogical table, your lordship will find your lordship will find that on the second column, second row, fourth box, your lordship will find A. Pujara. And, my lord, the estate belonged to Damodar Das Wadhwa. There's no dispute about that, my lord. The estate belonged to Damodar Das Wadhwa. Now, my lord, kindly sees my learned friend's client is Jayasri Wadhwa, my lord, at the very bottom of that page, left-hand column, left-hand corner.
So your simple case you made out that it is by Mitakshara, not by the survivorship.
Mitakshara, yes. Even my learned friend said so. I said Mitakshara, but with the amendment of section 6. That is what I said. Yes. And that is my only case, because now their case runs on the earlier Succession Act and Mitakshara concept. And I say that after this, there is no more any dilemma about that. Now it has to be in the succession manner, and therefore, my lord, the schedule will apply. And I've shown the schedule where I am on a second class on a higher pedestal than the person who has come before your lordship. This was the only case, my lord. And other than that, my lord, they said that we were required to also cite them. I had pointed out the provisions of the original cite rule, saying that no, there was no requirement for citing them also. The judgments galore also saying that the class where it has to be divided, they are the persons who are entitled to citing.
Correct.
So these were my submissions, and, my lord, in the subsequently, my lord, when they produced a will, my lord, they produced a will which stood, my lord, revoked also prior to this application, my lord. Then, my lord, though they did not mention anything in pleadings, my lord, that the advocate on record was the same, so he knew, but some kind of a foggy submission, some fog on the transaction, but there was nothing on pleadings. So I said, if they have not pleaded it, they cannot make out a case out of it. So these were my submissions, my lord. I was only required to, my lord, deal with the judgments which they had placed, my lord. But your lordship will kindly take the judgments which they had, and then I will place, my lord, the judgments which I refer to, my lord, and I think I can end it there, my lord. My lord kindly takes the judgments which they had placed, my lord. Judgments Guru. Judgments Guru. My lord, may I just first take your lordship?
Yes.
My lord, if your lordship kindly takes 1990, 3 Supreme Court cases, page 333. So, my lord, they had cited this judgment, my lord. My lord, at paragraph 9, if your lordship kindly sees.
Elizabeth,
my lord.
yes. This is for the caveatable interest.
Yes, my lord.
Yes.
Saying that, my lord, kindly sees the learned paragraph 9 only, my lord. Counsel, however, lastly submitted that the petitioner, in spite of having substantial interest in the estate, is losing her right to prove that the alleged will by such and such is not a genuine one, and that is a fictitious one. We must point out that by granting a probate, the court is not deciding the dispute to the title. My lord, I am relying on this because at every instance, my learned friends are making out a case, my lord, that these properties are joint family properties. But your lordship will not find a single particular as to how this has devolved, how this is a joint family property. The only thing which I have found, my lord, they have said is that can a person or a male be the owner? My lord, that is the maxim they said, my lord. Can a person who's a male be the owner of necklaces?
Yes.
Which they say this is not possible. Therefore, these are joint family properties. Well, this cannot be a pleading for proving any joint family property, my lord. I humbly submit. And if it's a joint family property, your lordship, it becomes a question of title. They will have to prove it and take it.
No, if it is a joint family property and the person are having their interest, so they are not in having a claim over the property.
Well, again, I say, my lord, let me not take the jewelry as such. Let us say it's a property as a landed property. But it would be a title dispute, which my learned friends are making. A probate or a letters of administration will not decide on the title.
Correct.
They will have a right.
The probate court cannot decide the title, but if the court finds that the person interested,
yes, my lord,
not made a party in the probate proceeding, have a legitimate claim. So whether
I'm grateful, my lord. I'm coming from there, my lord. My lord, then, my lord, they will have to show from where this becomes a joint family property.
That is different.
That's why, my lord. First of all, my lord, they don't come at the relevant time. Now, when they come, they must show that how it has devolved as a joint family property. Just by saying they are jewelry is relating to the female part of the species, my lord. Therefore, my lord, a male cannot wear a necklace, my lord. I think male can.
Female jewelry should be going to the female only, not to the male.
My lord, today's world, my lord, with humility and without any disrespect to anyone, my lord. Anyone and everyone can wear a lot of things, my lord.
Okay, next.
And my lord just stopped me at the right time, I'm sure. So, my lord, therefore I say, my lord, pleadings become also very important in this case, my lord. And my lord, I will be referring to a judgment that on the basis of a vague pleading, cause of action cannot be made out. You have to, because that's the general principle of a code of civil procedure also.
Okay.
I must have a right of objecting to it.
Okay.
I must. So that is why, my lord, I say, my lord, this also says that the title cannot be decided. Even if it is a 263 title, once they say it's a title challenge, it cannot be done in 263. That is the basis of this judgment. As a matter of fact, I'm relying on this judgment.
Okay.
Next, my lord, kindly takes, my lord, is, my lord, AIR 1964, Calcutta, page 34, my lord.
Yes.
My lord, kindly sees the facts of that case, my lord.
Yes.
But here, lordship will find 4B, my lord, what has been referred to. The names of the brother of Muhammad Bashir and his descendants have not been given in the petition.
Where from you're reading?
My lord, paragraph 4B.
Yes.
My lord has been handed over, my lord, SCC online.
SCC online, yes. SCC.
Yes, my lord, paragraph 4B, my lord.
Yes.
The names of the brothers of such and descendants have not been given in the petition, admitted they're distant heirs of Muhammad Bashir under the Mohammedan law. So in the present setup, they are not entitled to any share in the estate of the deceased. Then your lordship will kindly see reference is made to para 5, which sets out sections 263.
Yes.
Now, when my learned friends have taken the point of section 263, then they have come to paragraph 8, section 283 of that judgment. The district judge with full discretion to whom citation is to be issued. But at first, admittedly, it's the discretion of the district judge. I cannot also stand in the way. The district judge comes to the conclusion, even the High Court will have to do that, being the judge under the Succession Act. The persons to be cited are persons claiming to have interest in the estate of the deceased. Now, in view of, again, I say, section 6 of the Succession Act, as it stands, amended, they are not the persons interested anymore. Because under section 6 and section 9, persons interested have to be at the same level of the schedule.
Yes.
Therefore, I humbly submit, that this judgment, being of the year 64, may not be applicable at this stage, Then, will kindly come to, this is, 1929 Rangoon,
Yes.
Dear Lordship will kindly see. I'm not in the habit of reading the head notes, but the head notes are very nicely written. But straight away, if your Lordship has the Rangoon series, with your Lordship,
Yes, Rangoon series, yes.
Rangoon series. It kindly takes page 41 running.
Yes.
Under section 218 of the Indian Succession Act, if the deceased has died intestate and was a Hindu, administration of his estate may be granted to any person who, according to the rules for the distribution of the estate.
Where from you are reading? Under section? Acha, okay.
41, I have absolutely the top minute.
Yes. Deceased has died intestate, was a Hindu. Administration of the estate may be granted to any person who, according to the rules, distribution. Yes.
Distribution of the estate applicable in the case of such deceased would be entitled to the whole or any part of such deceased estate. So, the distribution part comes in now, therefore the schedule will prevail. Correct. That is why, this as a matter also supports my case. But I could have very well understood, that the co-personality principle remained the same. But obviously, subsequent to the amendment, it is not the same anymore. And section 4 of the Succession Act, Hindu Succession also has an overriding effect.
Okay.
This is section 6, subsection 3. I'm not reading it again. I've read it. If you watch it once, I can. But that is my case, basic case. Then, the other judgment which they have referred to is 2008, 10 Supreme Court cases, 489.
Yes.
Here the point is, the ratio is, even a person with the slightest of interest has a caveatable interest. There is a principle which I cannot obviously object to. But on facts, your Lordship will kindly consider, even from their pleadings and their genealogical table, do they fall within the same level as that of my mother?
Yes.
When your Lordship will find that it is not the case, this judgment is also will not going to help my learned friend's client. Then, 19... 58 coverage. 2022 SCC online, Supreme Court 539.
Yes.
नहीं करना.
Yes.
But there also the case was that the person who was entitled to citation was not cited. 2022 Supreme Court case online, Supreme Court 539. But again, I fall back on the same submission as my last one, These would not be applicable at the in this present case, Your Lordship will kindly see paragraph 4, 5, These are all the illustrations given.
Yes.
But kindly once looks into paragraph 2, if Your Lordship kindly promise me, The appellant sought letters of admission registered will deed said to have been executed by one Thakappan Nadar in favor of the appellant, brother of the testator and his 2 sons. After the grant of letters of admission, another brother of testator filed an application for revocation. So, they're at the same level, So, therefore, the distinction which I've been trying to draw is from the facts of this case,
Yes.
Now, these are the judgments my learned friend has shown, May I just rely on 2 judgments, if Your Lordship kindly first takes.
No, there are other judgments.
But I had 6,
1957 SEC online Calcutta 146. Then 2022 SEC online that is already done.
50, I'll just deal with that, I'm sorry, 58 Calcutta. 58. Not such a 58 Calcutta. Yes. AIR 1958 Calcutta 377, I was not aware that they've shown.
Yes.
But here Your Lordship will find, I think they have referred to
paragraph 26.
26, and I'll also refer to paragraph 42 and 45. 26, revocation is claimed that the circumstances connected the execution of the will are suspicious. Then, the suspicion and everything has been sought to be discussed. Kindly sees just in the middle, but it seems to me that it would be wrong to accede to such an argument. A creditor attacking the genuineness of the will as the appellant in our case does would, if he had notice of the probate proceeding, have been entitled to appear and oppose the grant. So, it was the case of a creditor, So, in that case, the case was made out for the purpose of showing that there were circumstances which are suspicious. Now, let us consider what could be a circumstance which is suspicious.
Paragraph 20.
Today,
paragraph 26, last 5 lines.
Now then, if the creditor opposed the grant and showed that the circumstances, those are the lines.
Yes, continue.
Now then, if the creditor opposed the grant and showed that the circumstances in which the will was said to have been executed were suspicious, the court would have acted in the principle of Tyrell versus Payne and refused probate. But again, there is no quarrel with this,
No,
this is the principle.
Now come to next. That's why I'm telling on the same paragraph, in the next 4 lines from the bottom of the same paragraph, 4, 5 lines.
It seems to me.
Yeah, it seems to me that a
case like this can be brought under explanation B in section 263, which provides that the grant can be revoked when it was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case.
Correct. This is the.
May I take all 3, one at a time? The fraud, I have not found any specific pleading on fraud. Next, making a false suggestion. I have been able to show that the persons to be cited are the persons interested under the relevant act.
Yes.
And I've done that.
Yeah.
And I'm specifically referring to the genealogical table given by my learned friends in their application. Then, my lord, or by considering from the court something material. Now, my lord, there's been an attempt to make out a case that I was required to bring it on record before your lordship that there was a will which was revoked. My lord, may I say this, my lord? Let us say, my lord, there has been consistent revocations of will. My lord, I have given effect to the revocation of the will. When a will is revoked, and that also by my lord, by way of
that's what they have made out a case. There was a will, and the witness to the said will, also the advocate of the same, and it was revoked. Subsequently, you filed the case. That portion, revocation of the will, and the person who was the witness to the will was the same advocate, has not brought to the notice of the court or not pleaded in the application. So whether
my lord, may I just take it from where your lordship just left it, my lord? First,
that is the thing.
Is there a will? First is that question which I'll have to answer. When I'm making an application on letters of administration, I need to show your lordship that there is no will. Is there a will? The answer is no. Now, why is there not a will? Because there's a revocation. My lord, today with humility I say, my lord, there is no challenge to this revoked will. My lord, even today, there is no revocation application.
Okay.
Of that will.
Correct.
Now, my lord, my lawyer had to bring it on record, my lord, with regard to letters of administration. My lord, I have shown your lordship that what are the particulars required for a probate application on the original side rules.
That you already shown.
I have shown. So it is not a condition precedent. Then, my lord, what is to the extent that I will have to show? My requirement to show before your lordship is that there is no will.
Correct.
If there is a will, then obviously my suspicion. And that I have suppressed fraud.
So you mean today, once the will has been revoked, there is no will in the eye of law. It is not required to be pleaded.
It is not required.
Correct.
I am giving effect to that there is no will. Yes. And man, it's a registered revocation.
Okay.
So that is what I wanted to say, Malad. Then what else would I have to say, Malad? Then Malad, that is the boundary which I wanted to show your lordship. If I had suppressed that there is a will, then yes, it's a material suppression. But when it is revoked already, then Malad, there is no requirement of telling that there is a revoked will.
Okay.
That is my submission, Malad.
But in that, then again they have made a submission in the revoked will. One person has got some interest over the them, and he had the knowledge, he had got the interest. But why you not made a party to them?
Well, that person has not come up.
Person who has applied for letters of administration, the court gave him the letters of administration without knowing that in the will she was expressly excluded.
I am very grateful, Malad. Let my learned friend say that there was a will first.
Okay. Next.
Today, Malad, there is a revocation.
Oh, I got your point.
No one has come up and said anything else.
As per your case, it has been revoked, so there is no eye of law.
And not only that, the suppression, if what he's saying has to be a material suppression.
Okay.
And if we had challenged it, or any of the beneficiaries had come and challenged it, we would have seen. It's a registered document. It has to be given effect. As on today, Malad, it's a registered document.
Yes.
That is what I'm trying to submit, Malad. Now, Malad, with regard to Malad, a few judgments from my side, Malad. No. Malad, I'll be referring to Malad 2029 Supreme Court cases, page 1, Malad.
Yes.
Kindly, Devdut, can you just please?
Yes.
I've already handed over I've already handed over.
Man, I'm grateful. Malad, paragraph 50.
Now, which judgment?
Hold on. 2029 SCC page 1.
Yes.
Paragraph 50, Malad.
50, 50.
50, Malad.
Paragraph 50 is at internal page 48, right on top left, Malad.
Page 48, Malad.
Yes.
Malad kindly sees paragraph 50 onwards, Malad, section 6 has been excuse me, Malad, has been set out.
Yes.
The substituted provision has also been set out at para 51. Then Malad kindly comes to page 50, para 52. The objects and reasons have been set out. And then Malad, para 53.
Yes.
Section 6 deals with devolution of interest in co-personal property of a joint Hindu family governed by the Mitakshara law. The originally enacted provisions of Section 6 exclude the rule of succession concerning Mitakshara co-personal property. The case which is being made out by my learned friend on the other side. It provides that the interest of co-personal male Hindu who died after the commencement shall be governed by survivorship upon the surviving members of the co-personality. Exception was provided that if the deceased had left surviving female relative specified in class 1 of the schedule, a male relative, especially in that class who claims through such female relative, interest of such co-personality shall devolve by testamentary,
intestate succession,
or intestate succession, as the case may be, in order to ascertain the shares of a deceased co-partner. The partition has to be deemed before his death. Exception 2 disentitled the separated person to make any claim in case of intestate. Then, though the widow could claim a share, being a class 1 heir in the property led by the deceased, the widow was entitled having a right to claim a share. In the event of partition, daughter was not treated as a co-partner, goal of gender was done. Then, kindly comes to paragraph 60 and 61. The amended provisions of Section 6.1 provide that on and from commencement, the daughter is conferred the right. Section 6.1 makes a daughter by birth a co-partner in her own right, and the same manner as the son. 6.1a contains concept. 6.1b confers same rights. And then kindly comes to 61, which says that the prospective statute operates from the date of its enactment, conferring new rights. So, I say that from that date, this whatever the statute has changed will apply. In this case, it is subsequent to the amending position.
Yes.
Then, I will refer to 2023-10 SCC. Page 1. Okay. Page 1, Malad.
Yes.
This also similarly provides in paragraph 40, 49 to 51.
Yes.
And 61, Malad kindly takes 49, Malad. I think I'll just read this, Malad.
Yes.
Before the amendment, that's at page 38, running Malad. Before the amendment, Section 6 provided on the death of a male Hindu, his interest in Mitakshara co-personality property would devolve by survivorship among the surviving members of the co-personality, not in accordance with the mode of succession provided in the Act. Section 60 of the amended provision now stipulates on a Hindu dying after the commencement of the amended Act, his interest in the property of a joint Hindu family governed by Mitakshara law devolves by testamentary or intestate succession, as the case may be, under the Act and not by survivorship. So the case which is being made out by my learned friend's client, Malad, is by survivorship through her husband, who is also deceased now. Malad, that may not be the correct proposition at this point of time. Then Malad kindly takes two judgments. One is 2001, 8 Supreme Court cases, 233, for the proposition, Malad, that vague pleadings would not constitute a cause of action. কোথায় এটা? তো হয়ে গেছে, দেখেন খুলে রেখেছো।
এই জাজমেন্টটা দেখাচ্ছি।
দেখাও তো, খোলো। মানে kindly takes para 23.
Yes.
This is with Representation of People's Act case. Mandates that an election petition shall contain a concise statement of the material facts on which the petitioner relies. By series of decisions, this court is well settled that the material facts required to be stated are those facts which can be considered as material supporting the allegations made. In other words, they must be such facts as would afford a basis for the allegations made in the petition and constitute a cause of action. And then expressions, kindly then takes placitum E. The function of the party is to present as full a picture of the cause of action with such further information detail as to make the opposite party understand the case he will have to meet. The question of it being a joint family property and also how they have reached a conclusion that these are joint family properties, that needs to be given. And if they're trying to say that my advocate on record has caused any suppression and fraud, there has to be specific pleadings for that.
Yes.
That is also not there,
Yes.
So paragraph 23 and 24.
Yes.
On 24, the last sentence, the last but one sentence, courts have always frowned upon vague pleadings which leave a wide scope to adduce any evidence. No amount of evidence can cure basic defect of the pleadings.
Yes.
And next, will kindly see 2015 9 SCC 755. This is basically a corollary of the earlier judgment. This is with regard to that nothing can be proved or argued which has not been pleaded. Kindly have a look at para 39.
Yes.
Paragraph 39. Sorry, just
39 paragraph.
Yes.
But here, mentioned there is a plaint filed by the appellant. Please set up was that the instigation of the defendant's collusion with them. Mill Mazdur Sabha had refused to give its permission to the sale of the mill. That's the defendant number 1 to the plaintiff. Not a case set up by the appellant. The Mill Mazdur Sabha had agreed to the proposed sale on certain conditions offered by the. In view of the settled position of law, fresh pleadings and evidence, which in variation to the original pleadings cannot be taken unless the pleadings are incorporated by an amendment of the pleadings in a considerable division bench. That was perfectly just been holding unless the pleadings are amended, specific pleas taken for the proposed that could not have been taken into consideration at all. But here also, the original application for revocation did not contain anything about the will or the revocation of the will. That was not the ground of making the application for revocation. And even if that has been made, now then they would have to show that they have made specific pleadings of fraud as against my learned advocate, because no one else has been specifically named to have influenced. If I could make out the case, it's not there. I'm just expressing my mind to the maximum that someone must have influenced the revocation. My advocate went out of his way to get it revoked and again filed, if that is the case. But there is no such pleading, But that cannot be in thin air, That is what I'm submitting, and it is not a part of the main petition also, So,
Yes.
These are the judgments which I would like to refer to,
Yes.
Those I think answers. If some new point is allowed to be taken by my learned friend, then I will give a reply. Otherwise, I don't have a reply to a reply. Those are my submissions. I'm grateful, I could not appear in person.
Thank you.
I'm very grateful.
That I start now or
next?
Okay.
So appearing for the executor. So appearing for the applicant. Counsel for the executor concluded his argument. Counsel for the applicant prays for time to give reply to the submission made by the counsel for the executor. According case is adjourned, let the matter appear. So yeah, date. 31st July at 3:45. 31st 3:45.
31st July. শুক্রবার না তো? আচ্ছা ঠিক আছে। 31st July, 31st June হবে কি করে?
Till 14 or 15, 14, this court will not be there.
This is my application, where Mr. Bose was supposed to make a submission with regard to
Item
15.
Yes.
This is the application where we had made a substitution application for substituting the heirs of one of the partners.
That power attorney?
Yes. No, not power of attorney.
Partnership.
Partnership. Whether the heirs of the deceased partner can at all be substituted. And when specifically prays for.
Your Lordship, I'm led by Mr. Devnath Ghosh, Your Lordship.
House Finance.
Good House Finance. You are there?
Yes.
My lords, we are appearing for the defendant number 2.
I appear for the person who is now sought to be brought on record.
My lords, I'm being led by senior advocate Mr. Bose.
I'm bullied. Milord, তোমার বলা হয়ে গেছে কমপ্লিট নিশ্চয়ই কমপ্লিট করতেই না you want to add up something you can. Milord, this is a dispute, Milord, it is coming of a addition of Milord, the legal heirs, Milord, of a partners in question.
You are appearing for?
Milord, I am appearing, Milord, the person who is now sought to be brought on record. So I, Milord, say Milord,
legal heirs of the plaintiff number 1.
Legal heirs of the plaintiff number 2. Of the
defendant number 1.
Defendant number 2. Milord, so far as this is concerned, Milord, it's whether it's legally permissible or it's legally necessity, Milord, Lordship will see that, Milord. Perhaps, Milord, it's not. The answer to that, Milord, is, Milord, the provision is this Code of Civil Procedure, read with, Milord, section 45 of the Contract Act in question. Now, Milord, the issue is, Milord, covered by 2 or 2 judgments of this court, Milord, of the Supreme Court, Milord, which says, Milord, because Lordship knows, Milord, I am a legal heir. It's not a personal cause of action. If Lordship takes the plaintiff in question, it's not a personal cause of action. I am a legal heir. Paragraph 2 of the plaint, it has been impleaded as a partner. Lordship has seen the plaint, Milord. I am a late entrant in the matter. I am as a partner.
Yes.
So, Milord, if I am introduced as a partner, my father or Milord, my predecessor, Milord, whether the heirs will automatically come in, or whether the legal heirs can restrain this, Milord, addition. That is the only legal issue.
Correct.
That, Milord, the only legal issue, Milord, I have to address, Your Lordship. Now, Lordship will kindly have a look at the plaint in question. Kindly have a look at page 14. Yes. Affidavit in support of master summons, page 14. The defendant number 1 is a partnership firm. The defendant numbers 2 and the original defendant number 3 have represented to the plaintiff as being partners of the defendant number 1. Upon date of the defendant number 3,
the defendant numbers 3A to 3D have become the partners of the defendant number 1 as heirs of the defendant numbers 3. That's the case. So, my lord, whether, my lord, on death, my lord, it's an automatic, my lord, choice, my lord, or an automatic right is given, my lord, to the heirs, my lord, to be added as a partner, and by reasons whereof that they should be added as, my lord, the defendant in the suit 3A to 3D. Now, my lord, kindly take, my lord, the defendants, the pleading are the defendants have obtained loan, etc., etc. My lord, as there's a case of dishonor of check, and my lord, a decree has been claimed against the defendants and each of them. That's, my lord, page number 20, as pleaded in paragraph 660.
Yeah.
But, my lord, the principal premise, how the plaint proceeds, that it is the defendant number 1 is a partnership firm, and defendant numbers 2 and the original defendant number 3 have represented as being partners of the defendant number 1. This is, my lord, the situation in law, my lord, which has been given. Now, if your lordship takes একটাই copy আর দেয়নি কিছু, এই তো দুটো দিয়েছে, কি বলছো তুমি? Lord, kindly have a first look at, my lord, 1984-3 Supreme Court cases 462. এই কোথায় কে এরা মামলার সময় থাকে না কেন বলো? একটাই কপি তো। Lord, the relevant provision, lordship, my lord, which comes in the way of the application is Order 30, Rule 4. Lordship will straight away come to paragraph kindly, my lord, takes paragraph 7 onwards. My lord. The averments made in the plaint unmistakably show that the plaintiff landlord unequivocally treated the firm as a tenant. The suit for eviction was filed against the firm, but as the other defendants claimed to be the partners of the firm, they were impleaded by the plaintiffs as the proper parties. It was open to them not to implead the partners of the firm in view of the provision of Order 30, Rule 1 of the CPC, which permits the firm to be sued in the firm's name. Undoubtedly, if a requisition is received to disclose that who are the partners, the same always to be complied with. The plaintiff chose to sue the firm and join the partners as proper parties. The material of the averment is that the firm is a tenant. Now, the question is whether suit is instituted against the firm and the partners are implicated as proper parties in the event death of a partner so sued, would the suit or the appeal, as the case may be abated, if the heirs of the legal representative of the deceased partners are not substituted within the prescribed period of limitation. This is a twofold answer to the question. Order 30 Rule 4 provides, notwithstanding anything contained in Section 45 of the Indian Contract Act 1972, where two or more partners are sued in the name of the firm under the enabling provision of Order 30, any person dies, whether before the institution of the suit or during the pendency of the suit, it shall not be necessary to join such legal representative deceased parties to the suit. Secondly, death of a proper party would have no impact on the suit, more so where the death of the partnership stands dissolved or the heirs do not desire to be join the firm. Both aspects were overlooked by the High Court. Turning to the facts of the case, we are concerned with the suit was framed and instituted. As it was framed and instituted, it is a suit for eviction of the firm was implicated as the tenant, and the deceased partners were implicated merely as proper parties, which tantamounts to making them formal parties. No relief of any kind was placed against them in their personal capacity. So, Lordship reads the plaint. If Lordship reads the plaint, well, they are personally liable. Then, will Lordship, of course, but the plaint proceeds on the basis defendants, but the plaint second paragraph, which is the main paragraph, sheet anchor, as the partners of the partnership firm. In this context, no relief was praised in their personal capacity. The The decree of eviction would operate against them according to the plaintiff because of the firm. Therefore, who was posted a question to the learned counsel for the respondent whether on death of a proper parties whose heirs and legal representatives were not substituted and no relief was claimed against such a party, would the suit or appeal abate more so when the parties against relief is very much there in prosecuting the appeal. The learned counsel for the respondent has no specific reply to the question except that if the firm is abolished, this is the argument perhaps here, then some new firm is created. The plaintiff may not take notice of it. We are at loss to understand the abolition and creation of the part. The position boils down is that the two of the partners were the appellant all along with the firm in the second appeal before the High Court died during the pendency of the appeal. It's nobody's case the legal heirs of the representatives are joined in the firm and they're entitled to be taken as partners in place and the deceased partners as the partners of the firm. Therefore, the question to be answered is whether on death of two of the partners or the formal parties implicated in the capacity as the partners by the plaintiff along in the firm in absence of substitution of legal heirs of the representative the appeal abates. The answer is negative. Therefore, the question of substituting the legal heirs of the two proper formal parties does not arise and death has no impact on the proceedings. Therefore, the appeal cannot arise. Similarly, the Supreme Court is saying, Millard. Now, Millard, there is one more authority, Millard. Your Lordship takes, Millard. Kindly, my lord, have a look at 1996 6 SCC 730.
Yes.
6 SCC 730. Huh? Kindly, my lord, take paragraph 5. As no suit was pending, either in the trial court or in the appellate court, when the High Court took up the revision of the first respondent, the argument was wanted or occasion to pass an order for impleading a new parties to the suit. The revision should not only have been dismissed as infructuous, even otherwise the court would have been very circumspect in dealing with the application of a third party seeking to become a party to the suit. When the plaintiff, who is the dominus litis of the suit, is opposed of, if the consequence of such addition would devolve a de novo trial, the court should normally have disallowed the application. The way back in 1931, the PV Council did not allow an application for implement on the ground such cause might have opened a de novo trial of the suit even after noticing the party to be implead was not merely a proper party but a necessary party. Here is the first respondent. That apart, para 6. That apart, even on merits, the first respondent's application filed under Order 30 Rule 4 is not maintainable on the facts of the case. The said rule is quoted below. Right of suit on date of a partner, notwithstanding anything contained in section 45 of the Contract Act, where two or more persons may sue or be sued in the name of a firm under the following provision: any of such person dies, whether before the institution of suit or during the pendency of the suit, it shall not be necessary to join the legal representative of deceased as a party to the suit. Not subsection 2 of 34. Nothing in the rule 1 shall limit or affect the right which legal representative deceased may have to apply to be made a party in the suit to enforce any claim against the survivors or survivors. So, 2 is an exception. 1 is a prohibition. Yes. The aforesaid rule 1 is clearly an exception to section 45 of the Contract Act. The principle made out in section 45 applies to the situation when one or person has made a promise to two or more persons jointly. The right to claim performance of a contract arising out of such a promise would then rest upon those partners together with the joint lives after the death of them. Such right would devolve upon the representative a joint promise with surviving promisee. Thus, if a joint promisee were partners of a firm in the provision obliges a legal representative of a deceased partner to join the rest in enforcement of right to have performance of a contract. This is the nub of section 45 of the Contract Act. But a conflict of opinion arose between different high courts regarding interpretation of the rule involved in the said section. The High Court of Madras, Bombay and Allahabad took the view that a suit for performance of the said right of a firm legal representative for deceased partner need not be implemented, where the Calcutta High Court took a contrary view. In such cases, legal representatives were necessary parties. In fact, sub-rule 1 of Rule 4 of Order 30 has been has been prescribed to resolve the conflict by diluting the rigorous content in the rule embodied in Section 45 of the Contract Act in relation to suit involving a partnership firm, where Rule 1 and Rule 4 of the code, that is, it is not mandatory to join the legal representative deceased as a party in the suit, when Rule 2 says, in the other words, that sub-rule is not an hindrance to legal representative deceased to get himself impleaded if he has other rights to do so. So it's a right given on the legal representative, not on a third, someone who tries to implead him as a party. It is therefore clear that the sub-rule 2 does not create any right for such legal representatives to get impleadings, but only operates an exception to sub-rule 1. At any rate, Rule 4, sub-rule 2 of Order 30 cannot come into the operating situation of Order 1, Rule 2 cannot be invoked. It cannot be invoked. Therefore, we allow the appeal and set aside the inquiry. So these are the two Supreme Court judgments. The third one, the recent view, Millard, Mr. Bose has already placed. Millard, I only need to, Millard, distinguish, Millard, Mr. Ghosh's judgment, Millard. It's 120. I can continue. Judgment huh? Mr. Rupak Ghosh's judgment. Millard, it's 120. I can go on continuing. I'm ready with the matter, Millard, whatever lordship. At
2 o'clock, let Mr. Ghosh complete. It will be better.
Matters, yeah, fixed matters. লিভ নিয়ে বসে আছে 3 মহিনা ওই তো মহিনা লিভ নিয়েছে
Today, Mr. Ghosh wants to continue. 3 o'clock, the matter I'm told, Malad, may not happen.
That matters already. Keeps it on
Already matters are already been.
Yes, already given. Why Miller deprive me of a free at 3 o'clock?
That's why I telling this in this court, the advocates are having a eagle eye to when the date will.
Miller, accept second any date, Lordship.
Sensation suffering for the plaintiff, sensation suffering for the defendant, sensation suffering for the legal heirs of the defendant. Number 3. Legal heirs of the defendant number 3. 2. Legal heirs of the defendant number 2. Counsel for the legal heirs of defendant number 2 argued the matter at length, but due to paucity of time, hearing could not be completed. Case had gone. Let the matter appear. कब है? किसी को ऊपर दे देगा ना 17 को. On 17th July. 17 July. Different number 3. Yeah. 17 July.
My lord rises, my lord. Since lordship won't be available next week onward, my lord. Lordship had appointed
17. Could it be 16th or 18th?
18th कर दो. No, 18th then होगा. 16th कर दो.
I'm mentioning upon notice on behalf of my lord, the special officer appointed by your lordship. Receiver appointed by your lordship.
16.
Name change आगे बोले दीजिए.
16, not 17. Not. Then Mr. Bose, catch hold of Mr. Bose. Then 22 22nd July. 22nd July. Yes.
Just for a change of name of the my lord officer appointed by your lordship by an order of 20th of June. My lord, lordship had appointed
11.
Para 11. He expressed some difficulty, my lord. Kindly appoint.
Should we give somebody junior's name, your lordship?
My lord, we can give my lord if lordship, my lord.
Both all parties are there.
Yes, I am here, but your lordship, the state of Madhya Pradesh, your lordship.
Not here. That is the problem.
That's the problem. That man again come.
No, but lordship won't be, my lord, there for a
What
while.
can
And
be done? But, it is very big problem otherwise.
no, it's only the personnel.
Maybe.
And personnel, it's absolutely lordship's discretion. He just expressed some difficulty. He was feeling embarrassed to come himself.
We can provide your lordship somebody junior say from Bar Library.
Remember, my lord, we can, my lord, discuss a name here and now.
Because I have given middle because it is the receiver, the department and police. Some problem will be there. For the administration, some problem will be there.
ওই জন্য senior বলছে
কি করব
Record the matter is mentioned by the learned advocate appearing for the decree holder and submit that the advocate who has been appointed as recently the learned advocate who has been appointed as receiver is having some personal difficulties and intend that he is not motion to act as a receiver and he prays for appoint some other advocate. in view of the submission made by the counsel for the plaintiff and the receiver. Oh,
Junior, Your Lordship, he can handle, Your Lordship.
he has been appointed as a receiver accordingly. Receiver instead of Mr. Anuj, in place of Mr. Anuj.
Item number 80.
Great. This order may be read with the be incorporated with the order dated. Would you date है ना?
Well, item number 80, it will appear in the heading of adjourned motion, my lord. Because I have filed a GA application.
Item number?
80, my lord, 80.
80?
80. It will appear adjourned motion, my lord.
80, you have filed an application?
Application GA number, my lord, under order 13A, my lord.
ठीक है, इसको adjourn motion में
Adjourn motion.
Next time,
I'm
yes.
grateful.
One indulgence. Next two matters, Your Lordship has a 2 p.m. fixed matter. I'm waiting for the response.
Which one?
Next two matters, 16 and 17.
16, 17.
16,
yes.
17.
Ah.
It's taken up at after the fixed matters, then I'll just.
I don't know if the fixed matter adjourned, then matter will be called. If it is not adjourned, that's why
I'll be on legs. If it's called, I'll just
okay.
pass on.
Mention any word.
Great.
These for the plaintiff. Can you take it after?
Shut down.
an unfortunate
You are
incident.
appearing for whom?
From the plaintiff, my lord. Due to an unfortunate incident in the family of the advocate in record, her mother expired. It could not be filed within the time. So now I'm seeking for leave for another 3 or 4 days to file. And in the meantime, we have also filed an application for judgment upon admission. Because some documents have come forward where they have admitted in writing about the unequal admission. So that is coming on the 30th. So this, and let us some 2 or 3 days be given to us so that we can have it filed.
My lord, the application was already served upon me, my lord, yesterday.
What application?
The judgment of admission.
Judgment upon admission application?
Yes, my lord. It'll appear on the 30th, my lord, before this honorable court.
Judgment upon admission application they have filed?
Yes, my lord.
Okay. Record an order. So and so suffering for the plaintiff, so and so suffering for the defendant. The matter is specifically fixed today for witness action. By an order dated 7th April 2025, this court has framed the issue in presence of both the advocate appearing for the parties and directed the plaintiff to file judge's brief of documents by disclosing all the documents within a period of 6 weeks after serving the copy to the learned counsel for the defendant. The plaintiff is also directed to file affidavit of evidence of the plaintiff witness within 2 weeks. Full stop. When the matter is taken up today, when the matter is called today, learned counsel for the plaintiff is informed this court that yes, what judge brief document is not ready.
Judge's brief of document is ready. We could not file because it could not be made ready within trial due to bereavement in the family of the learned advocate.
Due to some personal difficulty of the learned advocate on record of the plaintiff. And he also submitted that he has also filed an application under Order 12 Rule 6.
Order 12 Rule 6.
Judgment upon admission. Full stop. Concerning the submission made by the counsel for the plaintiff, this court find that the advocates appearing before this court had the knowledge that this court is having short of time for fixing the matters so that the matter can be disposed of expeditiously. In spite of the same, the matter was by an order dated 7th April 2025, this court has fixed the matter today, especially fixed the matter today for witness action. But the plaintiff failed to bring the witness today. Accordingly, the case is as per the submission made by the counsel for the plaintiff, the case is adjourned subject to payment of cost of rupees 50,000 to the State Legal Service Authority within a week from date.
Lordship, this could not be done because of the
It is made clear that if the plaintiff failed to pay the fee and the cost within a week, the evidence of the plaintiff will be closed. Pass over. Pass over. Pass over.
Due to bereavement of my
Next, call the matter.
your lordship has not granted leave, man.
Pass over.
My lord, item number 19, I'm for the plaintiff.
I'm for the
petitioner, my lord.
respondent.
My lord, in this matter,
The number?
my lord,
19.
19.
Yes, you the 19.
My lord, in this matter, our client has not been, we are not being able to seek specific instructions regarding our appearance in this matter, my lord, which is why we could not appear on the last occasion, my lord. My lord, and we are also in the process of transitioning the brief to another advocate, my lord. However, due to lack of communication with the client, we are not being able to endorse our NOC and provide our
You are appearing
NOC.
for whom?
The plaintiff, my lord.
Mr. Sarkar is appearing for the defendant.
For the
Plaintiff-
defendant, yes.
Plaintiff Sanchari Chakravarti.
My lord.
Then?
My lord, I'm the junior of Miss Shanchari Chakraborty. My lord, the difficulty is we do not have proper specific instructions from the client to appear, my lord. And
But
we
you are
have been
appearing
in touch.
Since beginning.
Yes, my lord, but of late there has been some communication and we are in the process of taking an NOC. I mean, giving an NOC. However, my lord, the clients are not communicating with us properly and as such, there is a communication gap. My lord, since we are the advocate on record, I still have some responsibility towards the brief. Hence, I'm appearing before your lordship, my lord. My lord would kindly keep it after 2 weeks so that the transitioning process can be concluded within the within 2
My lord,
weeks.
GA1 of 2023 is pending for a long time.
What is the GA1? What
My-
is the GA1?
GA1 that is filed by the appellant, my lord. What my instruction is, my lord, kindly, my lord, according to lordship's last order dated 10th June 2025, my lord has directed that if the plaintiff fails to appear and they have not concluded the submission regarding GA1, appropriate order will be passed. So my submission is, my lord, kindly dismiss the GA1.
My lord, we are appearing as per your lordship's
Kindly
directions.
see the order dated 10th June.
Yes, my lord.
Then
We are appearing as per your lordship's
okay, I am
directions.
dismissing when you will get the
My
instruction
lord, but
from
kindly
client.
keep it, just keep it 2 weeks after, my
No,
lord.
The court is not having such time.
My lord, I appreciate, my lord. However, my lord, because of this communication gap, we do not have specific instructions of appearance, my lord. We are trying to get in touch with the client so that the NOC can be given. However,
So
my
if your
lord, we do
client is
not.
not interested, why you are begging here? Your client is not coming to you. Why you are begging before the court?
My lord, as the advocate on record.
Let the consequence will follow by the should be followed by the faced by the your client. Why you? Either you are making a false submission.
No, my lord. We are not making any
So,
false submission, my
10th
lord.
June, you're not appeared. Today you are appearing and asking time. You know that the court will be dismissed the application in terms of the order date 10th June.
My lord, we did not appear.
Madam,
on
I
the
was
last
there for the
occasion.
last 30 years.
My lord.
I know.
My lord. My lord, on the last occasion, we did not appear because we are not receiving specific instructions from the client to
Okay,
appear.
no instruction. I record you. You failed to take steps because you are not getting instruction. That's why I will record that the plaintiff is not interested to proceed with the matter. I am dismissing it. Then the plaintiff engage the other lawyer and file an application. Let us. Why that this will be on board with the burden of the court.
My lord,
Record
I
an
yield
order.
to your lordship. My lord.
Sense appearing for the plaintiff, sense appearing for the defendant. Counsel for the plaintiff submits that they are not getting any instruction from the plaintiff and thus she prays for time for taking appropriate instruction or to withdraw their power from the instant suit. Counsel for the defendant draw the attention of this court to the order dated 10th of June 2025, wherein it appears that on 10th June 2025, none appears on behalf of the plaintiff, and this court has categorically stated that if the plaintiff fails to appear on the date fixed, appropriate order will be passed. Today, when the matter is called, counsel for the plaintiff prays for time. For the interest of justice, the case is adjourned. Let the matter appear on 28th of July 2025. It is made clear that as a special chance, it is made clear that on the date fixed, if the plaintiff failed to proceed with the matter, the appropriate order will be passed.
Grateful.
The suit will be dismissed.
I'm deeply obliged. I'm deeply
Very
obliged.
good. Very good.
Defendant's lordship. Lordship,
Yes.
I was being led by Mr. Shatri Bhattacharya on the last date. He had completed his submissions.
He was yet to conclude.
Praying for setting aside ex parte decree.
Concluded.
Well, he records that we will start on our next date, Your Lordship.
Why not today?
You were under the impression that he was to cite some more judgments or something else was left.
No,
Mr. Ray was leading me in the
counsel
matter.
for the defendants concluded the argument. The order dated 30th April is recorded. Due to paucity of time, the counsel for the plaintiff could not argue the matter. According to cases adjourned. It is 30th April itself. So why are you not ready with that?
Mr. Ray was leading me in the matter. Mr. Ray was addressing Your Lordship. Mr. Ray had...
Whatever it may be, the matter is in the list. Sense appearing for the plaintiff, sense appearing for the defendant. Counsel for the plaintiff prays for time. According cases adjourned. Let the matter appear on 4th of August 2025. Next.
Grateful, Lordship.
Mr. Ray was...
I appear on behalf of the plaintiff,
Yes.
opposing this application, GA2 of 2025 filed by the defendant number 1.
Who is for the defendant number 1?
Good, my lord.
Lordship, I appear on behalf of the defendant number 1. So my application
only one point. Your Lordship, the writ of summons served
Last
upon.
date you are not appeared.
Lordship,
You are
I was-
appearing for whom?
I am appearing for defendant number 1.
Only one, not 2.
1 and 2, Your Lordship.
1 and 2. Now on the last occasion, Abhimanyu Roy appeared for the defendant number 2 and 3.
Your Lordship, it must be a rating mistake. I think it should have been 1 and 2.
Okay. So what you have filed an application?
Lordship, my application
GA2.
GA2, Your Lordship, only 1 point.
What is the application for?
Lordship, that the writ of summons has been served without the affidavits accompanying as required under the Commercial Codes Act. And that amounts to non-service. Your Lordship, I will first take your Lordship through the provisions of Commercial Codes Act. If your Lordship kindly takes up the Commercial Codes Act.
Yes.
If your Lordship
Order
comes
6 Rule
to-
15.
Yes,
A.
Your Lordship, Rule 15A. If your Lordship
15A.
first comes to the schedule of the amendment as proposed in the Code of Civil Procedure, given in the Commercial Codes Act. If your Lordship sees
Commercial
the
Code Act?
first, Lordship,
Commercial Code Act?
Your Lordship, the first amendment of Section 26, the schedule which amends the Code of Civil Procedure, Lordship. Your Lordship found it, the first amendment is in Section 26. Your Lordship found it?
No. Where from you got it?
Lordship will see after the sections are stated, there is a schedule given for amendment. Wherein your Lordship, Order 11, Order Rule 6, Order 6, Rule 15, all have been amended in terms of the Commercial Codes Act. If your Lordship allows me, may I just point it out for your Lordship?
Yes.
Page 18, your Lordship. The heading schedule is given, and the first amendment is amendment to Section 26. Your Lordship, the proviso has been amended to Order 6, Rule 15A, where it reads, provided that such an affidavit shall be in the form and manner as prescribed under Order 6, Rule 15A. So the usage of the word shall is emphasized on. Lordship, thereafter, if your Lordship comes to the amendment made in Order 6, Rule 15A, Lordship will see the number 4 amendment of first schedule.
Number
4 amendment of first schedule. Lordship will see therein 4A, 4B is in Order 6.
4A, 4B, yes.
Lordship, it reads in Order 6. Is your Lordship found
Order
it?
6, Rule 1.
Yes, your Lordship. 1 says after Rule 3, the following rule shall be inserted. Now, your Lordship kindly sees Rule 3, 3A, 15A. Verification of pleadings in a commercial dispute. It says, notwithstanding anything contained in Rule 15, every pleading in a commercial dispute shall be verified by an affidavit in the manner and form prescribed in the appendix to this schedule.
Correct.
So it has to be strictly in accordance with the appendix given in that schedule.
Correct.
Now, your Lordship will also see 15A4, where a pleading is not verified in the manner provided under sub-rule 1, the parties shall not be permitted to rely on such pleading as evidence or any of the matters set out therein.
Correct.
So if it is not, your Lordship, you cannot rely. Thereafter, 5, the court may strike out a pleading, the effect if it is not so, strike out a pleading which is not verified by a statement of truth, namely the affidavit set out in appendix to this schedule. Now may I take your Lordship to Order 11, the amendment to the Order 11. This is the affidavit required under Order 11. Lordship, my only emphasis is on the word shall. If your Lordship allows me, I'll skip this part.
Now, if your lordship comes to the appendix 1, the statement of truth, the format of the statement of truth.
Yes.
This is the very end. Appendix 1, statement of truth. Now, your lordship, what is important here?
Yes.
Is point number 3 in this statement of truth. The jurate portion which is to be said, which is to be affirmed by the deponent. I say that the statements made in paragraphs blank to blank are true to my knowledge. One is true to my knowledge. It's divided into 3 parts, your lordship. And statement made in paragraphs blank to blank are based on information received, the second portion of it, which I believe to be correct. And statements made in paragraphs blank to blank based on legal advice. So the jurate portion in the statement of truth contains 3 separate, because your lordship order 11 rule mandates that you will have to file all your documents that is in your power and possession. If this is not the format, then your lordship, in my humble submission, it would amount to non-service. Now your lordship kindly takes up, my case is I have not been served with the affidavits in terms of the Commercial Courts Act. Now if your lordship kindly takes up the plaint.
Yes.
Your lordship comes to the
plaint.
Lordship, in that application, no, your lordship, the plaint is
So you are harping upon that and you are not enclosed that.
I believe my learned friend has done so. Plaint.
Yes.
Your lordship, even in my application, your lordship, because of the soft copy, it's there in the application as well. Has your lordship taken the plaint?
Yes.
Lordship kindly comes to the affidavit portion, internal page 33 of the plaint. Now your lordship kindly sees 2 in this affidavit. It reads that the statements made in paragraph such to such are of the foregoing plaint, including the cause title, are true to my knowledge and derived from record, and those contained in paragraph such and such are my humble submission. So unlike what is provided in the statement of truth under the Commercial Courts Act, this is not being verified in the manner as it
There
is
is a
so.
statement of truth.
Lordship, the statement of truth must be with your lordship. Your lordship, it is my contention in my application that I have not been served. I have been served with the plaint, your lordship. I am not denying that I have not been served with the plaint.
Statement of truth is not served.
No, that is my specific contention, your lordship.
That's why. So, say like
Lordship,
that.
I have, your lordship, plaint has been served. The affidavits as required under the Commercial Courts Act has not been served. Now, your lordship, until and unless the affidavits as required under the Commercial Courts Act, this is the case I am running, is served upon me, your lordship, that the service made is ineffective and or incomplete. And therefore, your lordship, it amounts to non-service and my time to file the written statement does not start. Lordship, I say this on 2 counts, your lordship. In fact, 1, your lordship, I'll club it into 1. Is that until and unless I know, well, your lordship, may I just show 2 documents from the plaint to satisfy your lordship? Kindly takes up page 30209.
Plaint?
Of the plaint, your lordship.
209.
Now, your lordship, these are letters inter party to which I am not a addressee or the author.
209.
209 and 210.
Yes.
Plaint. Your lordship will find this is written by one Goldsmith to one James Glendy, and CC is to Deepak Bhargav and Rajni Bhargav.
Who is the James?
James Glendy is the plaintiff, your lordship.
James Glendy, plaintiff. To who has written this letter?
This has been written by Goldsmith, your lordship, who is
D3.
D3.
You are not appearing for
No,
D3.
your lordship, I am for 1 and 2.
So what is the contention now?
Now, your lordship, this is a document inter party to other parties to which I am neither the author nor an addressee.
Sure.
So, Your Lordship, until and unless I have been served, because Your Lordship, Order 11 is very strict that everything in the power and possession. Lordship, the statement of truth.
Correct. That is the only
Lordship,
thing.
the statement of truth. Lordship, I am unable. Lordship, I know I am running on thin ice. But Your Lordship, may kindly appreciate from a legal point of view. And I will try and satisfy Your Lordship that even apart from this case, Your Lordship, there must be a prospective direction at least on the department to hear on serve these affidavits along with the plaintiff. Lordship will not take this as an individual matter. I am aware that I am on thin ice because I have not been able to file my written statement.
Correct. No problem.
No, Your Lordship, until and unless I am being served with a statement
Okay,
of
that is your simple case. The statement of truth has not been given, so that is not in compliance with the order 6 rule
because of
15A
which
and the
because
order
of which
11
I am not.
order 11 of the amended rules of the amended act of the commercial court act. So it cannot be said it is a complete service of the writ of summons.
Writ of summons, and therefore
That's why you are entitled to get the extension of time unless the total copy has not been served to you.
Lordship,
This is your contention.
Lordship, just two more lines. Lordship, in their opposition, Your Lordship kindly takes up paragraph 8. Page 17.
Opposition.
Yes, Your Lordship. They filed an opposition in 3 volumes. My application was for 2 pages.
Page.
Page 17, volume 1, paragraph 8.
Yes.
Lordship, at the bottom, it starts from 10 lines from the bottom, Your Lordship. It starts from the middle of the paragraph. I state that the records of the case
Yes.
clearly show that all documents, including the statement of truth as per Order 11, Rule 15A and the affidavit under Order 11, Rule 1 of the code were duly filed by the plaintiff on 14th of August 2024. So he says that he's filed it. And it must be deemed that all documents along with a copy of the plaint was duly served upon the defendant numbers 1 and 2 by the sheriff of this honorable court. So he's saying that I have done my job. I have filed it. And it is to be deemed that these affidavits have been served upon me. And for this, Your Lordship, he relies on page 354, volume 3, Your Lordship. To show that it has been served. Now, if Your Lordship, 354, Your Lordship.
Yes.
Now, Your Lordship will see this is the report of the service report. Now, kindly takes the column of material to be served. That states 1 duplicate copy of the writ of summons along with copy of the plaint. It does not talk about the affidavits accompanying the plaint in terms of the Commercial Codes Act. Now, my learned friend is trying to make out a case that it is deemed to have been served. Your Lordship, it is my case. I have got the plaint, which is stated in the service report, but not the affidavits in terms of the Commercial Codes Act. Lordship, I've got.
Who has affirmed this affidavit?
Lord, the affidavit.
Your affidavit in opposition. Who has affirmed this?
Lord, there are 2 persons. Lord, Lordship will find.
This one.
Kingshuk Majumdar.
Lord, Kingshuk Majumdar. Lord, that is on
Kingshuk
behalf
Majumdar.
of. Yes, Lord.
So, when you file the statement of truth,
Lord, the statement of truth, Lord, that's part of my application. If my Lord comes to, Lord, kindly comes to page 106.
See, statement of truth.
Yes. Lord, this is possibly for some of the defendant. Lord, this is not for the plaintiff. Lord, this is possibly come up with the written statement because this is not my instructing advocate.
Give that. Depend number 3. D3 का इसको रखो. You are appearing for 1.
1 and 2, Your Lordship. Your Lordship, the simple case made out is I've been served with the plaint, but not the affidavits accompanying the plaint. And therefore, Your Lordship.
Let me see. From the statement of truth. प्लेंटिफ पढ़ो ना अंदर पढ़ो ना Yes.
Your Lordship, until and unless that is given to me, I am not in a position to file my written statement. And Your Lordship, if Your Lordship keeps this matter aside, Lordship, subject to what falls from Your Lordship as an officer of this court, Lordship, in any event, there should be a prospective direction on the departments in all commercial suits to serve a copy of the affidavits along with the plaint. Because till now, and before the Commercial Courts Act came, Lordship, the plaint was enough. After the Commercial Courts Act, these affidavits become necessary.
No, it is
to be.
See, since I have taken the determination of the commercial court, and that's why unless at the time of scrutiny of the plaint,
Lordship,
it is coming to me
Lordship,
with the report of the master, because the statement of truth is to be corrected, then I am giving a direction for a reaffirmation.
Lordship, that I bow down to Your Lordship, that restricts to the role of the plaintiff to file it. But now, Your Lordship, thereon,
service by
Lordship, that Your Lordship, that is my small argument that I want to make. Lordship, this is my humble subject to what falls from Your Lordship and my learned friend. Irrespective of this case, Your Lordship, there should be a prospective direction.
Lord, I'll straight away, my Lord, bring Your Lordship to, Lord, the prayers which have been made in the application. Lord, kindly sees what is the nature of this application. Lord, if Your Lordship, if my Lords have, Lord, page 3 of the, Lord, master summons. Lord, my learned friend has fairly submitted that he's praying for prayer A.
master summon का इसका
And B.
Directing produce of the copy of the statement of truth.
Lord, I'm concerned. Lord, prayer A and B, my learned friend has spoken of. Lord, prayer C is what I'm concerned with. Lord, this is really in the nature of an application under Order 5, Rule 1. Lord, kindly allow me to give you a few dates as to when my learned friend has approached. Lord, Lordship has seen the date on which this has been filed. Lord, 11th March 2025. Lord, now I'll take Your Lordship through the case details. If Your Lordship kindly comes to page 23 of my opposition as to what has transpired. Lord, because I need to show to Your Lordship when the suit was filed. Lord, Lordship has, Lord, volume 1 for now, Lord.
Yes.
Lord, kindly comes to page 23. Lord, Lordship will find from there, Lord, right at the bottom, Lord, Lord, the table which is there. Lord, plaint was presented on 19th August 20. Lord, Lordship has it, Lord. Lord, 19th August 2024.
23.
Lord, page 23 of my opposition, volume 1. Lord, Lordship will find the plaint was presented on 19th August 2024.
Yes.
Lord, thereafter, Lordship will also find, Lord, the very next page, Lord, Lordship will find there is a column, page 24, objection. Lord, Lordship has it, Lord.
Yes.
Lord, Lordship will find from here, my Lord, scrutiny was completed on 14th August 2024, and Lordships will mark, Lord, all objections are complied.
Where we are?
Lord, 24, Lord, right in the middle, Lord, the middle column, middle table.
Affidavit order 11 Kingfisher Majumdar Sanjit Singh.
Lord, page 24.
Which column, which serial number?
Lord, I am talking about serial number 1 of the middle table. Lord, scrutiny date. It starts with scrutiny date. Lord, page 24, Lordship has of my opposition.
Page 24 is there.
Lord, it starts with objection. Lord, right after
yes,
the
objection.
Lord, over there, Lordship will find that the objections are all complied with.
Correct.
Lord, thereafter, Lordship will find 14th August 2024. Lord, my instructing advocate's name is there, and just next to it, Lordship will find that what all has been filed. Lord, plaint with a copy of the Wakalatnama. Lord, the statement of truth affirmed by so and so, my Lord, because there are two, my Lord, persons who are affirming. My Lord, thereafter, Lordship will find, my Lord, The very next one, my lord, lordship will find affidavit under Order 11, Rule 1. My lord, that is one of the, my lord, I'll take your lordship through the pleadings which have been, my lord, made by my learned friend in support of his application. My lord, so what, my lord, my endeavor to show your lordship is that there was no, my lord, defect or no objection from the department, and my lord,
No, that is correct. That
yes,
he is not denying that it is not filed, it is not done. His only contention is that the statement of truth has not been served along with the plaint. That is his contention, and his contention is that if the statement of truth is the part of the plaint, if it has not been served, it is not good service. It is not good. That is the only. So now how the court can ascertain whether you have filed?
Yes.
Document you have filed, it is there. Because after the verification you have to.
Yes.
Otherwise your
No,
plaint
it won't go
cannot be.
through. It
Cannot be further proceeded.
Yes.
So you have filed. So how it can be ascertained whether it is served or not?
Lord, I appreciate, Lord, but the first question, since I started off with, Lord, Order 5, Rule 1, Lord, the time when my learned friend approaches your lordship, Lord, that has shown significance.
When you receive the writ of summons?
Lord, that, Lord, kindly comes to his application. I'll show from his application itself. Lord, kindly comes straight away to, Lord, page 4 of his application. Lord, my learned friend's application paragraph. Lord, kindly sees paragraph 2, page 4, paragraph 2.
Yes.
Lord, the defendant numbers.
September.
Yes, my lord. 14th September 2024. My lord, lordship will kindly marks the date. My lord, this is an admitted position that my learned friends have received the writ of summons from my instructing advocate on 14th September 2024. Also, my lord, kindly marks paragraph 4 thereof, page 4.
Yes.
My lord, from the sheriff. My lord, that is a little belated. My lord, 4th August 2024 is when my learned friend receives it. My lord, taking it from there, my lord, if, my lord, my learned friend had approached your lordships under the provisions of Order 5, Rule 1, my lord, within 30 days, my lord, he could have, my lord, easily given the reason that this is the reason why I could not, my lord, will kindly extend the date, and that is the prayer I had shown to your lordship, prayer C.
Yes.
He's asked for 30 days time from the date on which, my lord, so, my lord, the timelines assume significance. We are dealing with a commercial suit. My lord, it is not the case, my lord, earlier, my lord, it was, my lord, the case that the plaintiff, being dominus litis, has to be vigilant. My lord, but there's been my lord, the act has undergone a sea change with the, my lord, coming into effect of the Commercial Courts Act, wherein, my lord, a duty is cast upon the defendant also to be diligent and vigilant. My lord, in that, my lord, regard, my lord, kindly now sees the documents which I have annexed to show that my learned friend was very well aware that there is a suit which has been filed or which is going to be filed. My lord, kindly sees, because, my lord, lordship will appreciate, my lord, this was, my lord, preceded by a proceeding before the Mediation Commission.
Correct. See, that is not in dispute. Only the dispute with regard to the state of truth.
Yes.
Correct. He knows, and he admitted that the writ of summons was served in
Yes,
September and October. 2 dates is given, and that is proved by the sheriff's report.
Yes.
So only the question is whether now he is telling that now he has taken the plea of Order 5.
Yes, my lord. Order 5 read with Order 8. I shall come to that.
Correct. So he has not filed any application immediately.
My lord, and the timeline, my lord, I'll just give those dates, my lord.
Yes.
My lord, 3rd August 2024. I'm sorry, my lord. According to us, my lord, the time for him to file, my lord, the application under Order 5, Rule 1, my lord, which is mandatory in nature, that according to us, my lord, since he says that he was served on 14th September 2024, that expires according to us on 13th October 2024. Wherein, my lord, in my most respectful submission, my learned friends ought to have come with by way of an application, Lord, 13th October 2024. Lord, taking that same date, Lord, the period of 120 days. I'm sorry, Lord.
Yes, yes.
Lord, the period of 120 days, Lord, that, Lord, expired on 12th February 2025.
Yes.
Lord, similarly, Lord, if we take the, Lord, service from the sheriff, Lord, which is of 4th October 2024, Lordship will find that the time period for filing the application under Order 5, Rule 1, Lord, that has expired on 3rd November 2024. Lord, and the period of 120 days, going by that, Lord, notice, Lord, service of the writ of summons and the plaint by the sheriff, Lord, that expires on 3rd March 2025. Lord, my learned friends approach your lordships with this application on 11th March 2025. My lord, and your lordships, my lord, and I'll take correction from my learned friend on this regard. My lord, there is not one, my lord, reason or an explanation which has been given by my learned friend as to why and what prevented him from approaching your lordships at a time prior to that. My lord kindly sees now, my lord, the date on which, my lord, so my lord, my submission is this, my lord, for a period of 5 months from the date on which the writ of summons has been served, my lord, 180 days, my learned friend did not utter a word. My lord, not one letter.
Yes.
My lord, and my lord, I will give the example of this particular suit itself.
Yes.
My lord, there are several defendants in this suit.
Yes.
My lord, one of the defendants, my lord, I think it is, my lord, the defendant number. My lord, the defendant number 3. My lord, the defendant number 3 had come up, my lord, by way of an application which was, my lord, GA number 3 of 2025. My lord will kindly take this order of May 1, 2025. My lord, similar submission. Of course, my lord, the dispute was not that, my lord, the affidavit under order 11 has not been served, or my lord, the statement of truth has not been served, but the fact that there are certain copies which are illegible, as a result whereof, my lord, they were unable to file their written statement. My lord, so your lordships had extended the time because there was a reason which was furnished by the defendant number 3 as to what prevented them from, my lord, adhering to the, my lord, mandatory timelines of the Commercial Courts Act, and your lordship were pleased to allow that, my lord, upon service. My lord, they had approached your lordships prior to the expiration of 120 days. My lord,
Yes.
so, my lord, my submission is this. My lord, any application which my learned friend had to take out had to, my lord, conform to the, my lord, requirements of Order 5, Rule 1, and, my lord, Order 8, Rule 1. My lord, and the second contention, and my lord, I'll leave it at that, my lord, is that, my lord, these, my lord,
Yes, yes, yes.
my lord, my lord, these affidavits, my lord, and it has been held by our courts, my lord, your lordships, wherein these are curable defects. These are not something on the basis of which my learned friend can contend that because this has not been served upon me, this is not good service. My lord, kindly permit me, my lord, to show your lordship only one decision in this, my lord, by our court, my lord, 2021 SCC Online, Calcutta, 2457. My lord, I'll be relying on, my lord, paragraphs 1, 2, I know, 1, 2, 13, 15, and 17. My lord, this was, of course, my lord, a case wherein, my lord, the written statement, my lord, the affidavits were not there. My lord, and kindly, my lord, I'll just trouble your lordship with 3 paragraphs, my lord. The facts are there, my lord, before your lordships in paragraph 1 itself. My lord, I'll read, my lord, with your lordship's kind permission. My lord,
Yes,
may I?
yes, yes.
The issue which falls for consideration is whether a statement of truth in a written statement in a commercial suit is a mandatory requirement under the Commercial Courts Act 2015, and whether the absence thereof warrants striking out of the defense in the suit. My lord, I am trying to equate, my lord, written statement with a plaint. My lord, because, my lord, I believe my learned friend's contention is this, that till such time that the plaint along with these documents are not served, he is unable to file. My lord, kindly comes to, my lord, page 2, my lord, paragraph 2, plaintiff contends that a written statement without a statement of truth is an incurable defect, while the defendant urges otherwise. The difference of view centers on the construction of Order 6, Rule 15A as amended by the Commercial Courts Act. My lord, I'll not trouble your lordship with the facts. My lord, kindly comes to straight away, my lord, paragraph 13. My lord, over here, my lord, there was a, my lord, divergence of views because the Delhi High Court, my lord, said that this is a, my lord, non-curable defect. It's mandatory. My lord, but the Bombay High Court and a coordinate bench of our court, my lord, in a civil revision petition held otherwise. My lord, kindly reads, my lord, paragraph 13. Single bench of the Delhi High Court in Shiv Ratna paper versus so-and-so disallowed reliance on the written statement filed by the defendant under Order 6, Rule 15, so-and-so, on the ground that the defendant had not filed a statement of truth in support of its pleading. On the other hand, a division bench of the Bombay High Court in higher so-and-so held that the defect in pleadings under Order 6, Rule 15A4 is a curable defect. My lord, I'm only, my lord, pausing here for a moment. I'm only, my lord, relying on this because my learned friend has shown to your lordship, my lord, the provisions of, my lord, the Commercial Courts Act and, my lord, the appendix. My lord, now, my lord, kindly looks at paragraph 15. Coordinate bench of the Calcutta High Court in CO number so-and-so followed the Bombay High Court view in higher so-and-so to hold that the consequence of not filing a statement of truth in the prescribed form would not debar a party from proceeding with the pleading if such defect is cured. counsel for the plaintiff seeks that the said decision be held per incurium, since the single bench of this court did not consider the decision of so and so. And Milord Ambal Al Sarabhai is referred to, Milord, because Milord, the strict timelines and Milord, the mandatory requirements of the Commercial Courts Act. Milord, kindly now comes to Milord, I won't trouble your lordship with paragraph 16. Milord, paragraph 17 is what the ratio is, Milord. Above discussion may be seen in addition to the general inclination of a court to treat procedural lapses with kindness, unless a party disentitles itself to such benevolence by reason of its conduct. Milord, kindly marks this, Milord. By reason of its conduct or by operation of law, without taking the avowed object of quick resolution of commercial disputes away from the 2015 Act, rules of procedure cannot be given precedence in a manner so as to defeat the substantive rights of the parties unless specifically provided by law. In the present case, sub-rule 5 of Order 6, Rule 15 can be pressed into service in aid of the defendant. If a purposive interpretation is given to the various provisions contained therein, the discretion conferred on a court in the matter of striking out of pleading, which is not verified, cannot be seen as a speed breaker in the momentum of the Act. Milord, so, Milord, twofold submission before your lordship. Milord, that this is not a mandatory requirement as my learned friend seeks to put it. And secondly, Milord, when your lordships are deciding, Milord, issues, Milord, where your lordship's discretion is involved, and Milord, I say this, Milord, because, Milord, Order 5 also, Milord, confers, Milord, a degree of discretion to your lordships, and the language, Milord, may I trouble your lordship only once with Order, Milord, Order 5, Rule 1, Milord. Milord, I'll read. Lordship need not trouble. Milord, I'll read for your lordship's kind consideration. Milord, kindly sees, Milord, summons.
Yes.
When a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of service of summons on that defendant. Lord, now the proviso is what is significant, provided that no summons shall be issued when the defendant, Lord, the second proviso, provided further that where the defendant fails to file written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court, Lord, for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. Lord, so, my Lord, there is a discretion which has been vested with your lordship, my Lord, which your lordships will exercise, my Lord, upon, my Lord, and this is my submission before your lordship, upon sufficient cause being shown by my learned friend. My Lord, and my Lord, again, my Lord, I'll take correction in this regard. My Lord, there is no averment as to what prevented my learned friend from approaching your lordship within the 30 days. Or, my Lord, I would have even understood if my learned friend had approached your lordships within the 120-day period. My Lord, that has not been done. My Lord, losing sight of the fact that, my Lord, that Order 5, Rule 1, my Lord, the proviso thereto is mandatory in nature.
Yes.
My Lord, and my Lord, kindly sees, my Lord, there's not one letter which has been issued, my Lord, like your lordship has seen in the other matter, my Lord, the defendant number 3. My Lord, they had written to us, my Lord, we had given to them. My Lord, similarly, my learned friend could have easily come before your lordship and, my Lord, said that I have written, but they have not. My Lord, next, my Lord. My Lord, and my Lord, also, my Lord, notice of the suit. My Lord, again, my Lord, my submission is completely based on, my Lord, the defendant being diligent and vigilant. My Lord, kindly come straight away, my Lord, to page 31 of my opposition. My Lord, page 31, lordship will find in the same volume, my Lord, volume 1.
Yes.
Oh, okay. My Lord, kindly sees, my Lord, this is the non-starter report. My Lord, the reason why I'm showing your lordship is, my Lord, preceding this, my Lord, there are several notices which have been issued. My Lord, that starts, my Lord, from page 27 onwards. My Lord, kindly sees. My Lord, this is the member secretary writing. My Lord, lordship will find. My Lord, page 27 of my opposition. Page 27. My Lord, kindly sees. My Lord, this is the member secretary. My Lord, PLM writing, my Lord, to my Lord, all the, my Lord, the defendants and the plaintiff, my Lord, about the notice of the hearing. My Lord, kindly reads, my Lord, your lordship will find the name of Jagriti Trade Services.
Yes.
My Lord, 2 Jagriti Trade Services on the right.
Yes.
My Lord, a notice of this commercial suit is given on 19 June 2024.
Yes.
My lord, a man exercising ordinary diligence would necessarily want to find out what is this matter about. My lord, would make certain, my lord, inquiries, which has not been done. My lord, thereafter there is a second notice. Lordship will find, my lord, that is at page.
So what you want to say from this
My lord,
document?
the only thing, my lord, I was urging before your lordship is that, my lord, my learned friend is aware of the matter. He's aware that there's a mediation which has been initiated. He's aware that a suit has been filed. My learned friend also does not say that he's not been filed with us with the, my lord, the plaint and the papers there. My lord, he's been served only the affidavit and the statement of truth. But he could have written, he does not do so. My lord, this is the, my lord, the only point which I have. My lord, apart from that, my lord, just one more thing, my lord. Yes. My lord, this is on notice. My lord, and secondly, regarding, my lord, diligence of the defendant, my lord, there is another, my lord, this blame, my lord, this allegation, my lord, I take it as an allegation upon the plaintiff because the allegation is level that I have not served. My lord, the allegation is also, my lord, on, my lord, the court, the officers not being able to serve them the statement of truth. My lord, kindly sees what is written in paragraph 4. My lord, kindly sees this, my lord. Paragraph 4, it is stated that the defendant numbers 1 and 2 also received the writ of summons from the sheriff of this honorable court, honor so and so. Even in such writ of summons served by the sheriff of this honorable court, no statement of truth nor any affidavit in terms of so and so was served. My lord, now, my lord, in that, my lord, kindly sees one more decision. My lord, this was again, my lord, this was again, my lord, arising out of, my lord, a commercial suit. My lord, I'm relying on, my lord, this is on the conduct of a defendant in a commercial suit, or, my lord, a party in a commercial suit. My lord, I'm relying upon 2025 SCC online, SC, page 910. My lord, this was a case, my lord, wherein an appeal was sought to be preferred before the High Court. My lord, that, my lord, was delayed. My lord, there was a delay in filing the appeal. My lord, so the party, the appellant stated that he was unable to file because, my lord, the department was not being able to give them a copy of the order. My lord, now in that light, my lord, kindly sees what the Supreme Court has held. My lord, I'm relying on paragraphs. My lord, this will be, my lord, I'll have to place certain paragraphs. My lord, paragraphs 1, 2, 4, 7, 10, 11, 15 to 17, 20 and 21. My lord, I'll only trouble your lordships with the facts first and 15 to 17. My lord, kindly sees second paragraph. Petition arises from a judgment and order passed by the High Court at so-and-so, dated so-and-so in commercial appeal number so-and-so, by which the High Court rejected the interim application number so-and-so filed by the petitioner here under section 5, thereby declined to condone the delay of 301 days in filing the main appeal. Lord, paragraph 4, in filing the statutory appeal, Lord, there was a delay of 301 days as noted above. In such circumstances, the petitioner herein prayed for condonation of delay. High Court declined to condone the delay on the ground that no sufficient cause was assigned by the petitioner for the purpose of condonation of delay. My lord, thereafter, my lord, kindly sees paragraph, my lord, 7, my lord, the objects of the Commercial Courts Act is set out. I'll not trouble your lordship with that. My lord, paragraph 10. We are afraid it is difficult for us to take the view that the provision referred to above is mandatory, my lord, of, my lord, the judgment, my lord, the judgment being supplied to, my lord, the appellant. It comes to this, that till the registry does not provide the copy of the judgment, though not demanded, my lord, this is very important. My lord,
Where from
my lord, paragraph 10, lordship has it?
10.
Yes, my lord. I'm sorry, my lord, I skipped, my lord, I'm sorry.
Yes.
Lord, paragraph 10, we are afraid it is difficult for us to take the view that the provision referred to above is mandatory. It comes to this, that till the registry does not provide the copy of the judgment, though not demanded, my lord, though not demanded is what is, my lord, I'm stressing on, the period of limitation would not commence from the date of pronouncement of the judgment. My lord, similar, my lord, case has been sought to be run by the defendant that till such time that the entire plaint along with all of this is not given to me, either by the, my lord, the plaintiff or the registry, he is not in a position to file. My lord, thereafter, Lord, paragraph 11, placing reliance on such and such, it has been contended by the appellant herein that where the rules themselves enjoin a duty of communicating any order or judgment that has been passed by a court or forum, then in such cases, period of limitation prescribed has to be computed from the date of such communication. Lord, paragraph 15, if your lordships are kind enough to come to me, Lord.
Yeah.
Similarly, we find that the reliance by the appellants on the decision of so-and-so is also misplaced. In the said case, this court, while considering section so-and-so of the Companies Act, held that the period of limitation prescribed therein would start running only from the date on which a copy of the order is made available to the person aggrieved. However, yet again, in the said case, the appellant therein had made some efforts. My lord, this is very important. However, yet again, in the said case, the appellants therein had made some efforts to procure a certified copy of the order to be assailed during the period of limitation. In the present case, we find that after the order in question came to be pronounced by the Commercial Court Ranchi, the appellants herein during the limitation period did not bother to even inquire as to why the said order was not made available. It was only 8 months after the pronouncement of the said order and almost 150 days after the pronouncement of the order, after the expiry of the limitation period, that the realization suddenly dawned upon the appellant herein to apply for the certified copy of the order. My lord, kindly sees, my lord, paragraph 17, one of the avowed objects of the provisions of the Commercial Courts Act, read with the amended provisions of the CPC applicable to the Commercial Courts Act, is to ensure that there is no unnecessarily delay in disposal of the commercial suit. Once specific timelines are fixed and there is a strict procedure provided in the Commercial Courts Act, parties are by statute put to notice. Lord, this is what I wish to draw your lordship's attention. Lord, the parties are put to notice by statute. Lord, and I again go back, Lord, the reason why I was showing your lordship, Lord, the mediation notice. Parties are put to parties are by statute put to notice that they have to very carefully contest the suits filed as commercial suits, and that failing to comply with statutory timelines and a strict procedure, certain adverse consequences may follow on account of lack of application by a contesting party.
Yes.
Lord, I'm sorry. Lord, paragraph 20 and 21, Lord, I'll not trouble your lordship. Lord, my Lord, endeavor is to, Lord, show your lordship what is the, Lord, object and intent, and the fact that the defendant, once there's a suit in the commercial division filed, he is by statute put to notice that he has to be diligent in his endeavors. Lord, in this case, lordship will not find even one. Lord, and if my learned friend again will correct me if I'm wrong, that he has not written a single letter to me so far asking me for it, and my learned friend has come directly before your lordship. Lord, the last thing, my lord, which I wish to draw your lordship's attention to is, my lord, the reply. My lord, the affidavit in reply which has been filed by my learned friend. It's a very short, my lord, affidavit which has been filed. A very short, my lord, affidavit will be possibly, my lord, 10, 5, 7 pages, my lord.
Affidavit in reply.
It's affirmed on 13th day, May 25, Lord, by Mr. Jagdish Sharda.
Yes.
Lord, please see, my lord, Lord, completely bare denials, and I have put my learned friend that why he has not written. Lord, kindly sees only one paragraph, 2 paragraphs, my lord, page 4, paragraph 3. My lord, right at the bottom, my lord, where my lord, it starts with, it is stated. My lord, lordship has it. My lord, 3 lines from the bottom at page 4. It is stated, Lord, may I read? Lord?
Yes, yes.
It is stated that from Annexure B, it will only be evident that the plaintiff had filed such affidavit with the Honorable High Court, but such fact does not go on to prove that such affidavits were actually served upon the defendant number 1 and 2. My lord, thereafter, my lord, just 5 lines from my lord, that paragraph, my lord, 6 lines. It is stated that the plaintiff has filed such affidavit with this honorable court does not go on. My lord, only one contention, and my lord, my specific case, which I have made out in my opposition, which is pleaded, is what prevented him from asking me. My lord, this is what I wanted to show your lordship. My lord, this is, my lord, I'll leave it to your lordship. My lord, these are my submission. I'm grateful.
It's a very short reply dealing with the judgments. If I cannot have any quarrel with my learned friend as to that my client has not written any letters asking for a copy of the statement of truth. To that, Your Lordship, I cannot improve upon the facts. Your Lordship will kindly take up the judgment of the Calcutta High Court, AI 2021 SEC Online, Calcutta 2457, Order of Justice Moshmi Bhattacharya. Your Lordship, this, in my respectful submission, Your Lordship will see paragraph 17. No doubt, it's a curable defect. This can be cured. But until it is cured, the time does not start to play.
Correct. Your case is not with this. Your
Lordship.
case is the return. This statement of truth is
I'm
not
not-
out. It is not a complete, so you will not.
Yes, Your Lordship. I'm not saying that the plane should be dismissed or something. Now, Your Lordship, with regard to the other judgment of 2025 SCC Online Supreme Court, Your Lordship, the difference in these facts and the one that is before Your Lordship is, in here, there was to be an application for certified copy. Here, a defendant does not even know that a suit has been filed until a writ of summons is served.
But here you have received in September and October.
Lordship.
Go by the October.
Lordship.
October. Correct. You have not made any representation, not you have received. And even you filed the application in February, March. 12th March. That is also after the
After 120 days. So I cannot improve upon the facts, Your Lordship. I bow down to that. But Your Lordship will kindly appreciate this. Your Lordship, today, whether the department, both of us have argued, but today, actually, whether the department has served this upon or is actually serving these statements upon the defendants can only be ascertained by Your Lordship.
That I will.
Your Lordship may kindly call for a report.
I will reflect my the thing in the judgment.
Lordship,
But I don't know what result you will get.
Lordship, that is obviously Your Lordship. I have put the facts. So it's for Your Lordship. Either way, Lordship, it's only for the department which can show whether I am not denying that they filed, but whether it has been served is for Your Lordships to find out by calling for a report from the
Why you
department.
slept over more than 120 days?
Lordship, I have already stated. Grateful, Lordship. Those are my submissions.
Grateful, my lord, to your lordship.
Sensation suffering for the plaintiff, sensation suffering for the defendant. Defendant has filed an application being GA Com 2 of 2025, praying for supply of statement of truth and extension of time to file written statement. Extension of time to file written. Extension to file.
Your Lordship, yes. That's my prayer.
Written statement. Hearing concluded. CAV.
So grateful to your lordship.
Time dictation दे दे 3 बजे शुरू yes रिलीज वाला कॉल करो फिर ये दे yes
Well, this should be transferred to the
record an order so and suffering for the plaintiff. This court find that the suit is connected with the intellectual property matter. Thus, this court is not having determination. Accordingly, CS Com 19 of 2025 is released from the list of this court. This court find that the department has not assigned the IP case number. According, department is directed to assign the IP case number and to place before the appropriate court.
In this,
ये क्यों आया? आइटम नंबर 1 क्या है? ये कौन सा? 2 yes. Yes. You are for the plaintiff.
But spam for the defend number 1 and 4.
Defend number 1 and 4.
Lordship.
Yes.
Here for the plaintiff. Minute.
Here for the plaintiff. Yes.
Wait.
Oh, decree holder.
Yes,
decree
minute.
holder. Ah, sorry.
I'm sorry, Milord. Here for the decree holder.
You for the
Yes,
judgment.
Milord, they have Milord, given us
They are
that,
supposed to hand.
yes, they are supposed to hand over 3 checks of a total amount of 80 lakhs. Milord, the decree holder has agreed to Milord, to take that as for satisfaction of the decree. It was much more, but only thing is, Milord, and we have also Milord given a letter saying that upon Milord encashment of this amount, we will withdraw this and we will deem it to be satisfaction of the decree.
Total, what was the amount?
Total was much more, Milord, above 1 crore.
Above 1 crore, your Lordship, yes,
Plus-
parties are agreeing to settle it at 80.
Yes.
As per the
Decree was 1 crore and above.
1 crore.
Yes.
You mean 1 crore and along with interest.
Yes, along with interest. We have agreed for 80 lakhs, but till date, Milord, we have not received, so it
I
is
am
not
recording
in cash.
it.
Yes.
You are agreed for the 80 lakhs
Yes.
and he has entered to a check.
Lord, I have an undertaking
Check
from
or
the
check
decree
or
holder.
Check, your Lordship. Account page
check
check.
of so and so
Yes.
so and so.
Lord, I have an undertaking from the decree holder also, Milord. I hand over.
Copy served on me, Lordship.
So I am keeping it pending. When what is the last date is? Total
These are
amount?
all dated 20th of June.
That is over.
Lordship,
now
so
we can
the
present
validity
it.
of the check is for 3 months.
Now we can present it. So, Milord, no,
So I'm handing it over to my learned friend.
22nd July.
So, have you taken instruction? How whether it will be
22nd July.
honored?
Yes, your Lordship, that's my instruction.
Milord, Lordship has already kept it returnable on 22nd of July. May it remain on that date?
Only I am recording.
Yes,
This.
I'm grateful. Lordship will keep it as to be mentioned, Milord, because
Mention it, I will take.
Very
So and so appearing for the decree holder. So and so appearing for the judgment debtor. The decree holder has filed the present execution proceeding for recovery of an amount of ₹1 crore along with the interest in terms of the judgment and decree passed by this court. What is the date of the decree?
Lordship, the decree is dated 23rd of August 2023.
23rd August 2023. Okay. Full stop. During the pendency of the execution proceeding, it is settled between the parties that the judgment debtor will pay the total amount of rupees 80 lakhs and the decree holder is also ready to accept the said proposal. Accordingly, the judgment debtor has issued 3 checks of rupees 25 lakhs, 30 lakhs and 25 lakhs of Bank of Baroda.
all
BT
dated 20th of
Bank of Baroda, BT Road, Kolkata, dated 20th June 2025. Full stop. 2025. Full stop. The judgment decree holder also given an undertaking that if the check issued by the judgment debtor is encashed, the judgment debtor will not proceed this execution proceeding further. Full stop. In view of the above, let the case is adjourned. In view of the above, let the case adjourn. List the matter on 22nd of July 2025 under the heading to be mentioned. The undertaking submitted by the judgment decree holder along with the copy of the check be kept with the record.
Grateful, Lordship. Photocopies of the check.
Photocopy of the check. Copy.
They will not be able to encash.
Grateful, Lordship.
Check has been handed over.
I recorded.
So the 3 p.m. matter would your Lordship not fix it? 3 It was mentioned in the morning. ये 3 p.m. नहीं था हम लोग. नहीं, हम adjourn.
Somebody has mentioned it.
No, it was mentioned in the morning. Your Lordship had said your Lordship will.
You want date?
Yeah, any whatever date, not after, whenever your Lordship returns.
3 PM कौन सा है?
Not item 11. Milord.
Item 11.
The section 34. Not.
अच्छा that. Mr. Ghosh, na? Who is appearing?
Mr. Anuj Singh was appearing. Milord. Anuj Singh. was appearing.
Record and order. Item number 11. उसमें ऑर्डर किया था नहीं किया ना आइटम नंबर 11 में डेट दिया था so and so appearing for the petitioner so and so appearing for the respondent as per the as per prayer made by the counsel for the petition. Mr. Singh is for the respondent.
He was for the petitioner. He was for the petitioner. I'm for the
counsel for the petition. Prays for time. Accordingly, case adjourned. Let the matter appear on 8th of August at 12:30.
I'm good.
Next.
My lord, in fact, my lord, if your lordship looks at your lordship's order while granting leave under 12A, my lord, that records everything. My lord, your lordship was extensively pleased to record that. My lord, there was a point.
Because, dealing with the revocation of the leave, then
once again. No, but now in view of the new judgments, my lord, there is no scope of revocation. It is the discretion of the judge. If the judge has exercised his discretion and given leave, you have to accept it. So where is the scope of, this is not like clause 12 that I can come and say that this part is outside, this part is, so I ask for revocation. Even, my lord, in one of our matters which went to the Supreme Court, my lord, the leave was revoked by Justice Sanjeev Banerjee, saying that there is a forum selection clause, leave is revoked, part cause of action arose in Bangalore, revoked. Appeal lost. Went to the Supreme Court, that became a reported judgment, which is Isha Distributors versus Aditya Birla Nuvo. Supreme Court said that nothing doing. If the plaintiff has made out a case in the plaint that no part of the cause of action has arisen within the jurisdiction where the forum selection clause is, then, my lord, the court has to proceed on the basis of the averments made in the plaint. Take that point in the written statement.
No, that's why I at the time of giving the leave, I recording the findings. So that
absolutely. My lord, here is a case, my lord. My lord, a contract issued, my lord, by the defendant. I was executing the contract. My lord, the work order, which is there, is at page 20.
Yes.
20 of the interlocutory application. My lord, there is no dispute, no issue regarding the contract now. The contract required me to complete the work within 540 days.
Correct.
Which is there at page 20, the second paragraph. Now, the 520 days, my lord, ought to have expired, or in fact, now it has expired on the 10th of February 2025. Now, my lord, this is a project, my lord, for augmentation of Henry's Island. It's a fisheries project. So basically, what I have to do is, I'm in the middle of nowhere. It's basically the receded sea which is receded, and it has now become a barren land. It is in the Sagar Islands where the Ganga Sagar Mela takes place. So it's a project by the government. So the entire thing has to be excavated, made into a pond, embankment, road, 2 buildings where the fishermen coves will be there. So it's a fishery project. Now, in order to reach there, but I have to go through one public road which is controlled by the Ganga Sagar Development Authority. Well, because before Ganga Sagar Mela, road was being constructed. So you could not go there. Then the Ganga Sagar Mela started. Because of the Mela, you can't go there, because it's only the devotees and the pilgrims. So this gave rise to delay. They accepted this. Now, my lord, when I say they accepted this, my lord, I'll show your lordship the extension, because they gave us the extension based on that. If your lordship will kindly take the extension that was given to them at page 25. My lord, kindly see the last paragraph of page 25. I mean, last para, yes, my lord.
Request for extension up to 31st of March.
My lord, the reason kindly consider is granted considering
Ganga Sagar Mela.
Delay due to Ganga Sagar Mela.
Yes.
Now, Ganga Sagar Mela is not in my hand. Now, my lord, what happens is, my lord, kindly straight away come to, my lord, I am not on the fact that my bills were pending. So those are other issues that will be decided in the suit. My lord, kindly come to page 28. Only for the purpose of limited for my interim order. Just kindly come to page 28. My lord, this is a letter written by.
So this is again 31st of May.
Yes, my lord. Kindly take the date of the letter. 19th of May.
Correct.
So below here it says, this is to bring to your notice that the date of completion of work was 31st of March and the set time has already, so 31st was March was the extended period. It ended in February. So they had given an extension on 31st of March. Thereafter, kindly take the second paragraph. Extension of time for completion of the said work was granted up to 31st of March without prejudice to the right of the government to recover liquidated damages in accordance with the provision of clause 2 of the agreement dated 4th December. Under the above circumstances as per clause 2 of the agreement dated 31st of March, you have rendered yourself liable to pay 2% of the tendered amount of the work arrived for each month of delay to be computed on per day basis as compensation for delay of work. The said amount of compensation is hereby levied on you, and it is for the period from 1st April to 31st May, 2 months, at the rate of such and such. Then, my lord, the last sentence. The tender will remain valid up to 31st of May 2025 for the interest of public service. Public service. Very good. So then, my lord, I give my reply. Let's proceed on the basis that whatever I said in the reply is incorrect.
Yes.
Let's proceed on the basis of that. Now, my lord, we will kindly come to page 31.
Yes.
Now, if you have said that the tender time period will stand closed till 31st of May, so then that was the end of the time period. Then, my lord, kindly have a look at the letter of 4th of June after 31st of May. In reference to the subject cited above, this is to inform you that till date you have not expedited the work. So on 4th of June, you are writing that till date I have not expedited. So that means this is a unequivocal admission of continuation of the tender.
Yes.
In proportion to the time. Now you are hereby directed to attend the meeting regarding the aforesaid work to be held at such and such on 10th of June. Now, my lord, 10th of June, I go to the meeting. My lord, kindly take paragraph 29 months at page 11.
Yes.
My lord, this is what happened in the meeting. Para 29.
Yes.
I was there. My director was there. Inquired that, my lord, that there's a typographical error.
Yes.
Now, my lord, kindly take para 30. This is my cause of action. Why the suit? So you tell me, my lord, I asked for 3 months. You may give me 1.5 months, 1 month, whatever. So you have waived your right in terms of the notice of 19th of May by calling me once again to work. So now, my lord, what I'm asking for, my lord, my lord, what I'm asking for, not to give any effect or further effect to this letter of 19th of May. That's all. Because I cannot ask for without notice to them anything else right now. But I'm conscious of that. But this is all that I'm asking for now. Pre B. In any event, 19th of May, you have waived your right. So what they will do is, well, I'll tell you, Lordship, what is happening. I am a infrastructure development contractor. I do contract all over the country. In fact, for this particular undertaking, I am doing several other work. So once they take coercive step, my lord, then all my tender process across the country, I have to declare.
Whether you are still continuing the work.
Yeah, so this is what happened, my lord, in June.
31st May, it was extended. Then you have been called for the
meeting. So
Meeting
discussion was how much time will you require? I say 3 months. They say I can't give you more than 1 month. Then they said I will let you know. The moment they say let you know, instead of letting me know, now they're giving inspection to other agencies. So now that means what? If you're giving inspection to other agencies, that means
even though if it is given, if it's going to give this other agency, the process is to be followed.
Absolutely, I don't mind. So don't take steps under 19th of May. That's all that I'm saying. You don't take any coercive steps against me on 19th of May because you have waived your right under 19th May. I am not saying, Malat, since they say it is in public interest, I have a prayer to allow me to continue the work. So, but I cannot ask for the prayer without their presence.
Correct.
I'm conscious of that. So what I'm asking for is, my lord, if your lordship will see prayer B of my injunction application, from restraining them from giving any effect or further effect or taking any steps or further steps in terms of the communication of 19th May.
Correct.
That's all.
So 19th May, it will up till 31st of May 2025. For
Correct.
the
And then the coercive steps, because here they have imposed liquidated damages on me. That is a money recovery. So the coercive step that they will take against me. Well, dear lordship can clarify that no coercive steps can be taken in terms of 19th May for a limited period.
But you accepted that 31st of May, that letter 19th May 2025, you accepted that you continue with
Kindly
the
take the next page. Next page, 22nd of May. I have disputed everything in the 19th May letter. My response went immediately on 22nd of May. Next page, 29. I said that the entire delay is attributable to you. And how did you impose liquidated damages? Of course, that will be final decision. That will be in the trial of the suit. May I take your lordship's kind leave, my lord? Deeply obliged.
Suffering for the plaintiff.
My lord, may I hand over the notice of motion? Copy has to be handed over.
Plaintiff has filed the present application paying for ad interim injunction. Full stop. A work order was issued in favor of the plaintiff by a letter dated 31st of July 2023 for augmentation of Henry's Island fisheries, page 20. Augmentation of Henry's Island fisheries project, sector B, district 24 Pargana. ठीक है? Full stop. As per the work order, the time of completion is for 540 days with effect from 1st August 2023. Full stop. 2023. That is up till 10th of February 2025. 2025. Full stop. By a letter dated 19th May 2025, the defendant has stated that the tender remain valid up to 31st of May 2025, and in the said letter, some penalty has been imposed upon the plaintiff. Subsequent to the letter dated 19th May 2025, wherein the tender was extended, the work was the time to complete the work is extended till 31st of May 2025, by a letter dated 4th of June 2025, the defendant had issued a letter directing the petitioner plaintiff to attend the meeting on 10th of June 2025 at 2 p.m. Counsel for the petitioner plaintiff submitted as per the letter dated 4th of June 2025, the plaintiff had attended the meeting and the plaintiff has requested he may be granted 3 months time for completion of the work. But the defendants have informed that they will extend it only 1 month. Subsequently, again the plaintiff has requested for extension of 3 months for completion of the work, but no decision has been taken. Now the plaintiff came to know, instead of extending the period for completion of the work, the defendants are trying to award the remaining work to some third party, as third party are visiting the site. Full stop. Counsel for the plaintiff submit that in the extension letter dated 19th May 2025, the defendant themselves have admitted that in the letter dated 21st of February 2025, the defendants have admitted that the extension for complete the work is considered due to Ganga Sagar Mela of 2025. Counsel for the plaintiff submit that it is the admission that there is no delay on the part of the plaintiff to complete the work, but the plaintiff is still ready and willing to complete the work within 3 months. But instead of taking any decision, the defendants are trying to allot them to give the said work to some third party. Counsel for the plaintiff submit that by a letter dated 19th May 2025, it is informed to the plaintiff that it was by a letter dated 19th May 2025, it was informed to the plaintiff that the plaintiff is liable to pay 2% of tendered amount of the work arrived for each month of delay to be computed on per day basis as compensation for delay of the work. In the said letter, it is also mentioned that the said amount of compensation is hereby levied on the plaintiff for a period from 1st April 2025 to 31st of May 2025, that is for 2 months, at the rate of rupees 11,288.97 per day. Counsel for the plaintiff submit that the plaintiff is ready to complete the work. Plaintiff has attended the meeting, and once the defendants have also extended the period for complete the work, now without taking the decision, the defendants are trying to allot the said work to some third party, and the third party is visiting the site. And on the other hand, the defendants have also imposed penalty upon the plaintiff. Counsel for the plaintiff submit that unless the decision is taken by the defendants for extension of time, the penalty imposed by a letter dated 19th May 2025 may be stayed. Had the learned counsel for the plaintiff peruse the materials on record. The work order was issued on 31st of July 2023 for a further with the condition that the work is to be completed within 540 days. The time to complete the work has been expired on 10th of February 2025, but the defendants have extended the time and the validity of the agreement till 31st of May 2025. Even after the defendants have issued the notice to the plaintiff to attend the meeting on 10th of June, on 10th of June 2025, accordingly, the plaintiff has attended the meeting and requested the defendants for extension of time for 3 months for completion of the work, but no decision has been taken. Now, the plaintiff has made out a case that the defendants, instead of extending the time, are trying to allocate time to allot the said work and the remaining work to some third party, and third party is visiting the site. The plaintiff is also agreed with the letter dated 19th May 2025, wherein some penalty has been imposed upon the plaintiff. Considering the above, this court finds that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. This could also find that at this stage an ad interim order is not granted, the plaintiff will suffer irreparable loss and injury. Accordingly, the defendants, their men, agents, and servants are restrained from from imposing any penalty upon the plaintiff imposing any penalty upon the plaintiff in terms of letter dated 19th May 2025 till आज कितना तारीख है 26 till 24th of July 2025. The plaintiff is directed to serve the copy of print, documents and the application to the defendant and to file affidavit service on the returnable date. Let the matter appear on 24th of July 2025.
Grateful.
24th.
24th. 24th. हाँ, तो जुलाई खरा
बोलो तो ना टाइप या कोई को बोला कि तुम टाइप कर देना आज करना है उसको
And for the plaintiff, Mr. Shorter was
6.
Item 6.
Yes.
And for the plaintiff respondent, it's the petitioner defendant's application, my lord, for acceptance of the written statement. Right here. Is here.
Who is for the plaintiff?
No, I am for the plaintiff respondent. The defendant has taken out an application.
I'm being led by my senior Ritovan Shorkar. He is stuck before a court. So then on that ground, I am humbly praying for a short adjournment, for the adjournment for the day.
What is the application for?
Worship, I am not aware of the matter.
You are not aware of the matter? What
The application is for acceptance of the written statement. Short point is written statement affirmed within 120 days, not report brought before my lord, and thereafter not filed in the department. My lord had called for a report also. The report is saying that it was never filed. So the point is, my lord has decided already in prior matters, my lord.
Just grant us a adjournment for the day. He will come. He can satisfy your lordship.
What do I can't stand in the way?
So and so appearing for the plaintiff, so and so appearing for the defendant. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 4th August.
GA1 is my other application that is on board. GA1, my lord, may I file my affidavit in reply? I was supposed to file, my lord had granted me time. Affidavit in reply in GA1.
In connection GA-Com1 of 2024, be kept with the record.
My lord had made it returnable on some date, my lord.
4th August.
Public.
But
and I am for the petitioner.
I was required to file my affidavit. It has
more
not
than 1 month, and my lord, there is yet no affidavit.
What has happened?
My lord, they haven't yet filed their affidavit in
I have not
opposition.
filed the affidavit. My lord, I do not know, my lord, how I can seek for extension of time.
What is the application for?
My lord, it's a case for goods sold and delivered.
GA1, what is the application?
My lord, it's for injunction and
You are
for
the plaintiff.
yes, my lord. My lord, even before the suit, we had given them 2 notices against which there was no reply. Then we went for mediation. They didn't attend the mediation. We got a non-starter report. And my lord, after filing the suit also, they haven't yet till now filed any opposition.
They don't want to disclose their defense. They want direct cross-examination.
My lord, in the meantime, in that case, my lord, I would pray if my lord can grant some protective orders, because my lord, I'm not sure what their financial status is as of now.
How much? What is the amount?
14
14 lakhs.
Yes, my lord.
Pay. When you will pay, I am fixing a rate.
No, lordship will not do that.
14
My
lakhs.
lord, we have annexed the GSTR returns also, which shows that
40, I could you're claiming the 14 lakhs.
Well, that is also one of my points. But even though I had not filed any opposition from the averments made in the plaint, the principal amount comes to around 7 lakhs. Although they have pleaded 8 lakhs, they have imposed interest at the rate of 24%.
my lord, the invoices.
Claimed
No, my lord,
demand
my lord,
notices, so it doesn't come to 10 lakhs according to. Yes, principal amount is 8 lakhs. That is what they have pleaded.
Lord, in the invoices itself, it has been mentioned that the interest will be charged at the rate 24%. So it has already been agreed between the parties that in default, the interest will be charged at
You
the
will
rate.
claim the principal. The valuation is to be taken into consideration from the value from the interest of principal.
My lord, both will be taken into consideration.
Both can be, yes, that is true. But my lord, insofar as the provision for interest in the invoices are concerned, my lord, even their demand notice, my lord, does not record that. Their demand notice says 18%. Invoice says 24%. Their demand notice says 18%. There is no agreement pleaded, no agreement for interest pleaded in the plaint. There is no payment made inclusive of interest.
8 lakh.
No, my lord, doctor will not do
I
that.
am I keeping the interest pending. Pay the 8 lakhs 91,000.
Lord, I can't say
It's
anything.
been
I
more than
don't
2
have my
years.
affidavit. My lord.
You have not filed the affidavit.
Yes, my lord, I do not know, my lord, how I
No
can.
defense. That's why no affidavit.
Will your lordship
What are the document relied upon?
My lord, we have given
Confirmation?
no, my lords. My lords,
Confirmation.
my lords, we don't have account confirmations, but we have annexed the GSTR returns and the e-way bills, which shows that the goods have been delivered from our end. And we have also annexed all the bank statements and the ledger showing the balance due from the respondent.
There is a ledger, but there is no bank statement.
My lord, we have the bank statements.
Yes,
Bank statement is yes. Bank statement is.
Bank
Lord, will your lordship give me one last opportunity? Although, my lord, I can, my lord, for the time being, I can argue on the plaint and the application itself. But insofar as the calculation is concerned, my lord, there appears to be some error in the calculation. So the value of the suit should be less than 10 lakhs. This court would not have
My
jurisdiction.
lord,
my lord.
even if my learned senior friend's point is taken into consideration that the interest we charged at the rate 18%, then also, my lord, I think it will be beyond the pecuniary limit that is 10 lakhs of.
There's no agreement for interest. Plaint has
Will it
to
be
say,
in-
plaint has to plead that there was an agreement for interest.
Well, the
Even under
documents annexed
Section
to the
34,
plaint
lordship
itself
can
shows.
impose, but that's at the time of decree.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the defendant prays for extension of time to file affidavit in opposition in connection with GA-Com 1 of 2024. Counsel for the plaintiff raised objection and submitted that time and again the defendants have taken time, but till date no affidavit in opposition is filed. Concerning submission made by the counsel for the respective parties, as a matter of last chance, time to file affidavit in opposition in connection with GA-1 of 2024 is extended for a period of 2 weeks. Reply, if any, that to be filed within a week thereafter. This is the matter on 24th July.
My lord, in such case, if my lord can consider prayer F at least, if they be filing the affidavit of assets as on today, along with.
But I'll come with the affidavit, my lord.
The defendant is directed to disclose their assets in their affidavit in opposition.
Grateful, my lord.
Well, lordship, the last part, well, if your lordship is satisfied with that, I have no defense, I'll disclose my assets.
Come on then.
But for the time being, lordship will not, well, lordship, the assets, my lord, even before my affidavit on merits.
Okay, call.
But well, may I say this? May I say this? On the next day, lordship is satisfied that there is no defense. Lordship may ask.
Only disclose. I am not telling that it's disclose.
Well, not to the plaintiff. Well, may I do it to the court?
Let us see. Next.
Grateful.
Grateful.
My lord, it's my application, my lord.
Yes.
It's appearing after affidavits.
Hmm.
My lord, this is that bank matter. I'll give your lordship a brief background. My lord, my principal contention is that
surface and that.
yes, if I am an MSME, then my lord, I am entitled to my account being restructured. Now, my lord, we had cited the Supreme Court judgment in PRONETS. My lord, that was also, my lord, lordship has also taken note of that judgment when your lordship has passed the ad interim order injuncting them. That, my lord, it is not only my responsibility, but it is also the bank's responsibility to restructure my account on the basis of the framework of the Reserve Bank of India guideline. Now, my lord, I'll start off with the PRONETS judgment because, my lordship, I am on your lordship's order of 16th of December 2024.
Yes.
Yes, Mala, I'll just start with the judgment once because there is a very important paragraph that I would like to start with. Paragraph 19 of the PRONETS judgment. Which is the 2024 SCC online Supreme Court 1864. Yes, my lord. একটা কপি আছে, কপি থাকলে yes. My lord, the most important paragraph in my humble submission will be, my lord, paragraph 18. That, my lord, the RBI circular has a statutory force that has already been discussed. But, my lord, paragraph 18, if I would just like to place. In that view of the matter, we are of the opinion that the findings recorded by the High Court in the impugned order that the banks are not obliged to adopt the restructuring process on its own, or that the framework contained in the notification dated such and such as revised from time to time could not be said to be mandatory in nature, are highly erroneous and cannot be countenanced. So, my lord, it is mandatory on the part of the bank on their own to restructure my account. It is on their own. Now, my lord, it is only my responsibility to inform or notify the bank that I am an MSME unit. It has been my learned friend's defense to my application that I have never taken the plea before. That is the affidavit in opposition case, and it was also the oral argument when, my lord, we were contesting at the ad interim stage. Now, my lord, pursuant to your lordship's leave, my lord, we have filed a supplementary affidavit. Ektu din to. But this has been affirmed. The supplementary affidavit, my lord. It was affirmed on 10th of April 2025. Few relevant documents. My lord, kindly takes, my lord, page 31 onwards. Why I say on its own are, my lord, the documents from page 31 onwards. My lord, this is an email that the bank writes to me enclosing a GECL offer for some credit facilities. Page 31 is the email, 4th of February 2022. Now, my lord, the offer letter that was issued on the same date, lordship will find that at page 32. Now, my lord, kindly comes to page 33.
Yes.
Now, my lord, I have to communicate my acceptance so far as this offer letter is concerned.
Yes.
The last page of the offer letter is at page 33.
Yes.
Kindly see below the signature of the chief manager, there is an enclosure that was made over to me under Annexure A. Now, my lord, Annexure A, lordship will find the format at page 34. Page 34. My lord, this is the format of the Annexure A that the bank had given me. I had to fill up this form and I had to make over this form. Kindly see paragraph 2. This is the format of the bank. 2A. My lord, 2 specially. In this connection, we would like to avail a loan of rupees blank lakhs, and we confirm and certify as under. A is, we are functioning business enterprise / MSME with Udyog Aadhaar number if available blank. I had to provide that whether I am an MSME unit or not, and whether I have an Udyog Aadhaar number or not. Now, kindly see my response. That is at page 36. 4th of February, the email from the bank. My response is on 7th of February at page 36.
Yes.
This is my email, doors jute to SBI SME Park Street branch.
Yes.
My lord, kindly comes to page 37. We fill up Annexure A and, my lord, we send it. Kindly see 2. In this connection, we would like to avail a loan of rupees, my lord, 1 crore and it should be 1 crore, I think so. And we confirm and certify as under, we are functioning business enterprise MSME with Udyog Aadhaar number such and such 4160. Now, this was sent to them on 7th of February. So, my lord, bank on and from 7th of February was aware that I am an MSME unit and I also have an Udyog Aadhaar number. Now, my lord, paragraph 18 of the Pronate's judgment, my lord, since the bank is already aware of this fact, or it was within the bank's knowledge that I am an MSME unit, my lord, in my humble submission, it was mandatory and obligatory on the part of the bank to restructure my account in terms of the framework of March 2016.
Yes.
Yes, that is there. Now, my lord, this is not the end. this is not the end. My lord, I'll just give you a lordship, my lord. 7th of February 2022, my lord, the bank was put on notice that I am an MSME unit. 14th of September 2022, additional credit facilities were, my lord, made over to us by the bank. So the credit facilities that were given to us on 14th of September 2022 was with the prior information or prior notice to the bank that I am an MSME unit. So the credit facilities that are were giving to me was on the basis of the precondition that I am an MSME unit. So when the bank is making over these credit facilities, if at all there has been a default on my part, in view of the guideline of the Supreme Court, it was mandatory on the part of the bank to restructure if at all there was any default. Now, Malad, they completely ignore the circular and Malad, they issue a demand notice on 6th of December 2023. I was never aware that my account was declared as a non-performing asset. It is only on receipt of this notice, which is on 6th of December 2023, that your lordship will find at page 118 of my petition volume 2.
Affidavit on opposition?
No, my petition. Malad, GA1.
$102.
118.
इनको क्या है इसको मालूम कर Yes.
Yes, Manoj, this is the letter. Manoj, I'm sorry, Manoj, this starts at page 117, 6th of December 2023.
Yes.
Yes, kindly comes to page 118 towards the bottom, the last paragraph. You have used and utilized the aforesaid credit facilities but failed to comply with the terms and conditions of the same and failed to repay the loan as per the agreed terms and conditions, as a result of which the aforesaid loan account has been classified as NPA on 29th of November 2023, and as such there is due and outstanding in the aforesaid loan accounts as follows. Number, the details have been given that 11.94 crores is due on my part. That's the total amount that has been claimed by the bank.
Yes.
Now, Malad, if Lordship sees, Malad, what was the responsibility of the bank so far as the circular is concerned?
Yes.
Malad, the March 2016 circular or the framework of the Reserve Bank of India guidelines my Lordship has a copy of the 17th March 2016 RBI. Malad.
इसमें गाइडलाइंस में कहाँ गया
একটা কপি থাকলে দিয়ে রাখ but I have a separate but I have a separate copy.
24 July.
No, this is 17th March 2016. আরেকটা
Yes.
Malad, I will, if Lordship straight away comes to Malad, paragraph 2 of the circular,
yes,
of the framework. Malad, kindly see 2.1. Malad, what does it say? It says identification by banks or creditors before a loan account of an MSME enterprise turns into an NPA. Banks or creditors should identify incipient stress in the account by creating 3 subcategories under special mention account category as given below. SMA 0, 1 and 2. One of very important words before it turns into NPA. So my lord, NPA was on 29th of November 2023. So before my account turns into NPA in terms of this guideline, they should, my lord, classify into these three categories. SMA 0, when the principal and interest payment not overdue for more than 30 days. Now SMA 1, principal or interest payment is overdue between 30 to 60 days. SMA 2, principal or interest payment overdue between 61 to 90 days. So there is no compliance so far as 2.1 is concerned, because they have not categorized my account as SMA 1 or SMA 2.
Yes.
There is no notice given also. Now kindly see, my lord, kindly comes to paragraph 3. The next step after identifying the three steps of the categories, the next step is to formation of a committee. In order to enable faster resolution of stress in an MSME account, every bank shall form committees for stressed MSMEs as per the following arrangements. All banks having exposure towards MSME shall constitute a committee at each district where they are present, or at division level or regional office level, depending upon the number of MSME units financed in the region. These committees will be standing committees and will resolve the purported stress of MSME accounts of the branches falling under their jurisdiction. Now, 3.2. For MSME borrowers having credit limits under a consortium of banks or multiple banking arrangement, the consortium leader or the bank having the largest exposure to the borrower under NBA, as the case may be, shall refer the case to its committee if the account is reported as stress either by the borrower or any of the lenders under this framework. This committee will also coordinate between the different lenders. Number 3.1, as I have placed, my lord, it is the bank's responsibility, my lord, to constitute a committee. Because if we go stepwise, the first step is to categorize as SMA 0, 1 or 2. Because when the bank identifies it as SMA 1, 0 or 2, the bank realizes that by that point of time, I am suffering some kind of a stress on account of the credit facilities or on account of my unableness to make payment of the dues. The next immediate step of the bank, so far as this framework is concerned, is to form the committee. Now, my lord, kindly see, my lord.
It will take time, na?
Yes, my lord, some time it will take.
Matter fix है क्या? है क्या है? I am fixing.
Lordship, in this connection, only one, Lordship, we have received the writ of summons and we are 38 days beyond time. We have affirmed the written statement. If your Lordship can kindly.
Where is the
This is the.
recorded on?
This is the written statement and this is the application.
Written statement given. Application you file in the department.
Lordship, I have to
In the written statement, I am giving leave to
Lord.
only to file in the submit in the department. Subject to acceptance in course.
Lord.
Today we will submit.
Today, Lordship, it's only 40 minutes. This is the written statement.
For the plaintiff, Supreme for the counsel for the plaintiff has argued the matter at length. Due to paucity of time, hearing will be completed. The case is adjourned. Let the matter appear. कोई date है क्या? Let the matter appear on 30th July. With the same meeting. Yes.
Only one thing, Lordship is kept it on 30th of July. The interim order is due to expire tomorrow.
Interim order is extended. Interim order is extended till 4th of July 2025 or until further. 4th of August.
Any day before 29th or after
30th July.
30th July.
Your difficulty?
Some difficulty.
Then I am fixing on 4th of August.
4th of August.
4th of August karo, interim order till 8th of August or until further order. Or yes.
Grateful, mother.
दे देना. ना. Submitted by क्या date है? Monday. Date दे देना.
Keep your
14th.
45. Number 12 and 13.
Lord, in this matter, I'm paying for defendant number 1 and others.
I'm for the defendant number 10, my lord.
Depend my applications GA Com 2 and 10 is not listed. My lord will list it any day subject to my lord's convenience so that we also proceed with that application. My lord, GA Com 2 relates to my section 45 application and G10 is my, there was some delay in filing my written statement, although that was filed with the leave of the court. I want to place that also. So any day subject to my lord's convenience.
Oh, no. Now I am taking the with regard
GA1.
GA1.
GA1. No, my lord, that may be.
When initially you have taken up the you are not
No, my lord, my landed friend was there. You have not mentioned anything.
Yes,
My lord, he mentioned that.
mention it filed. Then you are not mentioned that the application is to be had expeditiously because there is a direction upon from by the appellate court. This J1 is to be had expeditiously. That's why I am taking the.
My lord, that may be fixed for any day.
Any date it is going on when the time will
Today we
permit. Okay. Yes.
My lord,
Please, Your Lordship. I had concluded my arguments in reply against D6 and D7. Now, my lord, after that, the other respondents have also concluded their arguments and they've also served up the notes of argument. My lord, may kindly take next in serial is number 10. If Your Lordship kindly takes the note of argument filed by respondent number 10 and also, my lord, the affidavit in opposition filed by them. To Judge Sahib ke din, AO of D10. এই আছে অরূপ নস্কর
চাইছিলাম না আমি
Of the D10.
Please, my lord, if your lordship kindly has D10.
Yes.
And my lord, kindly also have the affidavit of opposition অরূপ কুমার নস্কর নস্কর না মোটা আছে অরূপ নস্কর 22 এটা 22 নভেম্বর 2024 অরূপ নস্কর আদিত্য মন্ডল 10 লেখেনি 10 লেখেনি অরূপ নস্কর দেখুন 24টা ডাকলাম মোটা আছে মোটা অত সরু না মোটা মোটা একটু মোটা অরূপ নস্কর আদিত্য মন্ডল
It is affirmed on 22nd November 2024. The page number 6 reads the defendant number 10.
ফাইল করেছো ফাইল করেছো ফাইল করেছো
Yeah, affidavit in opposition.
কি বলতেছো বলো
Question सब बोलता है यार. It's unmarked.
কোথায় ফাইল করেছিল ডিপার্টমেন্টে না
And I am told it has been filed.
10 नहीं देखो ना बैकशीट एकटा আছে सामने वाला दिखा क्या बैकशीट दिखाओ ना उनको अरे बैकशीटটা দে পেয়ে গেছি thank you now before I trouble your lordship with the pleadings in this affidavit
Arup Naskar.
yes please my lord Arup Naskar kindly see my lord pages 58 onwards are the documents which are appended annexed to this affidavit. There are several annexures, my lord, 58, and then there is a trail of emails, and then there is, in fact, there are about A, B, C, D, F, G, H, C, D, F, 8 annexures to this affidavit. Now, kindly take the note of arguments, please, my lord. Your lordship will cursorily just glance through the notes which start at page 6 onwards. Kindly just glance through the notes, my lord. Your lordship will not find reference to a single annexure in this notes. There is no reference except one paragraph, which is paragraph 5.
Yes.
Kindly come to paragraph 5. This refers to, my lord, the first report true or the final report This is the only annexure which the respondent number 6 relies on, although it has filed about 8 annexures, and that is only the FRT, so to say, my lord, as far as he is concerned, filed by the police authorities. So, my lord, the respondent number 10's argument, primarily in the notes, is an argument in law. But the case which is run in the affidavit, my lord, if your lordship now comes to the affidavit. Kindly see the affidavits, and I want to show your lordship, my lord, the falsity in not only in the pleadings, but in the documents also. The case which is run in the affidavit and the documents which are appended, and now the case which is pleaded in the opposition, I am sorry, in the notes, is entirely different. My lord, kindly see. D10, my lord, is admittedly a group company of defendant number 6, for whom Mr. Bose appeared, Sham Sale and Power Limited. And he admits this also, my lord. Kindly have paragraph 16 and 17 of my petition once, please, my lord. And how he has dealt with in paragraph 8 of his opposition. Petition volume 1, Devan, kindly.
A1. Page?
Paragraph 16 at page 13.
Yes.
Of the petition.
Yes.
And, my lord, dealt with in paragraph 8.
Paragraph 8.
Of his opposition, my lord. In paragraph 16, if I may just place quickly, my lord. Meeting was held with Mr. Sayan Chatterjee, Senior Sales Manager of defendant number 6, and Pratik Batra and the petitioner's directors. In course of such meeting, it was represented by Mr. Sayan Chatterjee. The defendant number 6 was a part of the Sham group of companies, which included the defendant number 10 and Sham Metallics and Energy Limited. So, my lord, a categorical case is made out that 6 and 10 are part of the same group of companies. And now your lordship sees paragraph 8 once, please, my lord. Paragraph 8 of the opposition deals with paragraph 16 of the petition.
Yes.
I state, if I may just omit the first 4 lines, I state that the answering respondent is not privy to the facts mentioned in the paragraph under reply, and hence refrains from making any comment on the same, and denies the alleged statements made in the paragraph under reply as regards the assurance and representations made on behalf of respondent number 10, and the same cannot be construed against the answering respondent in any manner whatsoever. The answering respondent is completely unaware of the alleged meeting on Skype platform, nor any of its representatives were present. I deny that the respondent, defendant number 6, could have confirmed and assured the petitioner that the defendant number 1 was associated with the defendant number 6 to 10 on behalf of the answering respondent. And the answering respondent would perform and deliver all goods placed, orders placed. Similar, no denial that this is not part of the same group. It is part of the same group of companies. 6 and 10 are part of the same group of companies. And, my lord, the defendant number 7, who's a director of the defendant number 6, is also the person who is in control of the defendant number 10.
Yes.
Apropos this, your lordship will also kindly see paragraph 10 of the opposition and paragraph 47 of the petition. Once, please, my lord, kindly have paragraph 47 of the petition onwards.
Yes.
Sorry, paragraph 65. I'm so sorry. Paragraph 65 of the petition once. Now, this is when my director visited the factory of the defendant number 10.
Yes.
Thereafter, in or about the third week of January 2021, Mr. Ali was taken to the factory of defendant number 10 at Durgapur,
Yes.
outside the aforesaid jurisdiction by the defendant numbers 2 and 3.
Yes.
At the factory of the defendant number 10,
Okay.
the defendant number 7 introduced himself as a director of the defendant numbers 6 and 10. Mr. Ali also made Mr. Jaydev Majumdar, who was introduced as head of marketing. Now, kindly see, my lord, how he deals with this in paragraph 12 of his opposition. Two names are mentioned here, my lord. The petitioner's director met respondent number 7 and Mr. Joydev Majumdar. And this, the director who met has sworn on affidavit himself. He has come from Italy. He has sworn this on oath. Now, my lord, kindly see paragraph 12, how they deal with this. Fourth line, my lord, in paragraph 12, the answering respondent reiterates that it is not privy to the statements made in the paragraphs under reply and hence refrains from making any comments. However, then, my lord, all this continues. He deals with other paragraphs also. Kindly come to page 26, about 5 lines from the bottom, my lord.
Yes.
I deny.
Yes.
Your lordship has that, my lord? About 5-7 lines towards the right. I deny that in or about the third week of January 2021, Mr. Ali was taken to the factory of the defendant number 10 at Durgapur by the defendant numbers 2 and 3 as alleged or at all. I deny that at the factory of the defendant number 10, the defendant number 7 introduced himself as a director of the defendant number 6 and 10. I deny that Mr. Ali also met Mr. Joydev Majumdar, who was introduced as head of marketing as alleged or as well. So, bare denials. Bare denials. Now, my lord, kindly see who has affirmed this affidavit. This is neither affirmed by the defendant number 7 nor Mr. Joydev Majumdar. Kindly see, my lord, the affidavit. This is affirmed by one Mr. Naskar.
Yes.
So he was not present when I met.
Yes.
Yes, I'm showing that. You show the page where common directorship, like 266.
Yes.
So, my lord, this is affirmed by Arup Naskar. He is neither the defendant number 7 nor is he Joydev Majumdar.
Yes.
These are the only two people, my lord, who could have affirmed on oath that Mr. Ali did not come and that Mr. Ali did not meet these two gentlemen, did not meet us. Now, my lord, if I did not, question comes now, my lord, if I did not meet Mr. Joydev Majumdar and I have no interaction, their cases, I don't know you. His pleaded cases, my lord, I have no interaction with the defendant number, with the plaintiff. I only know D1. I have no interaction with the plaintiff. I have never dealt with the. Then, my lord, the question arises, and I ask myself, how would the plaintiff know the name of Joydev Majumdar? Kindly see now, the emails which he has disclosed, everything is Joydev Majumdar. The emails which he discloses in his opposition, now kindly see page 60
Of your application?
of his petition, my lord. I'm sorry, his opposition. His opposition.
Page 60.
Page 62
Hmm.
onwards.
Hmm.
Kindly see, I'm sorry, 61 onwards, your lordship will kindly see.
Yes.
D1 is writing to one Mr. C. Basu, who is of the defendant number 10, and your lordship kindly see CC Joydev Majumdar.
Hmm.
This is the same gentleman, my lord, who I met.
Yes.
And your lordship will see all the mails. 62, in all mails, Joydev Majumdar of the defendant number 10 is copied.
Yes.
And his full address is at page 64, my lord. Your lordship will see joy@shamferro.com. So, my lord, neither Joydev Majumdar comes nor D7 comes to deal with this allegation on oath that I have come to his factory and I have visited these people. And Joydev Majumdar now, my lord, is on from the papers they have disclosed, is a person in the organization of the defendant number 6.
Yes.
And
6 a year.
Huh?
The 6 a year. How much a year?
Yes. And your lordship will kindly now have the affidavit in reply to D6 and D7 once, please, my lord.
Affidavit in reply.
Yes, which I filed, my lord. affidavit in reply. Reply affirmed by Rajesh Upadhyay backsheet আছে লেখা আছে ওখানে
Yes.
Now my lord, this is, kindly come to page annexure C at page 124. This is, my lord, the annual reports of the parent company of both D6 and D10. Page 124, my lord. There is no denial in his opposition, but I am showing your lordship my duty to satisfy your lordship to the case which I have made. This is of the parent company of both D6 and D10, which is Shyam Metallics and Energy Limited.
Yes.
And this your lordship will find is of the relevant year also. I'm grateful to Mr. Kindly see page 124. It's annual report of 21-22 of that year in which the transactions are taking place.
Page 124?
Yes, 124, my lord. At the top, your lordship sees left hand.
Annual report.
Yes, annual report 21-22. These transactions of that time.
Yes.
Now kindly turn to page 135. Yes.
Yes.
135. Sorry, 135.
Yes.
Kindly see names of the related party, nature of relationship. Your lordship will find the first name there is of the defendant number 6, wholly owned subsidiary.
Where?
My lord, in the box there, my lord, under serial 2. At 135, your lordship has. 135, my lord, there's a box in the middle of the page, my lord. Serial A.
Shyam Sale.
Yes, Shyam Sale and Power Limited is a wholly owned subsidiary.
Yes.
And then your lordship sees the last name there, Shyam Ferro Alloys Limited, significant influence. Shyam Ferro Alloys Limited, my lord, significant influence is defendant number 10.
Yes.
And then your lordship sees the signature there, Vice Chairman and Managing Director Brij Bhushan Agarwal, who is defendant number 7. So, my lord, the link between these two companies and D7 is complete. And on the next page also your lordship will find, I'm sorry, page 137, your lordship comes to 137. Enterprises over which, my lord, has that, my lord? The third box there, enterprises over which the key management personnel are able to exercise significant influence with whom there were transaction balances. Can you see the fifth name over there, my lord? Shyam Ferro Alloys Limited, who is D10, my lord.
Yes.
And your lordship will see key management personnel, Brij Bhushan Agarwal, Vice Chairman, Managing Director, who's D7. And I met this gentleman, my lord. It is my specific case. I met him at the factory of D10.
Yes.
So, my lord, that they are part of the same group of companies, there is seriously, my lord, there is no denial. Now, my lord, kindly come to what is the case made out in the petition, in the opposition. Kindly come to, my lord, 2 paragraphs, if I may trouble your lordship with. Kindly have paragraph 4 at page 8, please.
If it in opposition?
Yes, please, my lord. None of this is mentioned in the notes. The notes is only on a legal argument. There is no factual assertion. Kindly see now, my lord, paragraph 4. Pursuant to discussions and negotiations between the respondent number 1 and the respondent number 10, a contract of sale was entered into between the respondent number 1 and 10, whereby respondent number 10 was to supply 1000 metric tons of ferromanganese, vide purchase order number so-and-so for a price of rupees 14 crores. And it was mentioned in the contract that a sum of rupees 25 lakhs was to be paid in advance and the remaining balance was to be paid after loading into the container. It is pertinent to mention that the transaction between, and my lord, kindly note this, the transaction between R10 and R1 was purely commercial in nature. Then, my lord, kindly see 5. After making dispatch in 2021, respondent number 10 stopped further dispatch due to non-payment of advance by the respondent number 1. Further, the respondent number 1 made payment commitment to the respondent number 10, and after due consideration, the applicant allowed, it should be the respondent number 10 allowed, the loading of 10 containers containing 270 MT of ferromanganese during the period 21st April 21 to 28th April 2021. Again, the respondent number 1 failed to make further payments, and owing to such default in payment, the applicant withheld the loaded containers in its factory. Then, paragraph 6, he refers to several emails. 7, he refers to several emails. 8, he refers to several emails. Kindly come to 10 now, please, my lord. The respondent at page 11. The respondent number 1 finally made a payment of rupees 1,35 lakhs from 1st June 2021 to 2nd June 2021, for which the respondent number 10 dispatched 4 containers containing goods worth rupees 1,51 lakh 47 so and so, and withheld the remaining such containers for non-payment of the balance amount. And he annexes the ledger. So his case is, my lord, as and when I got payment, I released the goods. Now kindly see, my lord, the ledger. The ledger tells a tale which is totally contrary to what is pleaded. 91. Totally contrary. Kindly come to page 91 first. Let's just kindly have a look at first the purchase order ones. All these are, my lord, sham documents which have been created. Kindly see page 58 is the purchase order.
Yes.
58 is a purchase order, purported purchase order placed by R1 on R10. Kindly see the comments of special instructions in the box, my lord, below. Payment 25 lakhs advance and balance after loading into the container. Price is X works, loading is inclusive. So, my lord, 25 lakhs has to be paid in advance and balance immediately after the material is stuffed in the container. Now, kindly see, my lord, the ledger which he discloses at page 91. My lord, no invoice has been disclosed. Not a single invoice, although he claims to have raised so many invoices which are mentioned in this ledger, not a single invoice is disclosed.
Yes.
Now, a ledger, my lord, without supporting documents is of no evidentiary value at all. That is, my lord, settled law. Now, kindly see how the ledger and his narration differs. Now, my lord, 19th February 2021, he receives an advance of 20 lakhs.
Yes.
The purchase order says 25 lakhs, he receives 20 lakhs, no difficulty. Kindly see the next. 26th February 2021, he receives an advance of 50 lakhs. Therefore, he's received an advance of 70 lakhs when R1 was only supposed to give him advance of, my lord, 25 lakhs. They have very good relations. I have no difficulty. Somebody wants to give more advance, there is no problem. Now, my lord, kindly see from 27th February, there are till the last entry at the bottom of the page. 27th February till 1st of March.
Yes.
And this continues, my lord, till the next page also. 1st of March. From 27th February to 1st of March, there are 20 invoices raised. According to this ledger. And, my lord, each of these invoice is of 27 metric tons. I'll show your lordship why I'm telling your lordship. Your lordship sees these. These from, kindly make a note, please, my lord, and I'll show your lordship the pages. 27th February, invoice number 345, your lordship has. Third entry.
Invoice number 345?
Yes, second. I'm sorry, my lord, voucher number. It's written voucher number.
Voucher number 345.
Yes, voucher number 345, your lordship has. And kindly come to voucher number 350. About 5-6 entries down.
Yes.
Now, my lord, these. So, as on this date, no payment is, he has only received 70 lakhs.
Yes.
His contract terms provide he will give delivery only when payment is made. And, my lord, your lordship has seen the pleadings. He says payment was not being made. I stopped delivery. Here, my lord, your lordship sees there's a debit balance of 1,57 lakh 19,708.
Yes.
Contrary to his pleaded case that payments not being made, I stopped. Now, these were actually deliveries which were given to me. My lord will kindly have page 106 of D1's opposition. Kindly see now, my lord, page 106 of D1's opposition. where he has disclosed the shipping bills. এই প্রথম চারটে ভাই। এটা ম্যাচিংটা কোনটা?
Yes.
Kindly have the shipping bill which starts at page 100, please, my lord. Lordship has a shipping bill which starts at page 100?
Yes.
I'm sorry, not 100. That is the next next lot. Kindly have the shipping bill which starts at page 1 minute. 103, please, my lord. I'm sorry. 103. This is one shipping bill, my lord. Starts at 103.
Yes.
Kindly turn to page 106, which gives the details. AR4 details, your lordship sees the last entry at the bottom of the page.
Yes.
Invoice numbers, your lordship will find 345 to 354.
Yes.
10 invoices, my lord. I showed your lordship at 350. Kindly take up to 354. So, my lord, these 10 containers, each of 270 metric tons, were shipped to me. And your lordship will find my name at page 103.
103 of the same affidavit?
Yes, D1's affidavit. That 106 which your lordship saw was part 4. Now your lordship will see part 1 starts at 103.
Yes.
Kindly see towards your lordship has part 1 shipping bill summary. Then kindly see, my lord, the name of the consignee there towards, my lord, the right hand side. Consignee name and address is the petitioner.
Correct. Yes.
And my lord will kindly also see the date of this shipping bill. On the top, my lord, 8 March 2021.
Yes.
So, my lord, he has given delivery of all these goods to respondent number 1 without receiving any payment. And his pleading is to the contrary, that as and when I receive payment, I would give delivery. His pleading is to the contrary. All these goods are given when there is a debit balance. No payment is received by him. Similarly, your lordship will see now.
How much time will it take?
I will take some time, my lord, because this is only on fact.
Stop here.
Right.
Appellate side.
कब next date देखो जज साहब का कोर्ट date. My lord will not be presiding over this bench. Your lordship is not going to preside over this bench.
No, for 2 weeks.
The interim order has to be, my lord.
When?
30th it's expiring.
Where is the number?
Well, last order.
This in this case?
Yes.
Okay.
In this order. In this case, not any other. This is the last order which was made, my lord. Yeah.
Appearance लिख लेना. Appearance लिख ना. Counsel for the plaintiff has argued the matter in reply, but due to possibility of time, hearing could not be completed according to that John. Counsel for the plaintiff prays for extension of the interim order. When कब देगा? Let the matter appear on on 30 July. 30 July.
1
30.
Yes, ma'am.
30th July at the top. Interim order granted. Interim order is extended till 5th of July, August 2025, or until further order, whichever is.
My lord, may I make this one submission? My lord, for defendant numbers 8, 9, and 13 and 14, we had filed 2 vacating applications. My lord, by my lord's order of 2nd May 2025, my lord had firstly accosted us, and thereafter my lord had asked plaintiffs to file an affidavit in opposition.
We'll file it, my lord, in
we had failed to file our opposition to the main GA1. That is why we took out an application, whatever there is, my lord. If an opposition still has not come forward from
we'll complete it before the next
close.
I can't say anything,
After arguments had been
I cannot-
completed, they came up with a vacation. We'll do it in the meantime. We'll do it before the next day. We'll do it in the next day.
Well, I mentioned
Obliged.
the matter in the morning. The
Which
interim order is expiring tomorrow. Matter was also directed to be listed tomorrow.
you got?
I
Yeah.
have again given them a notice, my lord.
So appearing for the plaintiff after notice to the defendant, but none, any appearing defendant? None appears on behalf of the none appears on behalf of the defendant. Counsel for the defendant, plaintiff prays for extension of interim order. List of interim order extended till 5th of August 2025 or until further order.
In respect of
Let the matter remain. It is in the list.
it's no, it is supposed to come. It was supposed to come tomorrow. So a date.
Let the matter remain in the list.
My lord, in respect of item 24, the next matter, my lord, it is an execution application. My lord, settlement has already arrived. We have given them post-dated check.
My lord.
Last date of the check is 10th August. So, my lord, the matter may be fixed any day after 10th August.
Which matter?
Just
My lord,
item number 24.
24 and for the petitioner, my lord, the
You are the
parties
decree holder?
have.
You are the decree holder?
Yes, my lord.
I don't know.
The-
So suffering for the decree holder. So suffering for the judgment debtor. Judgment debtor submitted. The judgment debtor has already paid the amount.
No, my lord,
No,
we
my
have
lord.
given post-dated checks.
Has issued the
And
post-dated check.
some amount has been paid.
Has issued the post-dated check, and the last date of the check is on
My lord, 10th August
10th of August
2025.
2025. In view of the matter, let the matter appear on 12th of August 2025.
Grateful, my lord.
Item number 29, my lord. I am bringing a lot leave to withdraw the suit, my lord. Other side is there. Written instruction is with me, my lord. If you lord see kindly. Item number 29.
Item number
29.
For orders.
Yes, my lord. On the last occasion, I submitted for withdrawal of the suit. This is the instruction, my lord. If you will kindly come to paragraph C, my lord.
Prabhunath Singh, matter
Yes,
has
ma'am.
been pending since long and it has no financial impact except the council fees. Where is the case number? This is the case number?
Yes, my lord.
Record item number 30.
29, my lord.
29. So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff has handed over the communication dated 1st of March 2025 issued by the plaintiff to the advocate on record of the plaintiff, informing that the plaintiff is not interested to proceed with the matter and prays for withdrawal of the suit. In view of the, as per the communication dated 1st March 2025, counsel for the plaintiff prays for withdrawal of the suit. Considering the submission made by the counsel for the plaintiff and the communication dated 1st March 2025, CS Com 591 of 2024 within bracket old CS 81 of 2011 is dismissed as withdrawn. Interim order, if any, stand vacated. There's communication be kept with the record.
My lord, item number 28, my lord, today's list, my lord.
What?
That is execution matter. I am for the judgment debtor and also for the parties who have not been made party.
What you want?
I want, my lord, the similar matter is, one matter is there on 5th August. Similar matter.
Let it be on 5th August. Let
5th, it be on 5th August, my lord.
As per the which matter? 28?
Item number 28.
28, as per the, you are for the decree holder?
I am for the judgment
Who is
debtor.
for the decree holder? But then how it can be? Decree holder is not here. Come on then.
Appellate side.
Yes, call them appellate side. Call karo.
Item number 1 to 3.
Pending.
The appeal is still pending.
It will be 16 August, my lord.
Kindly fix the date in August.
Record and order. So suffering for the petitioner. So suffering for the alleged contemptor. It is submitted by the counsel for the respective parties that the appeal preferred by the state is still pending. In view of the above, let the matter be listed on 4th of September 2020.
We are grateful, my lord.
With your blessing.
सिंगल ऑर्डर, ऑल मेंशन एंड सिंगल ऑर्डर। पहले कैसा था? सिंगल ऑर्डर है ना? सिंगल ऑर्डर है, अलग अलग ऑर्डर है? या तो
Single.
सी दैट लाइक दिस। अच्छा, सिंगल।
Reader, sir.